Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
Is the next search on February 28, 2020, 7:44 p.m. How period does the FBI find people? And people's misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do you see?
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Wow, it is this morning came quickly, but this week has been dragging by. I don't know how that works, but it's been. Oh man, we're here. Morning is here. I'm super excited for today. We have a lot on tap. We may have a verdict today. Let me back up. We may have closings today. Okay, let's cross our fingers here. I hope this works properly. Okay, sorry about the music there. It's a little bit loud. Wearing a t-shirt today, a little bit casual. Hope you guys don't mind. I dressed down for the occasion. I don't know, I've got my OCD kicking in here. I need to make the wires disappear. But there we go. All right, which judge are we going to see today? Grouchy judge or really grouchy judge? This is kerfuffle. We will see. That all has to be seen. It will be all will be disclosed in due time. Kerfuffle. But before we do that, we have to do a couple things. First of all, we have to welcome. We have to turn this on so that works. So we'll wait. We'll wait here as if I hadn't forgotten to do this important part earlier. There we are. Connect. It's connected. Now we can turn it on. Groovy Jill. Good morning, Groovy Jill. First in chat this morning. Groovy Jill, I checked my records. I don't know if you won the internet once previously. It looks like if you did, you got off with a warning because there was nothing in your record about a prior offense, but this one definitely qualifies. So we're putting this down as a conviction. You're now guilty of and adjudicated guilty of being first in chat, and as such, I have to sentence you and punish you to internet ownership for the rest of the day. I'm sorry. You may not have known. It might be an accident. Ignorance is no defense in this case. It's all yours, Groovy Jill, and you're responsible for just making sure everyone else can use it. So good luck with that, and add that to your list of other responsibilities today. Thank you very much, Groovy Jill, for being first in chat. Also.
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. It is Wednesday. This is cruel and unusual punishment, says Mr. Man. The hump day cheer is, I'm sorry if all of you had the volume turned up and now your cats and dogs are wired for the rest of the day.
I'm not a camel.
I'm not a camel either. I've resolved to take bathroom breaks so you guys don't get worried about me. I'm fine, but I've resolved I'm going to start doing that today. I'll just be like, I'll need like an intermission sign. I might not even go. I'll just make you think that I did. We'll see. Anyway, we are getting. Oh my goodness, we've got so much stuff to talk about. You saw the new thumbnail today. We've added a couple things. We've got the grouchy judge. We've added Fireball to the sky.
Somebody just sent me a video of roaches fighting. I don't know who won.
Okay, right now I'm going to fix that. Just 1 second. We're going to.
Because he's the guy.
The XP command is not waiting the appropriate amount of time to fire.
Alex stole it.
So we're going to edit that really quickly. Audio. More experience.
There's a lawsuit.
Dynamic options. Skip queue. Don't skip queue. There we go. Now it's going to be in queue, so it won't talk over everybody. Mission accomplished. All right. I'm learning how to do this whole YouTube thing. I think it might become a thing. All right. Do you think we'll get to a verdict today? I don't know. We've got a couple things to do before we get to a verdict. We have a charge conference that's going to be happening first, where they're going to go over
Have them send someone with more experience.
There you go. It reset the queue when I went in and did that. We've got a charge conference we have to hear. They're going to go over the verdict forms, the jury instructions. Oh, birthdays. I forgot birthdays. I knew it. Dang it. Let's see. Here we go. We have birthdays today. I'm sorry. I did not mean to forget.
Somebody just sent me a video of roaches fighting.
I don't know who won. Let's see. Melissa Filson, Flutterbear, Jess Rubery all have birthdays today. We're going to sing to them. I say we. That's because I'm speaking for all of us. We're all going to sing happy birthday to them. It's the regular song. You know the words. You know your parts. I do expect all of you to sing regardless of where you are. Just know that today, if you're in your car listening, and I see those of you that are, well, drive. Thank you for just listening and not watching. I'm going to need you to sing extra loud. So if you guys could do that, that would be great. Warm ups with me now already. La 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 la. Okay, here we go. Melissa, Flutterbear, and Jess. Happy birthday to you. Happy birthday to you. Happy birthday, Melissa, Flutterbear, and Jess. Happy birthday to you. And is Good Vibes Stacy? Is it also your birthday? There might be, let's see. There might be, today is my birthday too. Good vibes, Stacy. Happy birthday. Happy birthday. Good vibes, Stacy. Good vibes, Stacy. Consider yourself sung to as well, because we've mentioned your name while the song was going. I think that counts. I know it's a cop-out a little bit, and I apologize for that. Happy birthday, Good vibes, Stacy, as well. Let's see. Martin, my brother's 50th birthday, says Zippy Fluffy. Happy birthday, Martin. Let's see, we've got a couple others probably squeezing in there. I apologize if I missed it. Allie says, my toddler thinks every day is his birthday. Where are my presents? Where are my presents? Oh, that's awesome. Every day being your birthday. To be a child again, right? Wow. Especially if we could keep our knowledge that we have now. Except for the part about birthdays only coming once a year. Happy birthday to everyone. If it is your birthday today, thank you. Thank you for sharing that it's your birthday. A lot of people don't disclose that, my wife included. And then also, thank you for being here with us. I realize there are a million places you could be to celebrate your birthday, and places where we'll celebrate you and your greatness and the greatness of this day in your life by giving you free pancakes, for example, at Denny's. But here you are. The Altos were a little weak, says JPC. JPC, if you could be a section leader for the Altos, that would be great. I know you know what I expect from the Alto section. If you could maybe work on them, maybe do a breakout room for a little bit and go over the parts a few times, we expect that to be fixed for next time. Thanks, JPC. I appreciate that. Anyway, if you're celebrating your birthday today, you're here with us. It means a lot to me. Thank you. Have a wonderful day. I hope we can make it as beautiful and wonderful for you as you deserve. All right, we are hopefully going to have court today. I say that because a couple things can happen. We didn't know. When is your birthday? All right, it's in March 24th. I guess I can tell you because you just have to go back on the channel and see it. But March 24th is my birthday. It's coming, but let me tell you guys, I sort of got myself an early birthday present yesterday. I realize it's early. When my birthday rolls around, I will get myself another one. But I just ordered something that has 59 buttons. 59 more buttons I get to add to this goodness. I am so excited. Buttons make me happy. And I get 59 more buttons, and they're really, really cool buttons. They're backlit buttons. It's just good. I'll show you when it arrives. Anyway, it should be here tomorrow. So let's see. Christy, it looks like I'm birthday friends with your mom. That is awesome. Yes, and I shouldn't have told you how many buttons there are, because now when we do the button contest, you guys will know just how many to add to your current guess. But that button contest is coming up soon. I think, I'm not sure if we'll do it on the next trial or the one after, but we're going to do a button contest here soon. Mimi and NC, my birthday's March 24th. It's a great day. What a day to have a birthday. The 24th. April 24th? That's close, Nicole. That's close. Melissa, my son is in love with your board setup. Awesome, Melissa. If there's anything I could do to help your son out or give him advice if he wants to do something similar, I'd be happy to. I've helped many people or just consulted. Sometimes I call people and tell them what's involved, and like, yeah, that just confirms that I don't want to do this. So, I'm not that good of a consultant, I guess, if I convince people not to do what I love. But it's all good. All right. Have we checked on the status of Mr. Frog? I have not. Debbie. We might need to do a little check. I think he didn't show up for his court date. That's the last I heard. Yeah. Little Miss, mine and my nephew's is Friday. Little Miss, you have to be here so we can sing to you. We definitely want to do that. You've been a long time supporter of the program. Appreciate that. All right. Lots of Aries in here. I don't know what an Aries means. I realize that's like an astrological symbol, but I've never understood the impact of what that means on me. Or anyone else for that matter. The stars mean little to me. Would you recommend a GoPro in general? Well, the GoPro is what you're seeing right here, and I don't like it. I'll say that. I don't like it because I sit in arguably a very dark studio. I know I say we've got bright lights, and so many March 24th birthdays. I can't wait to share my birthday with all of you. But I sit here with many bright lights, and the GoPro is looking into the dark. So you can see, first of all, the flutter thing is a little frustrating. We can fix that. But there's a little bit of graininess in the picture, especially you can see it on my shirt, like a little static. It just doesn't have really good low light pickup, like, say, for instance, this camera does. This camera being much nicer. It's out of focus. I don't know why, but let's see if I can. Oh, no, that's just my eyes. Anyway, let's see. There we go. Let's go back here. That camera is much better low light. It's because it's an f1.4 lens, but neither here nor there. We have a couple things going on. We've got the court is coming up here rapidly. It's, as a matter of fact, they're already getting set. You can see the heads moving around, the flag waving as people are bustling around looking for more beverages to put in the judge's cup. The court starts today at 9 o'clock. It's not going to start with a jury immediately. Jury's going to be an hour later. You have to see mine backwards, so I get younger. There are very few things I can do backwards, but one of them, Little Miss, is ride a bike. I kid you not. I can sit on the handlebars, face the wrong direction, and pedal and ride a bike, and for some reason that comes easy. But I cannot do a somersault. It's just, I don't know, it's something in my DNA. Michelle M. says, 4 months of being with this wonderful community. Thank you, Ari, for providing great content. And thanks, everyone else, for being wonderful. Michelle M., I echo your thanks to everyone else for being wonderful. I think that's a bigger part than what I've done here, because you guys really have made this channel amazing. And I thank you for that. Are we past the opportunity for a directed verdict? I believe we are, I am Dave, because he's made the motion twice. In this court, they call it a judgment of acquittal, a JOA, and he's made the motion twice. Once at the rest of when the state finished their presentation, and once at the conclusion of all the evidence. The second one being an easier bar, a lower bar to reach, but still the judge denied it. But he did give it some nice thought and spoke highly of his argument. There is one more time he can bring it up, and in that case, it will be a judgment notwithstanding a verdict, or a JNOV, and that would happen if the jury comes back with a conviction. The burner phone number, ! burner, will tell you. There it is. The JNOV, judgment notwithstanding a verdict, is a chance if the jury comes back with a conviction, he could ask one more time for the judge to overturn the conviction and rule on the case notwithstanding the verdict. It basically has zero chance of succeeding if he made the motion of the JOA at the end of the case, in the evidence, the case in chief, and it was denied. There's no real change between those two. So I don't think he'll even make that motion. It might not even be appropriate if you've made the one to make the other. But I doubt that's going to happen. Either way. Let's see. Ooh, I just about deleted a very important soundbite. I don't know how I hit that button. I just about deleted the "because he's the guy" button.
Alex stole it.
That's not it.
Because he's the guy.
Because he's the guy. Chris Diaz says, R.A., he may have done it, but do you agree the evidence isn't there? I agree. And his testimony may have hit with the jurors. Mansfield is a pro. How many letters fit in this? Yeah, I know what you're trying to say there. Chris, I agree the state has not proven this case. I really wish that the defendant on the stand, Mr. Tucker, when he testified in his own defense, he would have said something to the effect of, "It wasn't me. I wasn't there. I didn't do it. You've got the wrong guy." So any one of those, any variety of that would have been beneficial for me to hear. A little eye contact with the jury and a heartfelt, this wasn't me. There's no evidence that says it was me because I wasn't there. Not just saying you can't prove it. We've heard him say there's no evidence that puts me there. But you can't prove it. Sounds a lot different to the jury than I wasn't there. It wasn't me. I didn't do it. And I wish we got that. But his testimony may have resonated with the jury. I would say he did a better job on his testimony than the prosecutor did in crossing him. I think Mr. Tucker being able to stay calm, where even though he got a little bit, his voice raised a little bit, but being able to stay calm in his response, and the Tucker and Mr. Mansfield sort of losing his control a little bit and letting it slip. I think that was the thing. Can't rule out hung jury, of course, option. It's very much an option. Depends how the judge instructs them. They might not know that they can be a hung jury. Let's speaking of court. Good morning, Judge. Hopefully we've got a charge conference here. Hopefully everybody's here. I see prosecution. I see nobody. Oh yeah, there he is. There's Mr. Tucker.
State versus Franklin Tucker. Everyone's here. Mr. Tucker, prosecutors, 17 CF 841. We decided that we would have a charge conference this morning. The state had presented its proposed jury instructions to the defendant. Yesterday afternoon, he asked for time to review and consult, which was allowed. So here we are. Basically, the way I do it, unless somebody has some other suggestion, is to, again, cross-reference my Florida Standard Jury Instruction book to go through these in the order that they're laid out and ascertain if there's any objections. I'm not going to ask every time I look at an instruction any objection. If the defendant has one, you can just raise it. We'll also entertain any requests for some special or additional instructions.
I'll trade it up for you guys a little bit.
So, similarly with the verdict form when we get to that. So, at the beginning of the closings, I give the 2.7, the closing argument instruction, standard. If both the state and the defendant have now rested their case, the attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. So that's standard, and that would be given when the closing arguments begin. So then the first one I see on this stack is 3.1, Introduction to Final Instructions. Again, that's standard. So just out of curiosity, for purposes of the verdict form, even though we've got an indictment and an information, they're all combined in these instructions. The felony murder would be count 1.
Yes, sir.
Robbery, count 2, ag assault, count 3, battery, count 4.
That is correct.
That's the way I think it would be proper to arrange it. So again, this might be a matter of form, but in my statement of the charge, 3.2, bracket in the beginning of line 2, next to the small c from the word crimes.
Judge, I put after the, I think what the court is referring to is I put just a blank copy of
the actual instructions with respect to each crime, but if you look at the statement of the charge, I don't know if the court's, I leave it up to the court's discretion. It says Franklin Tyrone Tucker, the defendant in this case, has been accused, and I actually delineate the crimes. I think I should have taken out that bracket, Judge, so I can correct that. The crimes of first-degree murder, felony murder, robbery with a deadly weapon while masked, aggravated assault while masked, and battery while masked. Is that what the court's asking, Judge?
Well, I was asking about the bracket.
I think that's a typo. I'll correct it.
I just get very sensitive about any little mark that could be construed by a juror as some subtle message or indication or trying to draw attention. So, and then the next question I have, like, I've seen it done both ways, like, in count one, the defendant has been accused of the crime of first-degree felony murder, and we go through all that. Then we have another statement of the charge in count two. So you've lumped them together. I'm not saying that's wrong. I think that's what you were asking me, if I wanted them to be separated out or lumped together.
Well, at least the state has no objection to relying on the court's discretion, Judge, however you think it should be. I don't know if Mr. Tucker has any preference.
Mr. Tucker, do you have any input on that issue? Reference 3.2 statement of the charge. As it stands right now, they are all put in one instruction, which is fine, or another option is that they can be separately delineated. I don't think it's a matter of substance. I think it's a matter of form, but...
You said 3.2, right, Your Honor?
Yeah, statement of the charge.
Okay, just checking because...
yeah, I understand.
I'm trying to keep up here.
Yeah, well, you should have a copy
I do.
of... Oh, okay.
I do. I'm sorry, I didn't mean to interrupt.
That's all right.
You're being very...
I just want to make sure I'm keeping up here because I was looking at some things of my own over here, but I'm okay. 3.2...
They're being very polite to each other this morning.
That's 3.2.
Selena K., thank you for the memberships. 5 of them.
Accused of first-degree felony murder, robbery with a deadly weapon while masked, aggravated assault while masked, and battery while masked. I believe those are the charges I am facing at this point, so I don't see where that's a problem.
Okay, it's fine. 7.1, Introduction to Homicide. Again, this is a standard instruction. Only problem that I see are these things in parentheses and brackets where the, like on line 8, parentheses, crime charged, end of that line, brackets, or third-degree murder. I mean, I don't think those parentheses and brackets belong there. They're like instructions to the drafter, I think.
The judge is going full grammar police mode.
You know what I'm saying, Mr. Alvarez? Do you see?
Yes, Your Honor, I do see them. I'll take them up.
I don't think that I don't think the crime charge or third-degree murder belongs there. So
are we in agreement that entire paragraph should come out there?
The entire paragraph?
If you find that Matthew Reed Bonnet was killed by Franklin Tyrone Tucker, you will then consider the circumstances surrounding the killing if the killing was
first-degree murder or second-degree murder or manslaughter.
I wouldn't take that paragraph out. That's taking out the paragraph that tells them the jury has to find that he committed the murder, that it was him. Don't take that instruction out, or else it would be easier to reach the murder charge.
Crime charge, and we'll just leave in first-degree murder, second-degree murder.
Well, okay.
So
are there going to be lesser included, or is it just, or is this just standard that has to be included?
There's a separate instruction, Judge, where I included the category 1 lessers, which I think are required by law.
Well, they're not required unless somebody asks for them. I mean, they're.
I included them as a caution. I can know what Mr. Tucker's position is with respect to that.
Well, either side can request lessers.
They don't
I
have
don't
to
think
agree.
there's any mandatory ones, but I think like second is a level 1, category 1 lesser, which means if it's requested, it has to be given. So either the state can seek lessers or the defense can seek lessers.
Your Honor, if I might.
Yes, sir.
Because this might clear up some of it too, I guess. I don't know, this may be a stupid thing, but I think it confuses the jury when you're putting on charges here, or lesser charges like the justifiable homicide, excusable homicide, all that stuff. When you're putting all this in here, it really confuses the issue for the jury. I mean,
he only wants
that's
all
what
or
I would
nothing.
believe. And you know, it's like you're not going to give me justifiable homicide. You're not going to give me excusable homicide. That's not going to happen. You know, if they find me guilty of felony murder, it's felony murder.
I understand.
You know, so I just think you're making this big packet of something that is actually very simple. I think.
So, Mother Troy,
well,
congratulations on 4 months.
You and many
thanks for
other
gifting
legal
membership.
commentaries and lawyers feel the same way. But the Supreme Court basically says this is the standard instruction. This is what you should give. So I don't necessarily disagree with you, but I believe it's mandatory, like justifiable homicide, excusable homicide. Those are, in my view, maybe not required by law, but highly recommended by the Florida Supreme Court as part of that homicide instruction. So I'm not going to strike them.
No, I would like to I'd like to keep the issues as simple as possible for the jury to understand.
I understand that, and so would I. I don't draft jury instructions. I'm not on the jury instruction committee, but I do adhere to what the Supreme Court decides. So unless the state wants to weigh in here, to me,
They're going to be lesser
the justifiable
included.
homicide and the excusable homicide are part of the standard instruction, which must.
Okay.
So,
May I confer with Mr. Tucker?
go ahead.
Yeah. On the third paragraph, under 7.1, I just want to make sure we are in agreement.
The only thing I'm with, I agree with.
If you find that Matthew Rebuttal was killed by Franklin Tyrone Tucker, you will then consider the circumstances surrounding the killing and deciding if the killing was, I'll make sure it says first-degree felony murder, second-degree murder, or manslaughter, or whether the killing was excusable or resulted from a justifiable use of deadly force.
Yeah, I don't even think you need the crime charged in there. I think you just go to first-degree murder, second-degree murder, that kind of thing.
Well, that's true. The parentheses crime charge, that's going to be removed. That's just
good.
Scribner's notes, drafter's notes, or third-degree murder. But
the actual delineated crimes would be first-degree felony murder,
right?
Second-degree murder, manslaughter.
That's fine.
Okay,
that's fine.
All
Can
right.
I trigger your OCD?
Yeah, keep it simple.
If you notice the doorknob behind Mr. Tucker, it's stuck in the up position. It hasn't reset to the lateral horizontal position.
Felony murder,
It's a lever
first
doorknob.
degree,
Sorry to tell you,
7.3.
now you can't unsee it. I think the judge is happy he sees the light at the end of the tunnel.
3A, 3B.
You're welcome, David.
Appears to be.
I was just checking the other page just to make sure, Your Honor.
I understand. You check however you like. I'm just
again the one thing I'd ask is I don't know if I can ask this or not, but
you can ask.
Just again parentheses and things that are accentuating some of the language in here. The dangerous weapon in quotes or the great bodily harm. It may have to be like
There's
that.
our doorknob view.
Well, we'll get to that. I certainly, as I said earlier, am sensitive to anything that's at all different in terms of the type or underlining or italics. I'm mindful of that.
Thank you,
but
sir.
I haven't gotten to that yet. I'm on 7.3.
Well, I thought this was the page prior to 7.3.
Oh, you're back. I'd already gone through that before 7.3. Okay, you're talking about the quotation marks.
I'm going to turn this down
around
just for a minute as they're talking
dangerous
about
weapon and great bodily harm.
grammar. Let me explain what's happening here.
they have to be there or not.
Well, it's a fair point.
The paperwork they're going to right now is the instruction set that's going to be given to the jury that the jury can reference when they're back there deliberating. This is their instructions of how to proceed. And cases can be won and lost on these instructions. So they're arguing the semantics of the wording. They're arguing the form of the wording, you know, how it's laid out, the paragraph, how it's broken. All of this is up for argument. And Mr. Tucker obviously is, you know, he needs to pay attention here because sometimes the wording can be changed a little bit that might be more favorable to him, and maybe tell a jury, you know, I don't want to go this way. I have an option. I realize that these instructions give me an option to do something else. And so the crafting of this is an art form. A lot of times you'll have, say like we had in the Maya trial, we had an attorney almost dedicated to this side, to the jury instructions. Mr. Altenburn was you know, handling the jury instructions. They had dedicated that to him because it's that important. So it's going to be about an hour or so of this. It's a little bit mind-numbing at times. It seems not very important, but it will be to the jury. The jury looks at this, and this is their roadmap for moving forward. Is that a door handle, not a knob? You're right.
Quotation marks, dangerous weapon, great bodily harm. I believe they're in quotation marks because those are legal terms, and I believe the drafters just wanted to be sure that it was clear what the definitions of those terms are. I think that's why there's quotation marks there. That one, I don't think they're not extraneous marks, but
like I said, I didn't find fault in here anywhere. I'm just looking at this stuff, and you know, I'd like.
I don't think if that's the way they're in the standard, we can just leave that there.
I don't expect a lot of changes to these because they literally are
7.3.
copy and pasted from the Supreme Court's template. So they're not going to be slanted one side or the other, but there might be some slight changes based on the events that happened in court, what did or didn't happen.
So now, robbery, so that's being included as the alleged underlying felony at this particular point, or we're going to count 2 here. I believe you have to define in felony murder the crime that was the underlying felony wherein the victim was killed. So I believe that's why the robbery is included at this part of the instructions, 15.1.
Lauren Janai, good morning. Thanks for being here with us. I appreciate all the insight you've given us over the course of this trial.
Okay, so looking at 15.1, I'm down to the 1, 2, the paragraph beginning with the taking. Do you see that?
Yes,
there's a bracket at the beginning of the 3rd sentence, and then it ends at the near the end of the 5th sentence. I don't believe, now see that bracket I don't believe is appropriate. Stay
with agree on.
Okay.
The brackets are being deleted. Very little else has been changed.
Yeah, I'd also,
substantively.
Quotes at the bottom, in the course of committing the robbery, I don't think that's a legal term. I think that's, again, something that accentuates it.
Yeah. No, I have to disagree there. I believe that again, these are highlighted in the standard instructions because of the fact that in the course of committing, that is in fact the term that, believe it or not, is a subject of litigation and disputes. You know, does it mean after flight, for instance? So there's all, believe it or not, all sorts of litigation surrounding whether something's in the course of committing. So I'll go and check my standard instructions again, but in my, yeah, here it is. They've got it in quotes. So I'm going to, if it's in the standard, I'm going to leave.
Judge, the state would respectfully point out at the end of 15.1, the very last sentence, there are brackets included in that, and that should be removed.
An object not designed to inflict bodily harm may be a weapon if it was. Okay, so just remove the brackets. I mean, the phrases within the brackets appear to be appropriate.
Yeah, just remove the state saying just remove the brackets.
An object not designed to inflict bodily harm may be a weapon if it is used or threatened to be used or intended to be used in a manner likely to cause bodily harm. Okay. All right. So then, again, I hate to nitpick, but on that page, great bodily harm, you see the third paragraph down the page that you referred me to? Look at the third paragraph, great bodily harm. You see that?
Yes. Yeah, sure.
There's a quotation at the end, but not at the beginning. You see that?
Yeah, sure.
We're going to need more than an hour to do this.
Quotation marks there.
Yeah, we got to be consistent.
This judge aced his English class in high school.
Again, the standard shows the quotes right before the uppercase G. Put up there, please. Principles. If the defendant helped, that's 3.5A. If the defendant helped another person or persons, again, we've got brackets here. Commit, attempt to commit.
Jury will be here within an hour, so they'll be here actually in about 40 minutes.
What's the actual verbiage that state wants to use here? Both? Is it attempt or is it commit or attempt to commit a crime? One or the other or both?
Let me see.
3.5, you see?
Let me just say this at the beginning of the day as well. We do have Lauren Janai with us. She is the wife of the defendant in this case. She has called in a couple times to give us some information and set me straight when I was wrong. I appreciate that. I would ask that you guys be respectful and mindful of the fact that we have family and friends that are watching this. And
we're in agreement that the brackets are
to many people, this is a lot bigger than what it is to us who are just watching as observers. So please be respectful to them. And if you do have opinions that differ from them, you may be able to share it respectfully, but please be polite.
So it's no brackets, commit or attempt to commit. So there needs to be an or in there, in my belief. It wouldn't, I think.
I would agree.
Thank you. If the defendant helped another person or persons commit or attempt to commit a crime. So you take away the brackets, insert an or.
Yes, sir.
Defendant is a principal and must be treated as if you have he, she. It should be he, no brackets, take out the she.
Yes.
They just copy-pasted. They didn't correct anything.
And then once again, we get down to subparagraph 2, and there's brackets, or the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit. I believe it's eliminate brackets, insert or between those two unbracketed phrases. Again, some of this may be form over substance, but I believe they're important. Legally interlocking counts. 3.12D. All right, first sentence. It looks like is spelled wrong. Robbery, IA. I think that's supposed to be IS. You see that?
Yes, sir. Yes, sir.
Okay, so we say count one of the indictment. Okay, then, oh, this is interesting. Why do we have 2 periods after felony murder there? 3.12.
We've found the judge's pet peeve here. It's punctuation.
If I might.
Yes, sir.
The other thing I find a little bit confusing for this is I get that, the felony murder charge The felony murder charge is dependent on the robbery, and you know, it's like, okay, but they're doing it in reverse. The felony murder comes first, and then the robbery comes second. I just think that's a little bit confusing for people.
Well, I understand, but
They start with most
that's
severe.
kind of the way the standard instructions are organized. So I'm
not, you know, again, I'm not, you know, an expert in any of this, and it's just I'm just telling you what I think, Your Honor. That's all.
I understand that, and this is the rather tedious, one of the rather tedious aspects of a trial is to, you know, review and refine jury instructions. It used to be years ago that, not that many years ago, the jurors were given verbal instructions only. Now, the jurors get the verbal instructions as well as a copy of the written instructions. So actually, I will read what ultimately is agreed upon, plus they'll get the written copy. But we're on 3.12D, and this has to be cleaned up. So robbery is an essential element of the crime charged in count 1 of the indictment.
This is a big packet.
Murder.
It's a big packet.
Oh, okay. So there shouldn't be 2 periods after murder.
I would agree, Judge. I've already made the delineation to correct.
You should first consider the evidence applicable to
count 2.
It's like they didn't proofread this for a simple punctuation.
2,
which is robbery.
If you find the crime in count 2 has not been proven beyond a reasonable doubt, you must find the defendant not guilty on both counts 1 and 2. Okay, so again, just a matter of form. You have numerals for count 2 and you have a written 1 for count 1. I think they have to be consistent. So it's either we're going to use
bullet
numbers or we're going to use the word.
Third.
But count 1 is O-N-E and count 2 is the number 2. So
I will.
Ashley, I'm going to put a link in chat for
word 1 and
my favorite professional metal detector, and this is professional. So give me a minute. I'll add it in chat and tag you.
A good idea. Otherwise, looks okay to me. So now we're going to 3.4, when there are lesser included crimes or attempts. So presumably, Mr. Tucker, you're aware of lesser includeds, and even though they're not pled in the information by virtue of the language of the charge and the evidence presented, they are crimes which have been included in the definition and which can be substantiated by the evidence. You may request lessers, the state may request lessers. So is the defense requesting lessers?
No, Your Honor. I mean, you know, because I don't think they actually apply here.
Right.
Again, this may be stupid. It's just I think it, in order to keep it simple for the jury, it's like I don't think they're going to find me, you know, guilty of felony manslaughter. Manslaughter. I just don't see that happening. It's
I understand, you know, and it's certainly a strategic choice, and perhaps you're basically doing the so-called all or nothing defense. I mean, your position was I wasn't there, it wasn't me.
Right.
So
I think it just becomes confusing. You know?
I understand that. So then the issue is, as I indicated, either the state or the defense can request lessers.
We're going to request second-degree murder. That's a category 1. So we're not going to request manslaughter.
Okay.
So it's going to be all or nothing on that one.
That's fine, Your Honor. If the simpler, the better.
I understand, but I do believe, as Mr. Mansfield indicated, that second-degree murder is a Category 1 lesser. What does that mean? That means that if it's asked, I got to give it. But you're going to not proceed with manslaughter.
That is correct.
So we're going to delete manslaughter from 3.4. So now we get to read the 7.1 again, introduction to homicide.
Judge, here's and I did inquire of my colleagues, the prosecutors, Mr. Greenberg and Mr. Reeves. I know some judges, I'm deferring to the court, some judges like to read introduction to homicide before they read the instruction on second-degree murder. It's really, I don't know if you want to regurgitate it again. I don't know what Mr. Tucker's position is. I just put it in there as cautionary in case we needed it, so we would have it.
Well, I don't have a set position on it. If it depends on what the parties want to do. But if you're flexible, and Mr. Tucker says he wants to make it simple, and I don't think it needs to be repeated. They've already got it here once.
That's always been my preference, Judge. But I just, like I said, in an abundance of caution, I just wanted to include it in the package.
I think we're in agreement then, because I would like to get rid of any redundancy.
I'm sorry, I didn't hear you.
I said I'd like to get rid of any redundancy.
Okay, but again, it's certainly logical for it to be included in the package initially, and then we talk about it, and we agree that 7.1 is not needed. We're taking it out.
All or nothing is a gamble, but at the same time...
So then we get to 7.4,
lesser included
second-degree murder.
Jury who might not go for who might vote to acquit if it was all or nothing, might feel better going for a lesser included if there's a lot of opposition in the jury. It's a risky move, but I can see why he's doing it.
That looks pretty straightforward. So then we can take out the next 7.1 because we're not going with manslaughter. We can take out the 7.7, and now we come to robbery with a deadly weapon.
Agreeance is a word. It's the act or state of agreeing. He used it properly in context.
I'm just curious, do you have something in here about a mask?
Judge, there is an instruction at 3.3E. Later in the instruction says aggravation of felony by wearing a hood, mask, or other device to conceal identity.
Okay, that's part of this instruction, or is just...
That's a separate instruction on itself.
Okay. So 15.1 looks like it's subject to the same corrections as it was when it was included in the felony murder instructions, right?
Let's just remove the bracket, I believe.
The bracket.
Fisher metal detectors are good. They've been around for a long time. So there's some older models and some newer ones as well.
The quotation mark at the beginning of great bodily harm on the second page.
Yes, sir.
The elimination of the brackets at the last paragraph on the second page. It's the same modifications that we discussed for the instruction when it was included in the felony murder instructions. The same things. Aggravation of a robbery by committing an aggravated battery. Haven't seen this instruction too frequently. 3.3C. The principal instruction, 3.5A.
This is the one
All
where
right,
if
we've
he's
got the
involved at all,
same
he's guilty of everything.
modifications as we did previously. The elimination of the brackets and the inclusion of OR in the first sentence. The elimination of the brackets and the inclusion of OR in subparagraph 2, last line. So once you finish making your note, tell me, because I just had a thought.
I'm ready.
If the state is now not asking for manslaughter, don't we need to go back to that initial introduction to homicide instruction?
That is correct.
And eliminate that crime? So 7.1, I'm going back here.
We're removing the lesser included.
If you find Matthew Reed Bonnet was killed by Franklin Tyrone Tucker, you will then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder or second-degree murder. You know, the manslaughter is out.
Judge, I think we agreed that it would read first-degree felony murder.
Right, okay. All right.
And then we'll remove manslaughter.
All right. That's presumably acceptable to the defense?
Yes.
Okay. So then we go back to where we left off, the modifications to 3.5A. Aggravation of robbery by carrying. Okay, somebody already circled the fact that carrying has got a bracket with no G at the top. You see that?
Yes, sir.
All right, we've got the same problems with the brackets in line 3 and 4 of paragraph 2. Used, no bracket, or no bracket, threatened to be used, no bracket, or no bracket, attempted to be used, or intended to be used. I think all those phrases are included, but they're not bracketed. Would you agree?
Yes, sir.
Then we look at the last paragraph, and it looks like there's a stray bracket in paragraph 3.
This is the bracket roundup.
Personally
brackets
carried.
all over the place.
You see that single bracket there?
Yes, sir.
Take that out.
The jury has to convict and find beyond a reasonable doubt that he's guilty.
Aggravation of a felony by wearing a hood, mask, or other device to conceal identity.
Whoever typed this up uses brackets like I use commas. They're everywhere. They're just, the whole place is it's littered with them.
So here's another 3.4. Lesser included. Robbery with a weapon and robbery.
They asking for lessers on this one?
Oh, man.
Judge is looking at the clock and seeing how far he's in this. He's like, oh, great. We're way behind schedule. We're not supposed to be able to hear them, so the audio keeps getting turned down when they whisper loudly.
Okay, so were we requesting lesser included as to the robbery count?
Yes, Judge.
And which ones are being requested?
Just robbery with a weapon and just robbery, Judge.
Does the defense have a position on that?
No, Your Honor, other than, same problems we had before.
I understand. I believe they are so-called Category 1 lessers, and if they're requested, they have to be given. So, once again, we have the whole bracket issue here.
I'll make the same notation, sure.
If we include he, not she, take out the bracket around 4 crimes.
Do you want a curly bracket or a square bracket? I mean, like a fancy back
so
bracket.
now we've got 15.1 robbery with the Okay, why does it say deadly weapon? If it's robbery with a weapon as a lesser included, it wouldn't be deadly weapon, right?
That is correct, Judge. I'll strike that.
But is it the same instruction otherwise?
Again, I'm the layman here, Your Honor, but it seems redundant again.
Well, there is an element of redundancy in these instructions. It's virtually that way in almost every set of instructions. That's the way, again, the standard jury instructions are structured. They say repetition is the key to learning, at least one of them, so I understand that. I'm just focused now at the proper title to this.
I've added brackets.
We have to strike the word deadly, Judge. I have to go back and check. And
well,
I think the rest of it is actually pretty good.
So you're going to call this robbery with a weapon, and then you're going to call the other one robbery?
That is correct, Judge.
So you're taking out deadly.
That is correct.
Then we get down to that paragraph that's bracketed. The law does not require the force, violence, etc., and then ends with taking. There's brackets there that don't belong. You see that?
Yes, sir.
So then at the last second page, the definition of weapon, again, we have to eliminate all those brackets.
It seems petty, but the judge wants this to be perfect.
Yes.
Yes, I've made the proper notation.
I'm just going to call it right here.
So now we're on to robbery.
When the judge reads this to the jury, he's going to find another error.
Here, since we got rid of deadly in the title, there's another section here where it goes, oh, never mind. Okay, because it says the knife was a deadly weapon. I caught that, and I don't know.
Where are you looking?
I'm looking at the very top of the second page.
Yeah, a deadly weapon.
Yeah.
Okay. That's a good point.
Robbery with a deadly weapon is the last statement. I think it would be robbery with a weapon at that point.
Well, that's not a bad point.
I wouldn't take deadly weapon. I wouldn't take deadly out there.
State will agree, Judge.
That helps the state.
Well,
yeah, they readily agree.
To what?
I don't think I don't think the definition of a deadly weapon should be in that instruction.
By just saying robbery with a weapon,
yes,
it means it's easier for the jury to reach the conclusion
thank you, Your Honor.
that he's guilty of that. Meaning the jury doesn't make the determination if the weapon that they believe he had was a deadly weapon or not.
We've got the same paragraph problem with the brackets in that same place.
Judge, we're not going to ask for robbery. We're not going to ask for that as a lesser.
Okay, that's fine with me.
So we're just going to strike that, right?
Yes.
Okay, thank you.
Yeah, so then that would have to be
robbery with a deadly weapon.
In the,
no lesser included of just robbery.
3 point, whatever the lesser included instruction is.
Trial Watcher Canada, welcome to the gallery. Thank you so much. I would sing the national anthem for you.
Oh, so we're going to take out robbery.
My home and native land.
Okay.
Actually sang the national anthems for Canada, England, United States, and then the Scottish one, which is actually just a drinking song, O Flower of Scotland.
Isn't there an aggravated assault here?
In a big the Scottish festival, opening ceremonies. My family did.
Yeah, aggravated assault is count 2 on the information.
They're removing the robbery, the lesser included of robbery. They kept the greater of robbery with a deadly weapon, or with a weapon. I believe they took deadly out.
Very beginning, the state null pros counts 4 and 5, and left the robbery, the ag assault, and the battery. So, unless it's in a different place in my packet here, I don't see aggravated assault instructions.
I could have sworn that I included it in there. I apologize to the court if I didn't.
Well, is it in your packet?
I'm looking right now as we speak. Robbery with a deadly weapon. Aggravation, robbery, principles. Aggravated assault.
This is paperwork, and it's frustrating, but it has to be done right. If the jury gets the wrong instructions or incomplete instructions, they'll be very confused. There'll be a lot of questions on possibly
No, Judge, it is not in my packet. I'm going to have to include
a mistrial issue. Flowers College is more than a drinking song. I'm just saying, it sounds like it sounds like a song. I see that you've got the thistle there in your profile picture. It sounds like the sort of song you would sing down at the pub with your mates during a soccer match. It's just it has that feel to it. I mean, I get it. You know, when will we see her like again? That fought and died for this wee bit hill and glad. The words are stirring, but it's just you almost need a tankard or a pint in your hand to do it justice.
No, it's not there yet.
Jen Devka, welcome to the gallery. Thank you very much.
So,
great to have you as a new member. Make sure you take a seat by typing !seat. Get reserved seating. More rugby, or it would be football, like British football, or rugby. Yes, so I call it soccer because most of the people here might know it as soccer. I've been to one football match in England.
8.2 is
it was tremendous. It was wonderful. Scared the daylights out of me leaving there with many intoxicated people who were unhappy about the outcome.
4 elements beyond a reasonable doubt.
I think was it Tottenham? I'm trying to remember who I watched. I'll have to go back. I didn't have a dog in the fight. I just had the opportunity to watch a football match. I took
actually, it's while masked, so. I have to have a separate finding on the verdict form.
Yes, we do, Judge. Now we do. We do have that.
All right, so we're going
to include aggravated assault in the instructions.
Well, I shouldn't assume. Is there some lesser of that?
We don't want any lesser. We're not asking for a lesser.
And I'm assuming as to the ag assault that the defense is not asking for a lesser either.
No, Your Honor.
So then we go to the
It was all that was available. It was all that was available. It was just a spur of the moment.
8.3.
I would have preferred to watch Newcastle or Manchester United or something like that, but I believe it was Tottenham. It was where we were at, where the tickets were offered to us. Michelle, the happenings in court, the way things present, and the facts of the actual charge, the actual the crime, mean that sometimes the instructions for the jury have to be adjusted to fit the actual
lesser
scenario.
included a battery being sought.
Oh yeah.
Plea of not guilty, reasonable doubt, and burden of proof.
I'm not dissing them. It's just I'm not as familiar with that team as some of the other Premier League's teams.
weighing the evidence, 3.9.
Realize this was back in the days that the Spice Girls were
Standard,
a thing.
no brackets as far as the
It's a long time ago.
All right, what about number 1 through 5 are standard benefit. Guys, that belongs. Number 6, inconsistent statement. Number 7, what about convicted of a felony or crime of dishonesty? So,
I think that can come out, just that no evidence was presented on any of the witnesses.
I don't know. I mean, wasn't Johnson, didn't he plead to a felony? I mean, that's the only right in this case, so I assume that would be the basis for the inclusion of that. I mean, Mr. Tucker got up there and said he had been in jail, but there was never any impeachment about any convictions of him, but I do...
You're right, Judge. I was thinking before this crime, but
No,
since Johnson testified.
No, I understand, but I'm just, again, trying to, consider everything. The conviction was final prior to his testimony, so I believe that would stay in.
Judge, do we leave it, has witness been convicted of a felony, question mark? Or do we do we take out the dishonesty part, or we just leave it as is?
I don't recall any evidence of a crime of dishonesty, so again,
it goes.
Mr. Tucker has some input, but what I recall is the agreement and the convictions in conjunction therewith. So, Mr. Tucker, did you have input on the inclusion of a crime of dishonesty here? Because,
to be honest, while I would love to leave it in, Your Honor, I don't think it would be fair to leave it in.
I think you're right, so we'll take that part out. So then let me review this instruction, the standard, just to be sure.
Evangeline Light, thank you for the huge super chat.
And
thank you
Your
so
Honor,
much.
Unless, because I know Travis, when he took his plea, he took it for robbery. I guess that could be considered a crime of dishonesty. I don't know.
The sound effects from the judge.
It's normally classified as a violent offense, but
I defer to the court.
State have any input here?
State would be opposed. I don't think it'd rise to the level of crime.
Yeah, I think normally, we're talking about stealing, passing bad checks, stealing and stolen property, fraud. I think the felony conviction is what pertains there. So I'm looking here.
This
I don't
is
see
his
any
true
of these
love.
others.
English
The
teacher.
defense requesting any of the others that are 1 through 10. We've got 8 of them.
Adam.
So.
1 through 10.
Adam Nusky. Hang on one second.
Standard jury
He just
instruction
added brackets,
3.9.
Yeah, I see
Reading
that.
the evidence. There is 10 options. 1, 2, 3, 4, and 5 are standard. Then there's 6 through 10 that are optional. Depending upon the evidence, they may or may not pertain. Number 6 pertains. Number 7 has not been included, pressure or threat. I didn't hear any evidence of that. Reputation for dishonesty, truthfulness, I didn't hear any evidence of that. So 7 and 10 have not been included, but everything else has been.
7 and 10? Okay.
Number 7, had any pressure or threat been used against the witness?
Okay, gotcha. And let's see.
Number 10, general reputation. There's been no reputation evidence, so I would agree with the factors that have been included. Just take out the dishonesty. All right.
I agree.
Evangeline, thank you so much. Appreciate the kind words. Thanks for your generous super sticker as well.
Expert witnesses. Okay, then the accomplice, informant paragraph, that is included, appropriately so. Defendant in this case has become a witness. That portion is appropriate. entirely proper for a lawyer to talk to a witness about what testimony the witness would give. That's okay.
That's okay.
All right.
Yeah, that's
so
it.
Now
that's been discussed.
We're going to rules for deliberation. That is 3.10, 3.10, paragraphs 1, 2, 3, 4. Okay, number 7, I don't believe belongs there. The jury is not to discuss any questions that a jury wrote that were not asked by the court. We didn't have any jury questions, so I believe 7 is not applicable. So please delete that one. 8, so we renumber them. 8 is certainly applicable, but that becomes 7. Cautionary instruction, that's appropriate. Verdict.
My kid's personal Uber driver says, tried giving my 17-year-old a recap last night. No disrespect to victims.
3.12a,
I couldn't get through the actual facts
counts.
without crying, laughing. I felt crazy saying this stuff out loud. There's not a lot of evidence here. There's not a lot there.
Okay. Verdict forms.
Austin, thanks for the kind words. Thanks for letting your wife watch with you. You can enjoy together as a couple.
So it would seem as though we need to take out manslaughter out of this verdict form. It's guilty of first-degree felony murder, guilty of lesser-included offense, second-degree murder, not guilty. No manslaughter. Count 2. So, guilty as charged in the information. I mean, again, maybe this is nitpicky, but it seems like the jury, find the defendant guilty as charged in the information offense of robbery ought to be more to the left. And, you know, if you were doing an outline, that would be the furthest here, and then those sub-findings would be indented. Again, that could be nitpicky, and maybe that's unnecessary, but if you find the defendant guilty of robbery, you must then answer the following questions. In the course of committing the robbery, was Franklin Tyrone Tucker in possession of a deadly weapon? Yes?
Again, Your Honor, it seems a little redundant, and again, we're going back to the deadly weapon thing, but I'm like, again, it seems like that could be one line, you know, to me.
The state's going to
maybe I'm wrong.
Jump on this if he wants to remove deadly, because that helps them.
Most defense attorneys would say that the no should be included in there, because otherwise the jurors may think they have no option. That's, you know, again, these are fine points, but my experience when I have an interrogatory verdict form, we give them a yes/no option, so there's not the suggestion that you don't have a choice.
No, I wasn't. That's not what I was saying, Your Honor. I was literally, it's in the course of committing a robbery was Franklin Tyrone Tucker in possession of a deadly weapon, and then goes down to 2. In the course of committing a robbery was Franklin Tyrone Tucker in possession of a weapon. I think we could just do with one of those and yes/no after that. I don't know.
The verdict form that I have on count 2, there are 2. There are 2 options, one for yes and one for no.
Yeah, I know, and I was responding to Mr. Tucker's query about whether the no was needed, and I said I believe it is. His point now is that deadly weapon and weapon are redundant, and my response would be that weapon is the lesser included, that you can
jury's waiting now.
Not you,
jury's here.
Generic you can do a robbery with a weapon that's not a deadly weapon. You could, I
thought we got rid of the deadly weapon, is why I was asking.
We did in the lesser included, but it's just a weapon. So the jurors could somehow, I don't know. Again, I'm just talking here and theorizing. They could say, you know what, we don't believe that it was a knife. We believe that this club or this piece of pipe or whatever it was, or this small knife, we don't believe it was a deadly weapon. We think it's a weapon. So that's why, or whatever else that they might believe constitutes a weapon, that's a lesser included. The states ask it, I've given it. So.
Okay. And Your Honor, I totally understand, and yes, I agree with the whole yes/no thing. They should have both options.
Austin French, thanks for leaving us with that.
Okay.
Starting to
Now
fight
we've
on the
got
way out
the
the
mask.
door. Lesson of the day,
All right.
parentheses, brackets, braces.
So here you do have the ag assault in the verdict form. You just don't have it in the instructions.
And in the first,
Thanks, Kelly.
the jury judge will bring the intonation over.
Well, it's all right. I mean, it's fine. You got enough other changes. It's fine. It's not a matter of substance. It's a very, very nitpicky point. We don't need to spend time doing that. So wait a minute. Aggravated assault weapon. I mean, that's a lesser. I thought we weren't going to have any lesser included. So, in the course of committing the aggravated assault, was Franklin Tucker in possession of deadly weapon? That's. I didn't even know that was an issue in that charge. But okay, let's say it is. But possession of a weapon. So. What does that do for the penalty? Does that change anything? I've just never seen an aggravated assault charge.
I agree, Judge. I think that was a error on my part based on the previous jury instructions that were submitted in, I guess, the Rory Wilson case. I think the only thing that should be included in there was, in the course of committing an aggravated assault, was Franklin Tyrone Tucker wearing a mask.
That's what I think. I mean, inherent in the charge is the deadly weapon. So what I'm suggesting, what the state's agreeing with Mr. Tucker, is to eliminate those special findings under count 3 aggravated assault, taking out the findings regarding deadly weapon and weapon.
Yes, sir. I agree.
Okay. The mask remains. Count 4, battery. That looks straightforward. So now I'm not sure why I have all these.
Judge, those are just additional. I don't think those are applicable, to be honest with you.
Okay, but we're missing.
The ag assault.
Remember, we're missing something else too. Submitting the case to the jury.
Oh no. They missed the ending summation.
Let's after we do the verdict form.
Somebody just brought us, a neighbor just brought us some candy cane flavored cocoa for Stephen's Hot Cocoa. And she also brought me like a 5-pound marzipan bar, which I've never had before. I've had a marzipan pig before, but never a marzipan candy bar, which I believe the candy bar serves 16 people.
To the jury room by the bailiff. Then when we get down to verdict, it should be verdict forms.
Excuse me, I'm trying to catch up, and where are we at this
point? It wasn't
that.
submitted in the state's package.
Oh, okay, got you, okay.
It's a standard jury instruction 3.13. After I go through all these instructions and I go over the verdict form, then
that's how you tell.
I've got to give 3.13 to explain some practical truths.
The state has messed this up.
Just looking at
they copied and pasted and did very little else, and it sounds like they didn't even proof.
Okay, again, we're going to be referring to the court security as bailiff. Your phones or any of those types of electronic
Debbie, thank you very much. Bar bracket is best.
Kindly leave those devices on your seats where they will be guarded by the bailiff. we include that. And I'm going to elaborate and talk about the lockbox. But
is that already in the standard, Judge, or is that something that I have to include?
What?
What you just read?
It's in the standard about the cell phones. Okay. Then, if you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote. If you have a question, I will talk with the attorneys. So then here is a choice. During the trial, items were received into evidence as exhibits. You may examine whatever exhibit you think will help you in your deliberations. Option A is what I go for. The exhibits will be sent into the jury room with you when you begin to deliberate. That's, I believe that's a better practice than keeping everything out here and making them ask for it.
State agrees, Judge.
I would agree, Your Honor.
Okay. In closing,
this means there are fewer questions that we get to hear.
That part. So it's standard with just those few options that I've identified. So yesterday we talked about closing arguments. So the state had asked for up to an hour and a half, and I acquiesced. Again, that doesn't mean you have to use it all, but what it does mean is you can't have any more. That's the, and you get an hour and a half too if you want it. But again, that's the limit. By no means.
Your Honor, are we finished with the jury instructions so far?
Yeah.
Okay, because I was wondering about the stuff that's in italics under the felony murder first degree.
We talked about that. That's just redundant. We're going to just exclude
get rid of it. And then I have one I would like to add.
What is
1.6. It's about pro se.
1.6. All right.
He's done his homework.
Pro se defendant. Franklin Tyrone Tucker has the right to be represented by an attorney or to represent himself in this trial, as do all criminal defendants in this country. He has exercised his constitutional right to act as his own attorney. This decision should not affect your consideration of this case. You want that?
Yes, sir.
Okay, he's entitled to it.
No objection.
So the state can prepare that in the same format as. And when would we like to give that? At any particular point in time where you request that be inserted?
No, Your Honor, just that it's in there somewhere.
I know. I'm just, sometimes, again, it matters to some attorneys, people, when it's given. Other times they're ambivalent about that.
Perhaps it should be back there with the rules for deliberation, because it kind of goes towards that.
Yeah, I would agree with Mr. Mansfield there. That sounds fine.
Back there, so at the very end, the others.
No problem.
Again, being it's 1.6, some would suggest it's at the beginning because it's at the beginning of the instructions. So I just want to know.
If that'll keep it simpler for the jury, again, 1.6 comes before 3. I get it. So yeah, that'd be fine.
Okay, so then. All right, so 3.1, Introduction to Final Instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Then I would go 1.6. Right after that, the explanation that the defendant is acting as his own attorney. That seems logical. Any other?
No, Your Honor, I haven't seen anything else that I think needs to be added.
Okay, so I guess Mr. Alvarez, you're the point man over there.
I am, Judge.
For these instructions of
from coordinating and being a stickler for all the court's instructions. If we begin closings now, I'm assuming I'll have ample time to make the necessary corrections over the lunch period, Judge, and have them all ready to go. Is that okay with the court?
It's fine with me. I mean,
rather than having
right, we're not going to. I think it's unwise to put you under the time pressure of hurry up and get this done, and then we have to check it, and these people, the jurors, are waiting.
Exactly.
I don't think that's wise nor necessary. What I think would be, we all know what they are. Most of the changes have been cosmetic. So nobody's going to be prejudiced by the fact that the final copy isn't available. So my suggestion would be we bring in the jury in just a moment. We go into closings. As again, whatever internal work assignments, that's your office's business, but whoever's going to do it, work on it. Should be done probably well before closings are finished. When closings are finished, we'll review them, and then we'll instruct the jurors at the appropriate time. Sound like a plan?
Yes, Judge, sir.
Sounds like a plan to me, Your Honor.
I wonder if the judge is going to let both prosecutors participate in the closing, or if it has to be the same person.
I would like to.
Restroom or whatever.
Okay.
Huh?
I would like to, if that's okay.
All right, so I assume the jurors are there.
Yes.
All right, so let's take, and I'll have to figure out about lunch and the like. We'll see how long the closings go. I might give them a stretch break at some point in time, maybe after the defendant's argument, maybe after yours if I think they need one, but I'll just use my discretion. So let's take a break until 10:25, and we'll bring them in and start with closing.
Since you just the state's clear, it's safe to be able to work on these during the lunch break, correct?
The lunch break? Well, I thought you were going to work on them during closing.
I had intended Mr. Mansfield was going to do the first part of the closing. I was going to do the rebuttal. But I'm very confident I can get most of these corrections done within 20 minutes, 30 minutes.
Okay, then I guess I didn't understand what you were saying. I thought the plan was to one of you all make the corrections during closings, and then we would come back, review them, and give them. But, okay, I mean, we can give the jurors lunch, and you can work on the instructions, and we can come back a few minutes early and instruct them after lunch.
Thank you so much.
Thank you.
Okay, let's take a break.
Okay, Judge is like, I've done enough work this morning. We are taking a break here. As that happens, right now I have an appraiser at my house, and he's measuring outside. He's actually right outside my window. He's out by the cat house, measuring the deck. And then he's going to come in and measure. So he might be walking in through here measuring stuff. Hopefully he doesn't kick any cables or unplug anything. It's a mess in here, so we'll see. But he's going to measure it. We need to do this because we have to find the actual value of our Airbnb before we improved it. So we're going to take if that happens, I'll just disappear for a little bit. But anyway, that's going on. Let's see, Will Wave. Did he just buy that house? Why appraise it? Content lasagna is a little complicated. It has to do with a business deal we're doing with friends, and we're bringing existing structure to it, and they're bringing a lot of the upgrade. And so the contributions for our joint business venture have to be measured so that we know where everyone stands. That's it. It's not. We're not even doing a current appraisal. It's an appraisal based on last February. All right. Smile, I'm on camera. I am on camera. It sounds illegal, says Greeners. It sounds expensive is what it is. It's like $750 for someone to tell us how much our house was worth a long time ago. But that's the cheapest we could find. It's necessary, unfortunately. So luckily, it's a business expense. All right. Let's see. It's important to determine the basis in the business. Yes, it definitely is. R. Bauer, let's add another month, friend. Let's add another month. Thank you very much. I appreciate that. 4 months. Thank you. It was wonderful to make your acquaintance during the Cavalcante manhunt. The judge does need a lot of breaks, but he also drinks a lot of water. We think it's water or coffee or something stronger. I'm not sure. It might be Fireball for all we know. All right. Can we get a discount code for the Airbnb? No. It costs us enough that we can't do discounts, unfortunately. Maybe one day we'll break even on it. It was expensive. All right. Let's see, any other questions? A couple of people were asking for a recap of where we were with the trial, and to do that, I think it's only fair that we show the thumbnail, which is what we have so far. The thumbnail. This is the latest and greatest. I'm not sure if you can see very well here, but we did. Come on, to click here and then zoom in. We did add some brackets that are floating around to the judge, the angry judge. We've added the judge there. We have the fireball in the sky next to the moon. We've added a little reflecting pond or reflecting pool right down here for the judge to gaze into. We have a brick, because a brick is not a wall, as Mr. Tucker taught the judge yesterday. That was great. Hang on one second.
Call from Bree.
Bree, how are you doing this morning?
Good morning. I just have two quick questions. One, maybe it's my ADHD brain, but why wouldn't it have been simple if they have all this stuff, it's all in the computer, like these are a document, somebody's obviously not proofread, but not done. There's two attorneys there. Why were they not just updating these instructions as the judge was giving them? Like one person take notes, hey, this needs to be changed page here, 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 and then the other person start making them as they go so they were ready?
Well, that would be the wise thing to do. You'd think that that would happen. There are only two of them. They're focused on the case, I think, and working together hand in hand, and they sort of view this as an afterthought. They said that they basically just took the state standard instructions and just copy and pasted them. So I think they looked at this and said, it's just going to be easy, no-brainer, copy, paste, we're done. I guess they didn't realize the judge is very particular about punctuation and everything else. And so, I mean, they've learned their lesson.
Do we need to have somebody go proofread the Supreme Court jury instructions to make sure they're all correct? Because I mean, if they're downloading them from somewhere,
it could be that they pulled them from different versions of and so the formation of the pagination is that a thing? The setup of the whole thing was different, and so some have italics and some don't.
I was just like, now somebody's going to have to work through somebody's closing and they're not paying attention. I'm like, I would have just, maybe it's my ADHD brain thinking I need to do more things than one thing at a time. And like, well, you could have already been doing this and been done by now.
Yeah, I could have. Brady, thank you very much.
I didn't know if that was something you could do on the fly, so I didn't know if maybe there was a reason.
The judge has told them many times. He's like, I'm going to expect you to have these ready, and the attorney, I forget his name, David, the attorney that's been working on them is like, yeah, we'll have them. I'm working on them. There's just a couple finishing touches I'm putting on. Well, apparently one of the finishing touches was not proofreading. So
she was leaving brackets. That's going to be. We need a bracket emoji, please.
We got. Well, I think you can get just brackets, but we put the brackets in the picture here around the judge.
Oh, okay.
So
good.
So that's a start. All right. Thank you.
Right. Well, have a great rest of the day, everybody. Bye.
All right. See you. Bye. Appreciate Bree. Let's see. The recordation pagination. This is Adam Nusky. This is our picture. We're gonna retell the story. This picture tells the story of the case, or gives us cues that remind us of key bits of evidence or things that have happened in the case. It's beginning to look a lot like an I Spy book or possibly a Where's Waldo, but it's I don't know. It's been a crazy case. You need to flip the bracket on the left. You want like an open bracket and a closed bracket? Hang on, let me zoom in here. So you want this bracket to be an open by just flipping it around like that way. Let's do it like this. How about there? All right, it's flipped. It's flipped. I'm not sure, guys. I'm not sure. Hey, Amber, how are you doing this morning? All right, how am I doing? I guess. Let me ask that. How am I doing? Are you calling to correct me?
Still a little salty about yesterday.
Still, it's too soon. Is what I'm going to say. Too soon. So go gentle on me.
I'm just saying, you've just got a lot of OCD people in the chat, and I'm one of them. So you can't just have random brackets just thrown in places.
Well, now it looks like the truck's in brackets, and I wanted them to look like they were being thrown out here and there, but I can see that it threw off the feng shui, which to this point has existed perfectly in the image.
No feng shui. There's no feng shui in this graphic.
It's terrible, I know, but I love it. It's become a piece of this, and it helps me. Honestly, I can't stress this enough. I don't know if I'm like losing my memory or early onset of Alzheimer's. I'm not sure what it is, but at the end of the day, I could stop live streaming, hit the button to stop, turn off the computer, walk away, and go and talk to my neighbor, and my neighbor could say, "What's the case you're following right now? What's it about?" And I look at them for a minute, and I blink, and I'm like, I should be able to remember this. I should be able to, but doing this every day, with putting different things in, has helped me remember the details of the case. So maybe I'm just a visual learner, or maybe one day I'll wake up and I'm like, who are you guys, and why are you in my studio? I don't know, but
I see. So you doing these creative thumbnails as we follow a case is more of
it's therapeutic,
helping yourself it's helping yourself with self-marketing when you're talking to people.
It's nearly medicinal. I mean, it's really helping with my weaknesses. That's why. But, Amber, thank you very much.
I have a suggestion.
Yeah, go ahead.
Of course, you're not rushing me off the phone.
I was trying.
Because you don't want me to tell you you're wrong about something. So with these graphics, I know we are potentially going to be doing them for each trial. I think we should start some merch with our thumbnails that we've put together.
So you could like collect items for each trial you've watched?
Right. Or have the T-shirt of, to commemorate your favorite case, or whatever the case may be. There's been a lot of chatter in the chat about putting it on a T-shirt. So I think we need to...
I'll say this. I've always wanted this channel to be more about content than like profitability, to maximize profitability for me. I believe that if I provide great content and good information and a fun place for you to come, you'll come back. And I've never wanted to have like a ton of merchandise, and so I haven't been very good at putting merchandise out there. I've got a lot of requests, but I just haven't done it. But I can see why how this is beneficial to me, and if that's beneficial to somebody else, I can see that. Sort of like trading cards. I don't think it would be a big. I don't think that would go on a T-shirt. Like I don't see that, but maybe something smaller.
Or coffee mugs. Lots of people are saying coffee mugs. So the idea that kind of went through my head is, myself and some of the other mods have something up our sleeve that you don't know about, but we'll know about within time.
This is how the channel goes, guys. The mods run everything. The mods run everything. Okay.
So this would be super awesome to kind of tell the story of the life of the channel. Somebody also mentioned a scrapbook idea.
I'm
so at the
terrible
end
at all
of the
these
year,
things.
we can do... Well, but you have help. You have mods for a reason.
I don't know how to use them, though. They just do stuff, and I say, thank you. I couldn't do it without you. All right.
They make you do stuff and tell you you're wrong.
At the end of the year, we can put together a coffee table book. I will tell you, I appreciate you guys working with me on this. Sorry, Tracy, that image looks terrible to read. This isn't much better. Is that? Yeah, my arm behind it makes it a little bit better. At the end of the year, we can put together a coffee table book. This is. We are professionals.
Sometimes.
But I'll think about it. I think something small.
Or even a mouse pad.
Yeah. I'll say this. Donate profits to the victims. I cannot begin to tell you the legal taxation nightmare it opens up as soon as we start looking at doing something to donate for somebody and I'm collecting it. I am all for donating and helping people who had a poor deal in life and got something happen. But if I'm the guy in the middle, I have to be, unless I set up a huge 501c3 formation of a company and huge, and the accounts and everything that goes with it, I'm basically taxed on everything that comes in and it becomes a nightmare. And honestly, it takes away from what goes to the cause. And so I want to stay as far away from any situation where people are donating something to me to give to someone else. Because of that, because at the end of the day, if I do it legally and follow the tax code, that what they get is less than what I was given, and that just doesn't sit right with me, even though I have to pay taxes and stuff. So
I agree.
So yeah, I've learned my lesson the hard way.
It would be awesome since we've kind of collaborated on the thumbnail as a channel. It's a channel created product.
Yeah, I do need some help.
Not just an RA created product.
I do need some help designing some merchandise. I owe you guys. I've done one coffee mug since the very beginning. I have not done anything since, but I need some help doing that. So we'll work on that. Amber, I've got to let you go. I think we're coming back to court right now. So we'll catch you later.
Fine.
All right. See ya.
All right.
Okay, we're all back.
Wow.
Of course.
Wow, Lauren.
Judge Jones, can I ask a quick question? Do you have the working copy that we had given Your Honor for jury instructions? I might refer to them during my closing, and if I could just use that hard copy, I don't care. I know it's a work in progress, but what I'm going to refer to is not going to change.
Okay, it's fine. I took out what we said we weren't going to be using, but I think I've kept them in order.
Your Honor, I also had a quick question, if you wouldn't mind.
I don't mind.
Actually, I got contacted by pretrial about a drug alcohol test for tomorrow. I don't know. Again, it seems kind of we're in closing arguments. I don't know whether I should be going to that or not.
Who is hearing Judge Manning in their head right now? Pre-trial.
Don't worry about it.
Okay,
I will.
Judge said it here. Don't worry about it.
Contact pretrial, and it seems to me, and frankly, I basically had said earlier when I don't know if I spoke to Todd or Scott that you had enough going on during the trial, and I was going to be in your presence quite frequently. That we didn't need to be doing that because, frankly, I just wanted to compound your stress, your schedule, whatever. So
thank you.
I will contact or have my office contact them. So obviously you can put the podium where you'd like to. Once we start, you can too. So the plan would be to go through the closings, break for lunch, do this. All right. So let's bring in the jurors.
That's part of the terms of the of him being out on bond. Was that the prosecutor or the judge that just did the horse? I can't even do it. I just spit. That's what he did. It's like a Zerber. I think it was the judge.
Please.
All jurors present in the courtroom, Your Honor.
Okay, please be seated, everyone. Good morning, ladies, gentlemen of the jury. Nice to see you all this morning. We're here on the case of State of Florida versus Franklin Tyrone Tucker. And as I mentioned to you at the close yesterday, we had some matters that we needed to tend to yesterday afternoon and this morning, and we've done that now. So we're ready for your listening ears and attentive minds. Members of the jury, both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments that are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. So, State, would you like to present a closing argument?
Thank you, Judge.
Let's see how they come in. If they
Ladies and gentlemen, good morning, everyone.
yell and scream and swing for the fences.
First, let me start by saying thank you for your patience and your time the last couple of weeks. Feels like a lot longer than that. And for your attention to the case that we presented to you, the case of State of Florida versus Tyrone Tucker. Now, in just a few hours, it's going to be your turn to take all this information back to the deliberation room and start your deliberation in this case. You're going to have to determine what you found to be credible and what you found to be not credible. And you will be the ultimate deciders of what evidence you believe and what evidence you don't believe. Now, I hear this a lot in this courtroom. In life, they say the devil is in the detail. And I think no case embodies that more than the case we just presented to you, because the devil really is in the detail in this case. I submit to you that the most credible evidence that you received was the testimony of John Travis Johnson. That is going to be the most credible evidence that you received in this case. And I believe you will come to that determination because of the detail that is involved in that testimony.
Not the police testimony, not anything else. It was the.
Now,
was the
you got a
informant.
chance to meet John Travis Johnson. He came in this courtroom and you met him. He's a pretty simple guy. He's not overly sophisticated. He's obviously struggled since he got out of the military. He's got PTSD issues. He's got some addiction issues. He owned up to all of that. He didn't hide any of that from you. The reason he was in Key West back in 2017, he came here looking for work after the hurricane, and he fell into his old ways. Right? He said he met up with some old friends that he used to know out on the beach, started doing drugs with them, started drinking, fell back into his old routine. Finds himself living at this warehouse where he makes the acquaintance of this man over here, Tyrone Tucker, and another man, Rory Wilson. And the three of them party together. They party together. And what does that partying involve? Alcohol and drugs. And like all parties, the party ends at some point. They run out of alcohol, they run out of drugs, and they run out of money. So he tells you it's time to figure out a way to get more. So what does he do? What do they do? The three of them get together. Travis told you that Wilson came back from, I believe it was the Burger King, and said, hey, I got some information about this lady over at the Treehouse. She's got drugs, she's got money. We need to do a lick. Let's go over there and hit that. John Travis Johnson said to you, he wanted more drugs. He didn't really want to be involved, but he wanted more drugs. Now, he's got the truck. They need a ride over there. So it makes sense. It's his truck. He's determined to be the one that's going to drive them over there.
Could throw a rock and get there.
What's he getting out of the deal? Gas money, and he gets to smoke the take. Who are the other two players in this scenario? Tucker and Wilson. That's what he told you. That makes sense. Now, they get together. He said, he testified, he didn't know anything about the legal theory of principal theory. You're going to get that instruction that I talked about during jury selection. The principal instruction is going to tell you that it's kind of an all for one, one for all scenario. I'll specifically read the instruction a little bit later here, but I want to stay with John Travis Johnson's testimony first. He said he knew nothing about the principal theory, and he knew nothing about this felony murder theory. So, you mean while we're committing a robbery, if somebody ends up getting killed, I could be charged with murder? Yes, sir. It's called felony murder. And that's exactly what happened in this scenario. The three of them hatched this plan to go over to the Treehouse. He gives you great detail about how the plan was hatched. They did a drive-by earlier just to kind of case the joint out. And remember, I told you I told you during jury selection, if a crime's committed at the Basilica, you're going to have nuns and priests for your witnesses, right? Well, the Treehouse is no Basilica, all right? The Treehouse was a flop house, a drug den in the middle of Stock Island, where people were living in a ramshackle structure with no water, no electricity. And what did they do in that place? Drugs, alcohol. Paula Belmont said prostitution. Who knows? It's not the Basilica. So they get this great lead, right? They're going to go over there and do this robbery. So they case the joint. He drives them over there. Or after they get done with the casing, they go back to the warehouse. Tucker puts on dark clothing. Wilson puts on dark clothing. Travis drives them back over. Why should you believe that? It's corroborated. Corroboration is important in this case. That's the detail I'm talking about. Devil in the detail, corroboration. His story, his testimony is evidence. That evidence is corroborated. So he goes over to the Treehouse. We saw those videos time and time and time again. You see a flash of the truck first. That's 8 minutes later, I think, 9 minutes later, you see the truck pull up. I'm sorry, I misspoke that. The first drive-by, we didn't see. When they go over there to commit the actual crime, they said there was a car out in front of the Treehouse. And you see the truck pull all the way through, and it goes around the block. Truck pulls back up, and you see two guys wearing dark clothing heading from the truck towards the Treehouse. Corroboration of what Travis testified to. It corroborates him. Now, Travis is not a manipulative person. I submit to you the manipulative person's this guy over here. That's the master manipulator, not Travis. You saw Travis. He's about as simple as it gets. Travis said he was in the front seat. He saw them go in that gate. A few minutes later, he sees somebody running from the gate. What do we see on the video? Corroboration. Sure enough, we see a man with a flashlight come running out of the gate, up over the hill to CVS. It's exactly what Travis said. After that, we see a guy in dark clothing come running from the direction of the Treehouse towards the direction where the truck had dropped him off. Consistent with what Travis said happened that night, that he saw Tucker coming out of the Treehouse with this bag in his hand, fumbling with it, right? And he sees him running, and he takes off because he's terrified at this point. Now, Travis says he sees Tucker fumbling with the bag. Who does Roger Ragged say grabbed the bag out of the Treehouse? The second person. Who does Paula Belmont say grabbed the bag, her purse, her bag, whatever? The second person. That's consistent with what Travis told you. Travis also said that when Captain Phelps kind of figured it out, he knew the jig was up and it was time to pay the piper. And he said when he saw that, he was shocked. When she laid it out, he was shocked because she had it to a T.
So she told him
She
first.
didn't tell him what to say. She laid out the basics of what the investigation had revealed.
Basics.
But Travis filled in all the details about
the details only he would know.
Particulars in this plan. Devil in the detail. So, Travis owns up to it. Time to face the music. And he gives his statement back in November of 2017, and he's arrested. And that statement has remained unimpeached to this day. He gave a proffer in 2022. He didn't get a deal until 2022, after he'd been in jail for 4.5 years. That's when the state approached him. Again, we don't pick our witnesses, right? The Basilica, one thing. Treehouse, another. The state approached him and said, we need your testimony. We believe if you're the getaway driver, you're the least culpable. So we'll work with you. And he
says,
agreed.
that sounds good to me. That sounds great.
And he came in here and he testified today consistently with every other time he testified. Consistently. That's why he should be believed, because he's credible. Now, because it's important that you understand the nature of his testimony, and because I submit to you the abiding belief in his testimony, we've got a PowerPoint here that we put together to kind of highlight why you should believe Travis Johnson.
Your Honor, Jordan, I'm sorry, would you mind if I got a little...
No, you can reposition yourself so you're able to view the screen.
Thank you.
Thank you, Vanessa.
I think it would be preferable if he had a seat there. Well, I think it would be preferable if we can, one of the deputies can help.
What's the rule? How many bullet points should you have on a single page of a PowerPoint?
Person making the argument being
Pretty sure
the
it's
only
in the
one
single
standing,
digits.
So,
1, 2, 3, 4, 5, 6, 7, 8, 9. I think we've got at least 10, maybe 11.
Now, ladies
12
and gentlemen,
there.
I did you all a favor. I brought somebody much smarter about these things that was born in a different generation. She will run the computer for me and I will refer to it, okay? So let's talk about Travis's testimony in regards to the sequence of events at the Treehouse. Travis says he drove by once, returned, and he parked past the Treehouse, and Wilson and Tucker got out and walked towards the Treehouse. We see that on the video, the Cosme video. Travis says he saw Wilson and Tucker go through the gate of the Treehouse. I'm sorry, I lost my way. About 5 minutes later, a man
lied to. He's like,
that we learned was O'Quinn ran from the Treehouse towards CVS carrying a flashlight. That man yelled for police. Tucker ran towards Travis's truck, but Travis drove off. Travis said he did not see Rory running towards his truck. What corroborates that testimony? The Cosme video corroborates it. Detective Fernandez, who you heard from, testified he saw a truck in the video. Detective Malone, who testified, said or gave a detailed description of the events that were observed in the Cosme video. She was able to point out the man running towards CVS with the flashlight. And we also see the man running from the Treehouse, who is Franklin Tucker. Now, later on we see, I think they use the word lumbering, because Wilson was described as somebody who would not be capable of running fast because he's a stocky guy. There was about a minute delay before the second person appeared in the If Travis really wanted to tailor his testimony, he had to switch that around. But he's been adamant that's not what it was. It was this defendant that had a knife in his hand, and Wilson had the club. Well, we know Wilson's DNA ends up on the knife. It was a full-on fracas inside that Treehouse. Fists are flying. There's chaos. Roger Raggett told you they were all over the place. Somebody threw him into a tarp. Somebody had him up against a wall or a floor or something. Paula had a guy on top of her. Weapons could have been easily switched around. And those are the only weapons that Travis saw. We don't know if there are other weapons in their pockets. But as far as Travis's testimony towards the sequence of events, it's corroborated by the evidence. Let's go to the next one. The map of the route that they took. Travis testified detailed the route taken for the drive-by and for the robbery. You see the video of Travis's confession. He draws the map during his interview with Detective Pitcher and Phelps. Phelps traced the route along the map that was in the wrong direction. Travis corrects her, and he says no. And Travis showed the correct direction on the map. And remember, Travis's interview was before they showed him the videos from Cosme and the Electric Company. This testimony came before he saw those videos. So he wasn't tailoring his testimony to the videos, hadn't seen them yet. Vanessa, could you play the next one? Here's the portion of his interview where he addresses the map.
Right there, the curb stops. Okay. So each time you come into this loop, it's come straight down 7th Street. Okay.
No, we came that way. He corrects her. He's not tailoring it to something he hasn't seen yet. Vanessa, let's go to the next one, please. As far as Travis's testimony about Rory wearing the black shorts and the black long sleeve shirt, in Paula's video deposition, 2 different times she describes the person attacking her. And this is the video that you all saw, the perpetuated testimony you saw this week. Yes, he was wearing the same. He was wearing like a dark blue sweatshirt, shorts, and these like shoe boot, black shoe boot things. They were like boot material, but not as high as boots. They were shoes, if that makes sense. Dark blue or black sweatshirt, shorts, and the black shoe things, and a mask, which I didn't realize at first he had a mask on because he jumped right on top of me. Next one. Travis testifies that Rory went into the treehouse to commit the robbery. We see the 2 guys walking from the truck towards the treehouse, and Travis says he saw them entering the gate. Paula identifies, to corroborate that, you can look to Paula's testimony. She identifies Rory back in 2017 as the person attacking her, and she says it again in her deposition testimony. How do you know that was the person? I knew who it was immediately just by who he was. I mean, the voice, after hearing the voice, there was no doubt in my mind. He was wearing the same clothes and being at the house earlier. That corroborates Travis's testimony. Travis testifies about Tucker wearing long black pants, black shirt, and black boots. That's what he says Tucker was wearing. Let's look to Paula's video deposition. So did you tell the police that you thought the person might be black because the person was wearing black clothing? Wearing all black, yeah. I guess I just associated, I don't know, I guess I originally thought it was a black guy because he was wearing all black and was told it was a white guy. Ma'am, the person was dressed in all black. That's Paula's testimony, which corroborates Travis's. Tucker was wearing all black. That's what Paula identifies the second person as wearing, all black. Next one. Still talking about Travis's testimony about Tucker wearing long black pants, the black shirt, and the black boots. Travis's video confession, he was wearing a pair of black pants and a black shirt and one of those, I guess it's called a neck gaiter, one of those hoodie things. Who was wearing the neck gaiter? Tyrone. I guess it's called a neck gaiter, one of those hoodie things. Next one. All right. We know, neck gaiter was never found. We know that. It was not presented to you. But we also saw a booking photo of this defendant. And a regular mask coming down over your head is not going to cover that long goatee. But a neck gaiter would. Devil's in the detail. Why believe Travis? It makes sense. You pull a neck gaiter up, you cover that big goatee. That's why you believe Travis. It makes sense. It's corroborated. Travis testifies about the black hoodie. He testifies Tucker put on a black neck gaiter around his neck when he got ready to go to the treehouse. In Travis's video, again, I guess it's called a neck gaiter, one of those hoodie things. That's corroborated by Paula. Paula says, all I saw was the back of that person. He was a little smaller. He was a littler, smaller, like not as wide, wearing a black hoodie. I just saw the back of them. They had a dark hoodie on. A dark hoodie and all over sweatshirt, hoodie, and dark pants.
Paul
She's
is not
describing
saying
Tucker to a T exactly the same way Travis described him. Corroboration. Corroboration. Next one. More about the neck gaiter that Travis testified to and how it covers Tucker's goatee. Tucker had a black neck gaiter around his neck when he left the warehouse. The word Jägermeister was written all over it. And then Travis showed you how the neck gaiter could be pulled up to hide his neck and face. Again, like I just said, Tucker had this long goatee in 2017. Vanessa, let's play that video. Just right there is fine.
He put on a pair of black pants and a black shirt. One of those, I guess it's called a neck gaiter. One of those, hoodie things. Who had the neck gaiter? On top of Tyrone, okay. Because he's got a beard this small. Okay.
He described him to a T. He's got a beard this long. You saw the beard. Neck gaiter covers it up. And this was all done. They didn't tell Travis anything about a Jägermeister neck gaiter. Phelps didn't say anything about that. Those were details that Travis provided to them. They didn't give him his narrative. He gave them his narrative. Tucker's before Travis described them. Next one, Beth, please. All right, here's Travis's testimony about the mask. This is the mask that Wilson had on, the demon mask. Most evil, most horrible demon mask you can basically describe. It's the mask that Wilson was wearing when he came out of the warehouse. Detective Malone testified the mask was found in a boat near the Treehouse. Roger Raggett testified the two men were wearing skull masks. Roger Raggett says they had some kind of masks on. It corroborates what Travis was saying. It corroborates what Paula was saying. Vanessa, let's play that video.
Look, both of them said the, which means that they agree with each other.
I think he had to just look like a, what do you call it, beanie, hoodie thingy.
Beanie, hoodie thingy.
A freaking mask. What the mask look like? A demon. Okay. Like when you say demon, I see you say, tell me what you're trying to learn. That's sharp teeth. Okay. Almost like a dinosaur-ish type. Okay. Looking thing.
He said, it looks like a demon with sharp teeth. Y'all remember this mask, right? Teeth don't get much sharper than they are in this mask. Why believe Travis? The evidence corroborates what he said. He described a demon mask with sharp teeth. Nobody gave him that description.
He's got something on his hand. He's wiping it off now.
Nope, those are details that Travis gave. I'm sorry, ladies, thank you. Those are details that Travis gave to them. Those are not details they gave to Travis. The defendant wanted to say that they gave Travis his narrative. No, they didn't. Travis gave his own narrative. Travis gave details on a mask, and it's 100% identical to the mask he identified here in court. Thank you. Next one. Travis testified about the knife that he saw in Tucker's hands. He says Tucker had a knife in his hand. I could see it in his hand. He was carrying it when he came out of the warehouse. When he came out of the warehouse getting ready to go over to the Treehouse for the hit. What corroborates that testimony? We found a knife in a planter box in the yard of a neighbor on November 18th, the day after the murder. This person lived at the Water's Edge Trailer Park. That's where they testified they found, DeValier testified that's where they found the mask. Water's Edge Trailer Park on 2nd Street, the direct route from the Treehouse to the warehouse. So they found the knife on the direct route from the Treehouse to the warehouse, the knife that Travis described to a T in court and to the detectives. DeValier identified the photographs of the knife while he was on the stand. That corroborates Travis's testimony. He saw Tucker with a red and black knife with two edges. That's the knife that was found on the path back to the warehouse. Next one. Still talking about the knife, he gave them details of the knife. Vanessa, let's play that video, please.
Now, when they got their stuff, when you said they got their stuff, what did they bring to the trunk to go do the report? What did they bring? He got his mask and their clothes and the gloves. Okay. And I think Kai had a razor knife or not a razor knife, but a diet knife. But just like the kind you strap to your leg? Yeah. Okay. Was it in a sheet or just a knife by itself? It was in a sheet. Okay. What color was the sheet? Black. What about, was it blue, green, yellow, pink? Red. All red? With black hand. Could you like the handle? The blade was red and the handle was black? The blade was silver. Okay. And then the handle was black and red?
Blade was stainless steel, handle was black and red. He also has a knife collection. He wasn't hiding that from anybody.
Anything else about that you can think of? Anything else about you can think of? It's got the black and then handle. Is it there was a certain red, there's still more areas that locked it in. Was it anything else on the inside or the center? Any Travis sheet with a strap on or straps on the leg? It didn't have straps. Okay, just a plastic, like a hard plastic sheet thing. Okay.
You see, you remember that steel
Corroborates
ball
Travis's
bearings that
testimony.
locks it in?
And lo and behold, how did Matthew Bonnet die? Stab wounds to his back. What blood was on the knife? The confirmatory blood was Wilson. But the defendant's DNA could neither be included or excluded. And you heard the DNA analyst. Just because she can't say it's included or excluded doesn't mean he didn't touch the knife. I think when David held up a pen, does this automatically mean my DNA is on the pen? No, it doesn't automatically mean that. It could. What she said was if there's not enough DNA in the profile for the test, then she can't make a conclusive finding one way or the other.
This is so bad.
So she never said his DNA wasn't on the knife. She said it was inconclusive. But she was able to conclude Wilson's DNA was on the knife. That knife very easily could have been passed around. For all we know, Tucker stabbed Bonnet and Wilson picked the knife up afterwards. Or the other way around, we don't know. And you know what? Under the principal theory and under felony murder, Wilson. It doesn't matter. It doesn't matter who wielded the knife in there. We don't have to prove who wielded the knife. Because under principal theory, you're all in it together. Travis is just as guilty of that stabbing sitting in that truck outside. Folks, the principal theory, I always liken it to if 5 guys stomp a person to death. You don't have to prove which stomp actually killed the person. You're all 5 in it, you're all 5 doing it, the person died. Okay? Here, they're all engaged in the commission of this crime. That they all had the intention that crime be committed. We don't have to prove to you who actually stabbed Matthew Bonnet. What we did have to prove to you is that Matthew Bonnet did get stabbed during this altercation and that those stab wounds caused his death. And I submit to you, we have proven that. But as far as who did the stabbing on the inside, we don't have to prove beyond a reasonable doubt who did it because we don't know. Roger Raggett doesn't know, Paula Belmont doesn't know, and Matthew Bonnet's not here to tell us. Next slide, please. Oh, before we leave that one, Dr. Steckbauer confirmed that it was stab wounds to the back. I think that's pretty much all we need to go from that one. That's fine, Vanessa. We can go to the next one. Thank you. Travis testified about Tucker and Wilson going through the gate of the treehouse. He saw them go in. Paula testified 2 people came up the stairs of the treehouse. Roger testified 2 people came upstairs. Roger testified the second guy was taller and skinnier than the guy attacking Paula. The guy attacking Paula, I think she referred to him at one point in time as a 250-pound gorilla, is what she said. And she said she couldn't see much other than that because he was on top of her. It corroborates Travis's testimony. Next one. Wilson was upstairs in the treehouse. How do we know Wilson made it upstairs? Travis saw Tucker and Wilson go into the treehouse. Paula testified the 2 people came up. Roger testified 2 people came up. Paula testified she knew the first guy. She knew him the minute he came up there. He knew him as Detroit. He'd been around the treehouse before. Had a very distinctive voice. Roger said he was familiar with the guy attacking Paula because of his sways. I believe what he was trying to say was swagger. Because of his swagger. He knew the guy's style, walk, the way he moved and talked. He didn't know the guy's name, but he'd just seen him around the treehouse and other places. That corroborates the fact that Wilson was upstairs in the treehouse, which is what Travis said. He saw him go in the gate. Next page, Vanessa. How do we know Tucker was upstairs in the treehouse? Again, Travis saw Tucker go through the gate with Wilson heading into the treehouse. During the recross of Roger Raggett, the defendant raised his hand way above his head and said, now this guy that was attacking you, would you tell me how tall he is? And Roger Raggett, who I submit to you, you're not going to get that guy to say anything that he doesn't believe in. He said, no, not that high. Bring it down, bring it down. Your height. About your height is what he said. About your height.
Which would be
and when I got up
people?
and asked him, did you say the second subject was Tucker's height? Yeah, I just said that.
Isn't that the same height as Travis?
It corroborates what Travis said. The 2 went in that gate and into the treehouse. Roger Raggett corroborates that testimony. Next one. Oh, we're there. Sorry for that. You're anticipating. The snuff can. Travis testified that when they were all back at the warehouse, Wilson took a snuff can out. It was round, like a Copenhagen snuff jar or can, whatever you want to call it. Took it out of his pocket. And he did this upstairs while they were at the warehouse. What corroborates that? Roger Raggett said the man kept telling Paula, give it up, give me the money and drugs. And Roger told Paula, just give it up, it's not worth getting poked over, was what he testified to. And according to Roger, Paula said, take it. And she pointed to a little container on a little container, and the guy took it. A little container. Consistent with what Travis says Wilson produced back at the warehouse. Devil's in the detail. Travis is telling you the truth. Next page. The backpack belonged to Paula. Travis said he saw Tucker running out of the treehouse, fumbling with this backpack, and stuff was spilling out all over the place. He also testified that Tucker showed up at the warehouse with the backpack and emptied the contents out to see what they got. What corroborates that? Well, Detective Malone testified the backpack was found in an air handler closet up in Big Pine, and it had Paula's EBT card in it. She also said the other items in the backpack were hers. They were like women's items, notepads, or something else.
Whose house was it found in?
Why was it up there with Travis? Travis told you. He was unpacking the Foot Locker that this defendant helped unpack when he was leaving the warehouse. Did that Foot Locker ever leave your sight? Yeah, it did. It was never in my exclusive control. How'd you get it out of the warehouse? Tucker helped me. You think Travis is sophisticated enough to make that detail up? Tucker helped me. He gets up to Big Pine. What does he find in the Foot Locker? The backpack. So what does he do? He throws in the closet. Out of sight, out of mind. Next one. Contents of the backpack we covered. Travis testified. Women's stuff, feminine effects, pens, notepads, trinkets, stuff to a female. Paula's video, she says, my keys, my jewelry, my perfume, a little pink purse, all women's things that had little witches on it. Detective DeValle testified he found a $100 bill, change, personal items like makeup, items that appeared to be from a woman's purse scattered on the ground outside of the treehouse. That's consistent with what Travis says. I saw him fumbling with the bag and stuff was emptying out of it. What does Detective DeValle find? Women's things that are consistent with what Travis just told you. Why believe Travis? The evidence supports his testimony. It's consistent. Next one. Travis said, I saw Tucker running down the street fumbling with this bag. Paula corroborates that. All I saw that second person doing was I saw him like this through the side of my body because I had someone on top of me. He was grabbing my backpack, opening up my backpack, consistent with what Travis said Tucker was doing when he came out of the treehouse. It supports Travis's testimony. Why believe it? It's corroborated. I'm sorry, that's the next one. Still talking about Travis's testimony about Tucker running down the street. Paula's video deposition, which you saw. You did. It was your backpack. Is that correct? Yes. And who took it from you? The other person, not Rory. She'd identified Rory as the one on top of her. No, ma'am. It was the white guy. I can't say it was a white guy. I originally thought it was a black guy because he was wearing all black. And I was told it was a white guy. I don't know who took it. I know it wasn't Rory Wilson. Consistent with Travis seeing that Tucker coming out of the treehouse fumbling with the bag. Yes, ma'am. Next one. Paula also says, I saw the second man with my backpack and I saw him with the billy club, but I couldn't see Roger because Detroit was blocking my view. And at this point, I remember Paula kept describing this long item. It looks like now she sees a billy club with the man that's with Roger. Roger testified that man had a knife to his throat. We certainly know that
talked for
something
35
was to his
minutes
throat.
so far.
Now, could have been both, could have been one or the other. Doesn't matter. Next one.
He has an hour remaining.
Travis testified that the $50 they gave him for the gas money smelled like perfume. That's completely consistent with what Paula said. Travis said it smells like perfume. Paula said, I think I had a brand new bottle of Dare perfume and some other items. And lo and behold, the money that nobody fed Travis that detail. Travis coughed that detail up his narrative. It wasn't Penny Phelps's narrative. Don't be misled by that. It is Travis gave the details. Penny Phelps laid out the basics of what the investigation showed, but Travis filled in these blanks. Next one, please.
How were the bills? 20s, 10s, 5s, 23 5s, and 5s, okay. And they smelled like perfume, I remember that. The one smelled like perfume.
Okay, next one. Travis says Tucker was upset with him. That makes sense. Of course he's upset with him. Came running out of the treehouse looking for the getaway car, and the getaway car took off. That shouldn't be hard to understand. Travis gets back to the warehouse. Tucker's mad at him. Travis says, I went for a walk to get cigarettes, just take a break, walk away from that. You saw the Florida Keys Electric video. You see Travis walking along by himself, and then he comes back after he said he'd run into Rory Wilson. He comes back walking with somebody else. And he says, I ran into Rory Wilson when I went to buy those cigarettes. And that's consistent with what we see in the video. We see him walking to the CVS on his own, or the Tom Thumb, I'm not sure which one they were going to, on his own to get cigarettes. He comes back with somebody walking next to him. And remember, Travis gave this statement before he saw those videos. So he's not tailoring his statement to the videos. He gave that statement before they showed him the videos. When he saw the videos, remember, he said he was shocked that they had him on video. Again, why believe Travis? Devil in the detail. Next one, Vanessa, please. He confessed in November of 2017. He had no deal on the table, no promise, no anything. He's been consistent ever since. You saw the video of his confession. He testified here in court. Once he decided to fess up, remember when he said the jig was over? He gave the details on the plan and the execution and the aftermath of that murder in 2017. After that, he said they asked him to look at videos. And yeah, he said when he saw the videos, he initially identified himself and he kind of vacillated because he was scared. He thought, God, they have video of me too. He was shocked to see that. I submit to you that's sincere. That is believable testimony from Travis. Next one.
If he was shocked, he probably saw himself walking.
Travis testified he did not know about this treehouse until the incident. He didn't even know where the treehouse was, and he'd never been there. All right? What corroborates that? Well, Paula actually corroborates that. In Paula's video deposition, she's asked, and you saw this. This is the perpetuated testimony. You saw this yesterday. Do you know Travis Johnson? No, not personally, no. Prior to the date of this incident, you never hung out with him? No. Associated with him? No. I don't know. Oh, have you ever even met John Johnson? I don't know how to answer that because he might have been the person that was there with Detroit, but I don't know for sure. Other than that, the only time I ever saw him was in the newspaper and, you know, here. Have you ever identified him? No, sir. As that person? No. Next page. Have you ever seen John Travis Johnson with Matthew Bonnet? No, sir. Have you ever seen him with Crystal? No. Have you ever seen him with Roosevelt? No. Have you ever seen him with O'Quinn? No. Have you ever seen him hanging out with any of your friends? No. Have you ever personally seen him at the Treehouse? No. It corroborates Travis when he says, I didn't even know where it was. I've never been there before. Paul is basically saying, I don't know who he is. He's never been over there. It corroborates Travis's testimony. Next one. Okay, now let's go to the next one. Paula's all over the place. Some of her testimony, she seems to get right. She starts in 2017, and you saw the hospital video yesterday. When she was at the hospital the night of the attack, and she's adamant. I can't identify that second person. At one point, I think she gets upset with Officer Malone, and she says, lady, I told you this 3 times. I can't ID him. I had a 250-pound gorilla on top of me beating the shit out of me. That was what she said. She couldn't say anything about the second guy. Now, this is interesting. Paula testified that in the very few days right after the incident, they were at McDonald's on November 22nd. It's about, 4 or 5 days after this incident. And the defendant testified to this yesterday. I saw Paula at McDonald's. We weren't friends, but we knew each other. I was feeling so bad and so sorry for myself for being interrogated for this thing all night. And he's scared, and he's feeling sorry for himself, I guess. And I remember seeing Paula. This is his testimony. I remember seeing Paula, and she had a bandage on her neck from the knife, right? And I remember seeing her, and I was just like, all of a sudden, I felt like, well, I'm trying not to curse, but I felt really bad. Here I am feeling sorry for myself, and then I see her. That was his testimony. Next one, Vanessa. Paula's deposition back in May of 2019. This would be, what, about 2 years, almost 2 years after the event. Actually, he himself, Tucker, told me that when we were at McDonald's, he himself told me, oh, the police found a knife with blood on it, because I said, oh, good, it would be my blood. And he said, no, it's Matt's. That confirmatory test didn't come from FDLE until months, years later. So how did he know that was going to be Matt's blood on the knife?
I believe Tucker
he told
says
Paula
he was told that by the
4
police.
days after the event. He told me they found a knife, and I said, oh, good, that'll have my blood on it. And he said, no, not going to be your blood, it's going to be Matt's blood. If he was passed out from his Red Balls or atom bombs or fireballs back at the warehouse, how does he know about that?
Why?
How does he know Matt's blood's going to be on that knife? Because he was there. He knows where that knife went. It went into Matt's back. That's how he knows. He knows that knife is not the one that was used on Paula. He knows that knife is the one that was used on Matthew Bonnet. Remember, he brought the knife to that event. Travis saw the knife in his possession. So he confirms to Paula, no, that's going to be Matt's blood. And then she said, whether that was true or not, I don't know. He himself told me that while we were sitting at McDonald's, that the knife that the police found had Matt's blood. That's a quote from her answer. She said it at least twice. She was not mistaken about what she remembered him saying. And that's very telling. That's huge. Because nobody would have known. Even the detectives didn't know it was Matt Bonnet's blood on that knife at that point in time.
Objection?
I'll sustain the objection to the extent, remember folks, this is closing argument. Your decision and verdict is based upon the evidence in the law. And the counsel's giving a closing, which is not evidence. So with that, you can proceed.
Did I call that?
Folks, you heard the testimony from Angela, our DNA expert. That's when we got the confirmatory results of the blood on the knife. That was long after, 4 days after this was a year, at least several months after the event. Tucker's telling Paula 4 days after the event whose blood is on the knife. Nobody knows that, sir, except the people that were there.
He should not be addressing that to him.
Okay. Nobody would know that except the people that were there, and that's huge. Now, the defendant took the stand and he's been wrongly charged with this. That was his story. If you boil down his whole testimony, he started partying during Fantasy Fest and the party never ended. He said this is usually what he does this time of year, and on the day of this, he remembers drinking these fireballs and got so hammered he fell asleep, woke up, police were everywhere. He remembers details that are, for somebody that was that drunk, he remembers the details of coming down the steps with his hands up, back when they committed the raid. He remembers bits and pieces of conversations, but for the most part, he was watching his friend's room, drinking, and passed out. He remembers going to buy cigarettes. He throws that in there. He said he remembered feeling so bad for Paula at McDonald's. Didn't testify that he told her whose blood was on the knife. Again, how would he know that? Why did we put on the DNA analyst? Why did we put? Because we wanted you to know we did our jobs. We did our investigation. We submitted items for DNA testing. Sometimes you get results, sometimes you don't. On this particular submission, we got a positive result for Wilson on the knife, and we got a slew of unconfirmed, can either say yes or no as a result, as it regards Tucker.
There were mixtures with Wilson and the defendant, Matt.
45 minutes.
45 minutes in, Judge?
Yes.
Very well.
Means he's used half of it up.
Now, a couple of excerpts I want to underscore from late yesterday. And again, I got a good time slot today, fresh in the morning. Yesterday afternoon, I got up here and I read into the record statements that Paula had made during her deposition in May of 2019. And I want to do that timeline for you. So the event happened in November of 2017. And she's adamant, can't see this other person, had this big guy on top of me, just couldn't see him, stop asking me that, I've answered this 5 times. Now we're in May of 2019. She's still saying she can't ID the second person. I can't ID him. Not that I can identify. I saw another person, but I can't identify him. Can you describe him? No, because I had Rory Wilson on top of me. You initially said you believe the second person had a billy club. I think that was Rory. Did you see the second person with any weapons? I don't know. I couldn't see the second person until they were going down the steps towards Matt because I had Rory Wilson on top of me. Do you remember what the second person was wearing? Dark clothing, corroborating what Travis said. You heard him say, I think we killed him. Now, she also talked about the McDonald's event. You recall seeing him at McDonald's? Did you know he had anything to do with it? No, ma'am, I did not, because I didn't know whether he had anything to do with it. I didn't even know that they all lived together. She didn't know about all that. Well, who told you he had something to do with it? Nobody told me. The police didn't tell you? Well, after they arrested him, yes. But not when I was having lunch at McDonald's, or I would have been nowhere near him. This was 4 days after. Are you sure he was involved? What kind of question is that? I told you I can't identify him. The person was wearing a mask. I can't say he had anything to do with it, and I can't identify him as being there one way or the other. Can't say he was there, can't say he wasn't there. And she goes on to say, actually, he himself told me at McDonald's that the police had found the knife with blood on it, and that's when he told me it was Matt's blood. He told me that while we were sitting at McDonald's. The knife that the police found had Matt's blood. Then there was a litany of questions about the scuffle between Roger and his assailant, which would be this defendant. Roger got thrown into a tarp. This is Paula's testimony. Remember what Roger testified to? I got thrown into some kind of a tarp. Paula says, I don't believe I said he was beating him. I was the one getting beaten. They had a scuffle, and you saw the second person holding a knife to Roger's throat? No, I didn't see that. You were told that? I was told that by Roger. That's why Roger wasn't helping me. Roger told her that the guy had a knife to his throat. These are all corroborating bits of evidence from Paula that corroborate Travis's statements. Again, the devil is in the detail. Now, Paula also makes a comment that at some point Paula testified that a small knife fell from somewhere during the struggle. She thought it was Roger's knife, and she thought about grabbing it. So there was a second knife. One was on Paula's neck, and she saw another knife fall, a smaller knife fall. She thought it was Roger's knife, and she thought about grabbing it. So Paula herself introduces a second knife into this fracas inside the treehouse. The defendant grilled Officer Malone about her demotion from major crimes. Her demotion was not a demotion per se. She stepped down. The recommendation was she stepped down because she didn't want to do that work anymore. This was 2 years later. There was no finding that the evidence in this case had been tampered with, altered, tailored, or fabricated. No evidence of that.
Objection. Okay, well, I'm going to overrule the objection. Again, this is argument, as I've explained. So.
No evidence of that. Malone testified she committed some policy violations, but that evidence itself had not been tampered, compromised, or manufactured, and there was no finding that it was. The DNA evidence, again, inconclusive for this defendant. Where was it inconclusive as for Tucker? On the blunt end of the knife, the right side of the forehead of the mask, inside wrist area of the shirt, and the black glove. Doesn't mean he didn't touch these items, just means they didn't have enough in the DNA profile to make that comparison. Mr. Tucker also called Travis a free man. You saw Travis. You saw him in the video. Travis is forever marked by what he got involved in here. He owns up to it. He'll wear it for the rest of his life. He's not a free man. He's a convicted felon. Convicted of pretty serious charges. These will follow him, and he knows that. You saw him in the video. He was crying, he was upset, he was struggling because the gravity of what he had gotten himself involved in was setting in. Why believe Travis? I submit to you, you believe him because he's being truthful. Paula, you saw her on the night of the event, November of 2017. You've heard statements from her depot in May of 19. At some point in there, she does a trip to California because she's posting pictures of it. And now, at the perpetuated testimony in September or November of 20, now she's adamantly saying in her cross, it's not Tucker, it's not Tucker, it's not Tucker. Not until September of 20 does that come out. What changed from the night of the event to May of 2019 to September of 20? We know she was friends with the defendant's wife on Facebook. She mentioned that. They were talking up to 20 times a day. Paula went from living homelessly in a flop house to a trip to California.
Okay, I'm going to overrule the objection.
Living in a flop house for homeless people with no water and no electric, to posting pictures of her trip to California. And then she appears for her perpetuated testimony and says it's not the defendant. It's not Tucker. Tucker wasn't the second guy. I can't say who it was, but it wasn't him. When she, at one point, told Officer Malone, I answered this question 5 times. I couldn't see him. I can't tell you. I can't even tell you if he was there or if he wasn't there. I didn't see enough of him. Now, new testimony. I submit you should take that testimony very cautiously, and you should reject it because it's simply not truthful. It has been tainted. Now, Law School 101, you're going to get a packet of jury instructions.
He said Law 101.
You're going to get a packet of jury instructions that's going to give you all the law that pertains to this case. You're going to hear that the defendant was charged with first-degree felony murder because during the commission of a robbery, somebody died. The state has to prove that somebody died. I think that's fairly clean. That came from Dr. Steckbauer. Matthew Bonnet is dead. While engaged in the commission of a robbery, Tucker caused the death of Matthew Reed Bonnet. And then it's either or for the next element. Tyrone Tucker was the person who actually killed Matthew Reed Bonnet, or Matthew Reed Bonnet was killed by a person other than Franklin Tucker, but both Franklin Tucker and the person who killed Matthew Reed Bonnet were principals in the commission of the robbery. Principals in the commission of the robbery. I submit to you this defendant has been proven guilty of felony murder. You're also going to get what the law calls, hard to explain, lesser included charges. Okay? Basically what that's telling you is if you don't feel that the evidence has proven the crime that's been charged, you could go down one level to what they call a lesser included crime. So for instance, on the first degree murder, a lesser included crime of first degree murder would be second degree murder. So if you don't feel that the state has proven felony first degree murder, you can consider second degree murder. For second degree murder? Hold up, it's a lot here. Second degree murder, the state has to prove that Matthew Bonnet is dead. The death was caused by the criminal act of Franklin Tyrone Tucker. and there was an unlawful killing of Matthew Reed Bonnet by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Just so you know, the principal instruction carries to every charge. The principal instruction carries to every charge, and I'm going to read the principal instruction, except these are smudged again. There we go. Let me read the principal instruction to you. This is the law the judge is going to advise you need to follow. If the defendant helped another person or persons attempt to commit a crime, the defendant commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did. If the state has proven beyond a reasonable doubt the following: number one, the defendant intended the crime to occur, and number two, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime.
You think you've done
that? To be a principal, the defendant does not have to be present when the crime is committed.
You think you've proved
those
points?
I would just ask if the defendant can return to the defense table. I'm not using any more video.
Okay, fair enough.
That principal instruction runs to every single crime. The defendant intended for the crime to occur. Did he intend for the robbery to occur? Of course he did. Of course he did. Did he act or say something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually attempt to commit the crime or to actually commit the crime? Sure he did. He got in the truck that day, loaded for bear, went over to the Treehouse, got out, went in with Wilson, committed the crime, active participant. He's a principal to everything that happens. So was Travis. Travis was a principal. To be a principal, the defendant does not even have to be present when the crime is committed. And I asked Travis, if you'd have known him, did you know anything about principal or felony murder? He said, no, I didn't. Would you have ever gotten involved in this? Never, if I'd have known that.
And you believed every word you told him?
It doesn't matter. I submit that he is, but his testimony is supported by the evidence.
He's gone 58 minutes now.
Judge, how much is on time?
59.
60 minutes, 59.
Okay. You know, this is a minor point, but in the Cosme videos, the defendant spent a lot of time going over the glare or the light in the front. If you watch the video, that glare never leaves that spot. That glare is coming from another location. If you watch the video, you can see the truck advance through that frame. When the truck advances through, there is a flash of light that I submit is the headlights of that truck. But the video speaks for itself, and you folks will be more than free to watch that video as many times as you would like. All the evidence will be going back with you to the jury room, so you'll have a chance to review everything.
That Tucker called him out, saying that reflection was the
Paula
headlights.
testified that a small knife fell from somewhere. She thought it was Roger's knife. So there was a second knife involved, one on her throat, and the other one she saw fall that she thought was Roger's. Only one knife was recovered, but there is talk of two knives being involved in that fracas at the Treehouse that resulted in Matthew Bonnet's stabbing. Folks, at this time, I submit to you that Travis Johnson has been proven to be credible over and over again. His testimony is corroborated by other testimony and by other videos and other pieces of evidence, the knife, the mask. Why should you believe him? Because he's corroborated. The devil is in the detail here.
And he had all the detail? Does that make him the devil? I'm confused. What are you saying there?
Testifies to a lot. The biggest change in Paula's testimony is her transition from not able to identify anything to it's not Tucker. And they're such good friends now that you saw pictures where he was laying in her hospital bed. She's supposedly got an infectious disease, and he's laying there with his tongue hanging out, no mask on. That tells you the kind of friendship they have now. Roger Raggett, I submit to you, no one's going to tell that man to say anything that doesn't exist. I drink, I think it was Bud Lights. I drink my Bud Lights, and I smoke crack when I can. I go over to Paula's. Paula sells it at the Treehouse. Who supplies the party favors? She does. I don't bring it. But he goes over there and smokes her crack, smokes her weed. That's what he's been doing for how many years, and mowing lawn at the golf course. That's who he is. But his testimony corroborates Travis, and it corroborates Paula. I submit that Roger Raggett, completely believable. Is he the kind of guy you would normally see in your walk of life? Maybe not. Probably not. That doesn't mean he can't come in here and be truthful. That goes for all these witnesses. They might not be the kind of people you want at your Thanksgiving table. I don't know. But you're not here to judge their personal choices. You're here to judge the credibility of what they're telling you happened. And I submit to you that Travis Johnson, credible. Roger Raggett, credible. Paula, hit and miss. At the end of the day, when you go back there and you talk about this testimony and you watch these videos and you, by the way, you're allowed to read back on anything. If there's something that you would like to hear again, you can ask the judge to do that. You can ask the judge for whatever it is that will aid in your deliberations. You're free to communicate that with the court, and the court will do what they can to abide by your wishes.
We're going to allow readbacks?
But at the end of the day, I submit to you that we have proven this case well beyond and to the exclusion of a reasonable doubt. And I'm going to ask you to go back to that jury room and don't be afraid to find this defendant guilty and hold him accountable for what he did that night in November of 2017 to Matthew Bonnet, to Paula Belmont, to Roger Raggett.
You know, I'm still thinking through that. We've proven this case well beyond to the exclusion of a reasonable doubt. Did he get
Members
too
of the
many
jury.
double negatives or something in there?
You're going to hear the defendant's closing argument in just a moment. I want to explain to you our schedule. I think it's important you understand why I'm doing it the way I'm doing it. I would like to have all the closings finished before the lunch break. It's going to mean that we're going to have a little later lunch than what we're accustomed to, but I think it's important for there to be continuity and not have any major breaks between one argument and another. So we'll be taking a bit of a later lunch. When you get back from lunch, then you'll hear the closing instructions and you'll have the case for your deliberations. What I'd like to do at the moment is to give you a 5-minute break. This is in the jury room. If anyone just needs to stretch or use the facilities, we'll give you an opportunity before we go into another closing. So take a 5-minute break, and then we'll come back to hear the defendant's closing.
All right, let me just say on that closing by the prosecutor, I guess the first part of their closing, I was following him all the way up until when he said, that's a close-up on her, that the most credible witness in this case was Travis. The most credible piece of evidence they've got is Travis's testimony. You know, I admit that's the first thing he said, and so he lost me right there at the beginning.
All right, so that means
the door shut first.
11:40. We'll be back, and we'll have just 5 minutes, 6 minutes. 11:40.
Sounds good.
We'll return.
Okay, so while they're off having a quick break, did you notice he gave no definition of reasonable doubt? I noticed that was a mess for me. I struggled with that one. It seems that the absence of evidence is evidence, and that's what he seems to be going back to over and over in this. For him to say, yeah, we had DNA, and sometimes you get DNA, and sometimes you don't. It's very different from just him like picking up a pen and saying, would my DNA be on there from picking it up? Probably not. Would your DNA be on the handle of a knife or in the glove, inside the glove that was holding the knife, as you stab somebody repeatedly in the back? Most likely. And that's why we have, I believe, Rory Wilson's DNA all over the handle of that knife, because it was there. Oh, Ivan, be good to me, okay, man? Be good.
Call from.
Quick call.
Okay.
To accept, press 1. To send a voice.
Hold tight just 1 second. Hey, Siri, set a timer for 60 seconds. No, go ahead. Ivan, unrelated. Go ahead. What's up?
I thought I got 120. I thought we agreed on that last
I said you can file for an extension, but I haven't seen that motion. Go ahead. What's on your mind?
Okay. All right. Well, have you ever seen a worse rambling of like Travis said it, so Travis corroborated it. Like, am I the only one that heard that?
Yes, he was on the witness side and the corroboration side, which was quite interesting. I saw that a little bit. The facts that
and only black men wear black clothes. That's something else I learned.
Well, Travis said that he was wearing a Jägermeister neck hoodie. I think what he said was it was a beanie type hoodie type thing. The mask, it was convoluted, and they're like, oh, he said the word hoodie, and then corroborating that, Paula said he was wearing a hoodie. Same. It's like the hoodie does not equal Jägermeister.
Yeah, well, and Paul was a victim, and how he attacked her, like,
she's not credible.
Get away with that?
She's not credible.
Like, you can't.
It's not convenient for his story.
Yeah, I've never seen him. I've never seen him disparage an actual victim who they admit is a victim.
Ivan, I've got to cut you off. I've got a suspected spam call, and we know we have to take this. All right.
All right.
Thanks. Bye. Hello.
Call from Britt Bottoms.
Oh, it's Britt.
To accept.
Britt, I thought we had a spam call. Hang on, Britt, just 1 second. let me just say, yes, Ivan, I just did hang up on you because I thought I had a telemarketer on the phone. Ivan, I'll let you call back and get the other 60 seconds. Britt, what's on your mind? I don't know why you came in as a spam call.
People have been spoofing my number. Scammers have been spoofing my number for weeks.
Oh, okay.
So that's probably
that's
why.
what they all say. Go ahead. No, Britt, what's on your mind? What's on your mind today?
None of that connected for me. Paula, she was a victim of a crime, so her memory is all over the place. Travis has motive to tell them what they want to hear. So none of that connected for me, and I'm still not guilty.
When you look at Paula, he literally says Paula is untrustworthy. You can't trust her when she says it wasn't Tucker. Yet she is the most commonly corroborated listed. The person that says corroborates the evidence. Paula said that. Paula said that. Paula said that. It's corroborated.
Yeah.
You can't play sword and shield with this and say yes. You can believe her when she says what we like, but you can't believe her when she says what Tucker likes. And he played that all the way through.
You can't have your cake and eat it too. Yeah.
It was terrible. It was terrible to me. Matthew Harris pops in. Let me just say this, Britta. Hang on a second. Matthew popped in. He has not watched this case, and I'd love to get his feedback. I think he watched this. He said it wasn't the most terrible. It was like mediocre.
Yeah.
But
it wasn't the worst closing I've ever seen, but it wasn't great.
But we've had the benefit of seeing what the evidence was and seeing how it's set out. And, and the way he laid it out, I think wasn't quite. It had a slant and a half. Let's put it that way. It had a slant and a half.
Yeah.
We've got
Uncivil Law hadn't been watching this either, and he did a reaction yesterday to it, and he was kind of confused on some stuff.
I imagine Kurt had some funny words to say.
Oh yeah, he did.
Oh, man, that's crazy. Britta, thank you very much. I appreciate that. Anything else you wanted to get in before we let Ivan call back?
I think I'm good. Thank you.
Thanks for the call. I appreciate it. We'll see you.
Sure. Bye. Bye.
Okay, Ivan, I'll let you finish. I'm going to be like Kanye, and I'm going to let you finish. Give me a call back. Sorry, my friend. I can joke with Ivan because he is a friend. I love him. We talk a lot offline as well. We disagree almost always, but that's okay because he's most of the time he's able to disagree appropriately, and we only have to time him out like once a day, which that's not too bad really. If Ivan is still around, I'm not sure. RA quoting Kanye. That wasn't on your bingo card, Greeners. It wasn't on the bingo. Okay, here we go. Let's let Ivan get his other 60 seconds. Ivan, thanks for calling back. So happy to hear from you.
Hey. All I know is that I've never seen somebody disparage a victim like that, and how it was like a total circular argument with him. Like, he said, this is true because he said it's true, and it's true because they said it's true. And I mean,
he even had, if you read between the lines in there, he literally told everyone that Travis was denying everything until it was laid out in front of him, until they told him the story. Yeah. And then he's like, oh crap, you got me. And then he's like, yep, your story's right. And by the way, that guy that's my height also, that wasn't me. It was that guy over there. He had my knife.
All he did, in my opinion, is just further prove that Travis is the guy. Like, there was nothing in there about Tucker. Like, nothing. Like, what's the evidence? I know we don't always need physical evidence, but like, come on, there has to be some. Like, there's been none.
Yeah. Lauren just says that I was just informed that Sheriff Rick Ramsey is in court. I don't know his significance in this case. Lauren, I'm not sure if you're at a point where you could let us in. We're about to go back to court right now.
Well, I just I appreciate the rebuttal, allowing me to rebut. But Matthew Harris, I think maybe we have been spoiled by good attorneys, but this guy's going to be selling Dish Network in 3 years. Mark my words, okay? And nothing wrong with that, but I'm just saying, okay?
All right. You heard it here first. Thanks, Ivan. Appreciate it. Good talk to you, my friend.
Love you guys.
See you. Bye.
Bye.
All right, we are about to go back to trial here in just a moment. They were supposed to only be about a 5-minute break. Apparently the sheriff's in the building. Sheriff Rick Ramsey. Oh, here we come now. It's back. We're back now. Matthew Harris, by the way, congrats on the 12-month anniversary.
Everybody's
Happy
back.
anniversary.
So we got all the jurors in the jury room.
Judge is surprised. Everybody's back.
Bring them in, please.
Mr. Tucker's up. It's going to be his turn for defense. Then that doorknob's getting worse. It's that door handle. It's just completely askew. After Mr. Tucker, the state gets to go again. They get the final word, and they will have, let's see, they'll have about 30 minutes. I think it's about 25 minutes. But Mr. Tucker gets the full hour and a half in one shot. So we're going to see how he addresses this, and hopefully he hits the most credible issue. I hope it doesn't spend time on the little points like the reflection of the headlights like the state did. That was petty. Yes, the state was wrong. He already called them out on it. I think the fact that the state brought it up in front of the jury reminds them that the state is flipped on what they thought that reflection was, and the testimony from Travis about what that reflection was.
So everybody can be seated. We'll just wait for the remaining juror and make ourselves comfortable.
There's always one. It's usually like just 30 seconds later. I do hope he gets this. I hope he's able to formulate his thoughts in a reasonable manner. He's able to hit everything he wants to.
Thank you. Please be seated, everyone. Welcome back to the courtroom, members of the jury. Now the opportunity for the defendant to make closing argument. Mr. Tucker?
Yes.
Okay.
Good afternoon, ladies and gentlemen. Okay. First, let me apologize to start off here. As you can see, I'm noticeably irritated, angry, upset. And there's a good reason why. Mr. Mansfield up here corroborated, he pounded that into your heads, right? Again, all Travis corroborated was his own story. That's it. He literally, all those details that he just handed out to you, the drawing the map, the I said this, I did that, all this stuff. Yeah, somebody who's there who did the crime could actually tell you all those things. Makes sense. And he's saying that's the only thing that makes sense is that Travis is actually, believable. Okay, well, when I put myself on the stand yesterday, Mr. Mansfield didn't impeach my testimony once. Not once. Did he say, prove that I lied anywhere in there? Then he goes ahead and he corroborates my testimony by saying, oh, you told the investigators the same thing 6 years ago. Yes, I did. And why I'm upset? 6 years ago. And after 6 years, the state comes up here with Travis said. That's why I'm here, right? That's what it boils down to. And, you know, I got to say, yes, I am upset. You know, I'm literally sick to my stomach right now.
Objection, Judge, to the improper argument.
Well, I will overrule the objection. If you're sick and need to take a break, sir, I'll certainly give you an opportunity.
I meant I'm sick, you know, because I had to sit there and listen to this.
Okay.
Again, Mr. Mansfield even says in his argument, in his closing argument, 2 guys. That's what all the evidence says. That's what it said from the beginning. You know, again, you know, go back to the corroboration. Again, Cosme video doesn't corroborate Travis's story. Even Detective Fernandez, who he brings up, says corroborates Travis's story, right? No, he doesn't. He says, when I asked him, can you see anybody in the truck? Can you see anybody, a getaway driver sitting in the truck? Fernandez says no. You can't see anybody sitting in the truck. We went over that ad nauseum, right? Nobody's sitting in the truck, so that doesn't corroborate Travis's story. Do you see 2 people getting out of where the truck was? Sure. But what's to say that wasn't Travis? How does that end up being me? That the prosecutor never says. Not once does he say how that becomes me. Anyway, so let's go on from there. We've got, okay, Malone. Detective Malone. Now, here's the thing, another point that was making me very ill. You know, the prosecution went ahead and they made sure that you didn't hear about the investigation, how it went.
Objection, Judge, improper argument.
And I will sustain that objection.
Okay. So, anyway, let's go here. I came here. I was living, right? I live in Oregon. That's where I live now. I didn't try and hide from this thing. I came here of my own free will, hopped on a plane, came down to Key West, right? Yeah, as Mr. Mansfield suggested, my wife is a multimillionaire. That's true. Absolutely. I could be standing in front of you with slick lawyers, you know, that kind of thing.
Judge, improper argument.
I will overrule the objection.
Can we come sidebar?
Yes.
Stop the timer at 3 minutes and 30 seconds. The state has objected to him saying he could have lawyers. Judge overruled it. Let's see if he flips on this. It's silent, so we don't get to hear this. The jury also doesn't get to hear this. It's quiet. The objections are a little much, and it might frustrate the jury if he plays this card too much. Matthew Harris likes the slick lawyers comment. A sidebar during closing. The optics are bad here. I think they won. I think you flipped on that. Let's hear.
And look, I put myself before you guys.
Yep,
and
state won.
Almost every piece of evidence the prosecution wanted to put in, I let them. I didn't object. Go ahead, put it in. Go ahead, put it in. Why? Because not any of that says I did anything. None of it. Now, he wants to go to the DNA results. And they want to use inconclusive as a positive, right? That's what they're trying to do. Now, inconclusive means exactly that, inconclusive. And then, to boot, when he starts, talking about the sweatshirt and the gloves, these are things that weren't even recovered from the crime scene, don't have anything to do with the crime as far as we know, right? They were recovered from the warehouse, that's true, somewhere's in there in the warehouse. They didn't put those into evidence. Those weren't found at the crime scene. They weren't found to have the victim's blood or DNA or anything like that on them. They're found to be in the warehouse. Again, that means nothing. Going back to it again, you're looking at this, okay, what is it? Let's see. Oh, yeah, so he wants to say, again, Travis's story is corroborated, right? Again. The weapons. We go down to the weapons. Travis says, a pipe and a knife. Roger Ruggett, who he said is very believable, very credible, right? Okay, he says 2 knives. That's what he says. Now, Paula does say something about a smaller knife later. That's true. And yes, she believes it's to be Roger Ruggets, not one of the ones that was brought to the scene. And again, it was never put into evidence as something being found at the scene. So, okay, again, it's just trying to confuse and literally trying to dilute your minds with things that don't mean anything. None of this means anything.
Objection.
I go over, and I was looking at all the witnesses that they brought, right? All these witnesses. Okay, yes, Dr. Speckbauer comes in and says that knife killed Matthew Bonnet, right? Okay, I don't disagree with that. I don't disagree with that at all. But what says I'm carrying that knife? What says that I'm using that knife? Nothing, right? That just says that, that knife was used to kill Matthew Bonnet, right? Okay, they bring the DNA expert. DNA expert says, you don't find my DNA anywhere on any item, anything that has to do with this crime. Again, the best they can pull out is inconclusive on some things that weren't even found at the crime scene. Now, again, I'm not trying to mislead anybody. I'm telling you guys, like I said, I put let them put in what they want, let them put up the testimony they want, anything they wanted. And this is the best they have. After 6 years, and yes, I'm angry. I'm not going to say I'm not. That would be a lie too. I get up there and I'm looking at this, didn't happen, didn't need to, all right, hold on. Oh, yeah, here we go. This is another one. Talks about corroboration. The clothes. We want to go back to the clothes that people were wearing. Travis's story. He takes us back to the warehouse. We go upstairs. We change into dark clothing. That's what he said. That's what he testified to. Paula, on the other hand, testifies that Rory Wilson's wearing the same clothes, and he actually uses this in his PowerPoint. That Paula testifies, wearing the same clothes she saw him in earlier that day. So where did he change clothes? Again, where'd that happen? Because if he's wearing the same clothes he's wearing that afternoon, then why isn't he in different clothes? Because Travis said he went up and changed. So how's that corroborated? It's not. Again, and then you talk about Travis's testimony, matching the other witnesses, matching the other evidence that's in this case, right? Travis tries to put the knife in my hand. Well, the DNA says differently. Now, again, how do you explain, you can say that, he may have used gloves. Well, okay, no, again, Travis, he says he doesn't see anybody put on gloves. Nobody else says that either. Okay, so how does that happen? If the knife is in my hand and I'm committing a crime with it, it should have my DNA on it. That's that simple. They use that for that crime. Again, and then go back to the felony murder thing and the whole idea of, you have to, it doesn't matter whether you participated or whether or not that you participated, that you actually killed the person. Well, he can't even prove any of that. You can't prove I was there. You can't prove that I actually committed any crime, that I actually did anything, that I even discussed a crime with them. He can't even prove that. He can't prove one element of his case, not one. We'll talk about somebody who's being misleading, somebody who's trying to hide things. Okay, he wants to talk about, the conversation I had at McDonald's with Paula, right? And how, I discussed how I had the knife. And not how I had the knife, but how I knew the knife was, it was Matt's blood on the knife, right? But then he doesn't want me to tell you about what interrogators talked to me about when I was down being grilled all night. What they actually told me.
Judge, I'm going to object. Can we come sidebar?
Yeah, okay.
He got it in. What are you going to do? You strike it from it's not testimony. He got the saying in. The jury heard it. He's basically saying the investigators told him this prior to that. This is how he got all the information. The judge is like, wait, calm down. They're interrupting each other right now. Mr. Tucker's frustrated. The state's frustrated. The judge is just trying to calm everything down. He shouldn't be able to bring up during his closing objections that were sustained during the trial. I think that's what the argument is right here. He should stop saying we or I with anything with the crime, distance himself from the scene. We have not seen that, John. We've hoped for it. We've hoped that he says it wasn't me. And he gets up there and says, you can't prove it. And it sounds different. It sounds different. Yes, the law says you have to be able to prove it, but it sounds different when you get up and you say, you know, he has nothing to prove it was me. There's no evidence that says it was me. You can't prove any of this. That's right. That by that standard, he should be found not guilty if they can't prove any of this beyond a reasonable doubt. But how hard is it to say it wasn't me? I wasn't there. I didn't do it. And he has not said that to the jury. They don't need to, but I think that would go a long way to help them out. Bailiff gives the thumbs up, ready to start.
Ladies and gentlemen, yeah, again, you'll have to forgive me. It's upsetting.
Keep your voice up, please.
I'm sorry.
It's all right.
Yeah, I went down to the station. I was there all night. You have to, again, I can't tell you how the interrogation or the interview went. I can't tell you what they told me. I can't tell you anything about that. Which again, it is very frustrating, not to be able to provide you with any of that information. There comes objection again. I wish I could. And again, Mr. Mansfield also alluded to, nothing being tampered with, nothing, being, was it mishandled or whatever. Again, I'm not allowed to talk about that.
Judge, again, objection to the way he's stating this. There's no evidence of mishandling of evidence or
again,
In any event, we're going to members of the jury. Remember, this is closing argument, all right? And it's based upon the evidentiary record, and we're limited to the evidence, both sides, that is in the trial. Not beyond that, so Mr. Tucker can certainly make arguments pertaining to the evidence in the trial.
Mr. Tucker was asked a question by the state while on the stand as a witness about him believing there's a conspiracy going here. I think he can touch it lightly.
I would just submit that even by saying what he just said, it's again, you're going beyond stuff that's been admitted into the trial.
Well, but in any event,
but I'll watch myself. I'll watch myself. Again, let's go back to this. Okay, same clothes. Then the hoodie thing. Travis Johnson never mentions that once. I don't think anywhere in his testimony he ever talks about a hoodie. A hoodie, was it a hoodie thing with a hoodie mask or anything like that? Where that actually comes from is from Paula Belmont's, her testimony. That is there. I don't remember Travis Johnson ever once talking about a hoodie. But he does talk about a neck gaiter. He does talk about that. And the neck gaiter thing, okay, he submits that, it's good for covering up a beard, all this other stuff. It's like, okay, it's also good for covering a face. That's it, right? And you would think, out of all these witnesses we've had, right? Some of them you heard, some of them you haven't, but the ones that you've even heard here, okay, if you have a neck gaiter covering up your face with Jägermeister written all over it, you think somebody probably would have said that. Somebody would have identified that, right? But does anybody? No. They identify it as two skull masks. They identify it as a hoodie thing, depending on which way, what angle I guess they saw them from. I can't say, but I can say this. You would think that, Jägermeister all over your face would probably be something you could identify, I would think. Then we go back to this. It's like, okay, yeah, loves the word corroborated. That was one. I couldn't believe corroborated. There's nothing corroborated here. Then he goes into the masks that, that Travis describes in the video. And again, that's not attributed to me at all. That is attributed to Rory Wilson again. Yes, Rory Wilson apparently wore this skull mask or a demon mask, whatever you want to call. Yes, it's fearsome. It's nasty. I'm not going to say it's not. I've seen it. But at the same time, it's not something that he's saying I'm wearing. It has nothing to do with it, right? So, okay, then you've got the knife. And again, going back to that. Travis had a nice knife collection. I can't testify as far as for Travis, but what I can say is he could describe that knife in great detail, down to ball bearings. in it. Yet, it's supposed to be my knife. Now, if it's my knife, how do you get in such great detail? I just, again, it doesn't make sense as far as that goes. I mean, the guy, he sits there and he can describe every little detail of this knife, but he's going to try and say it's mine. I can't do that. I couldn't do it back then. I can't do it now. So, again, I don't understand that. Let's see. We got into the, Travis saying that Rory was with that mask, but then he tries to attribute it to me. Knife, great detail. Okay. And, oh, yeah. Hold on a second. Oh, no. We got that one, too. Okay, so,
Their ball
he
bearings
also makes a
holding the knife in
big point to talk about what they don't know. What they don't know, right? Okay, which seems to be a lot, right? Again, you look at all the evidence in this case. I can go down the witnesses. I can go down all the evidence in this case. There's not a single thing that says I did anything other than Travis Johnson. That's it, right? And Danielle Malone, based on Travis Johnson, right? She admits that on the stand. Her story comes from Travis Johnson. Okay, well, again, talk about credibility-wise. And, he did try and say that Travis threw out my name without being told by Captain Phelps. That's not true either. If you watch that video when you go back in there, that's not true. What she does is says, if I remember correctly, it's we all know who the asshole in this story is, right? Again, and then he replies back, is it Ty? That's not him coming out and saying, Ty did, Ty's the one who did it. That would be a strong statement. That would be, okay, Ty did it. No. Is it Ty? Because he's looking to please Captain Phelps. Now, that's another thing. I did put in the whole Captain Phelps video with Travis, right? So I could show you where that whole getaway driver story came from. She literally tells him the entire story. He parrots it back. All he says is, yeah, that's what happened, right? Now, the details after that, of course he knows the details. He was there. He can go ahead and draw a map. He can go ahead and tell you, man, there's two guys getting out. He can tell you all that stuff. Why? He's there. That's simple. Again, nothing that says I was there. It just says he was there, right? So, okay, you got that. And, the whole parroting back thing, yes, there are things in that, and I knew when I put that video on there. Yes, there's some testimony in there that makes me sound horrible. But again, when you listen to that testimony, but April Walker, she's not here to testify. There's a good reason why. Captain Phelps, who headed the investigation, right? Headed the investigation. The one that's in that video. She's not here to testify. There's a good reason why.
Violation of Halliburton.
Okay, I'll
Mistrial?
sustain the objection.
Ask for a curative.
Ask for a curative. This is a big one.
Well, you're going to have to approach and...
Ooh, okay. Oh my goodness. Okay. He's crossed the line. He doesn't know what he can't go into, and he's trying to touch on all the things that he can't go into. This is, let's see, Halliburton. We need a quick explanation on this one. What's a curative charge? Let's see.
Members of the jury, please disregard any mention of Penny Phelps not being here to testify in this trial. Okay, you can continue.
Okay.
That was the curative.
We go back to Roger Roget. Prosecutor again comes up and he wants to say that, I did like this and I go like this. It's Roger Roget, he's talking about the height of the person who actually attacked him, right? Well, unfortunately for the prosecution, Travis is pretty close to the same height as I am, almost, pretty close. And yes, I don't think Roger Roget, I think he is a credible witness. I don't think he's lying one bit, and when I asked him if he knew my name, I asked him that because, in the report that they used to get me here, yes, it says specifically that Roger Roget said I, with him, my name, did this. Roger Rugged said he didn't say that, right? He didn't say that, but that was what was in the report.
Objection, Judge. The fact's not in evidence.
I believe there was some examination of that report, so I'll overrule the objection.
And yes, the report was also used by Danielle Malone when she gave her testimony. So, you know, when she was doing the video. And we go back to Danielle Malone now. Again, we could probably go all day on that. But Danielle Malone, she testified she was what? The fourth investigator down on the hierarchy here. And again, you heard yesterday when I asked her about Anthea Clay, right? And in their own words, yes, Anthea Clay was a suspect. Anthea Clay was never tried to be apprehended. And, you know, they tried, as a matter of fact, again, you know, we asked plenty of times about Anthea Clay, but, you know, again, we find her, what, 2 years later? Guess where she is? 2 doors down from the crime where she was.
Okay, I'll sustain that objection. I will sustain the objection. Your deliberations in the argument are limited to the evidence that was presented.
Yes, sir. Yes, sir.
Yes, I heard that, Amber.
Well, in the evidence presented, you saw the video with Paula Belmont in the hospital. And yes, Paula did change her story many times. You know, she won't deny that. You know, there were different reasons for that, because Paula Belmont did testify in the perpetuated testimony that her discussions with Detective Pitcher over and over again. Yeah, there was a time she questioned whether or not I did it. And that's understandable when the police are telling you that. She testifies to that in that perpetuated testimony. So yes, she does waver on her testimony. And then the video we saw yesterday at the hospital. This woman, okay, she had just gone through this crime. Just gone through this crime, right? And she's being questioned in the hospital. And yeah, I mean, there's some things she's saying in there that definitely could be misconstrued. I mean, when I played that one in the very beginning, it almost makes it sound like she's saying Todd is dead. You know, which Todd was the guy who goes and runs up the hill and, you know, gets the 911 caller, but it makes it sound that way, right? You know, but the one thing she is very clear about, she's very clear about this. Anna did this. Anna is the one who set this up. Anna is the one who wanted me beat up. She tried to do it with other people. Melissa Damas, she tried to do it with Crystal Dinklocker. You know, literally tried to set this crime up with other people, right? But yet she doesn't rise to the level of a suspect. Now, I know I'm not allowed to talk about, you know, the investigation or anything like that. But, again, you got to question is, you know, okay, this is a homicide detective, right? She's supposed to be investigating this crime. And yet that doesn't rise to the level of a suspect. So that is questionable. Again, her testimony as an expert, not expert, it's her experience and her training is what she says. You know, due to my experience and my training, I can identify this in this video. When we played the video for you guys, you can't see anything in there. You can't see anything except shadows, and you can't identify a single person in there. Yet they want to say it corroborates Travis's story. Okay, yes, Travis drove the truck there. I believe that all day. You know, yes, I believe that they probably went around, you know, once, you know, trying to case the joint, trying to figure out, you know, if there's anybody watching, whatever. You know, but I also believe Travis and Rory got out of that truck. And I believe Travis went and committed this crime.
This is good.
Now, Travis, yeah, when I did my cross on Travis, you know, you saw how he went from being the sweet, innocent, you know, getaway driver to, you know, again, he was highly agitated. If you know, I guess that's the best way I could put it. You know, but you know, again, I was a little nervous there for a second. I'm not going to lie. But the thing is okay. So you know, again, his story changes and vacillates, which that was another one. The whole vacillating thing. We went through that, and I actually asked him specifically. I was like, okay, does that mean you're not telling the truth? Does that mean you're lying? Is that a fancy way of saying it? I actually had to look up what the word meant. I didn't even know. But yet, the prosecutor and Travis both use this word repeatedly. Vacillating, vacillating. Oh, I was vacillating. You know, you were vacillating. Okay. It's a fancy word for saying lying, right? And he.
I'm going to overrule the objection.
And he admits it the next day when he comes in to finish his testimony. He comes back here, and immediately, when Mr. Mansfield puts him on redirect, he comes back and he says, were you not telling the truth? And he finally says it. He finally says, no, I wasn't telling the truth to begin with. He wasn't. That's true. He wasn't telling the truth. I think you guys can figure that out. I don't need to tell you what, the difference between vacillating and lying. You can figure that out for yourselves. But no, he did not tell the truth when he first got in there, right? Hasn't told the truth since. But he wants you to believe him now. Now he's credible, right? Now he's credible. But again, you're talking about the deal again. This man is getting off a life sentence. He's getting out of his part of this crime, by saying that I did this. That's what it boils down to. He's trading my life for his. And yeah, he got a hell of a deal, 5 years. That's what he got, the time he did in jail. And all he has to do is testify against me. Now, again, I get up there, I tell my story. You may not like me. You may not like my lifestyle, anything like that, anything like that. But it doesn't mean I did this. And I got out there and I told the truth.
This is good.
Told it, as I can remember, as much as I can remember the truth, and as much as I'm allowed to tell, because I'm not allowed to say everything. I wish I could. But no, I get up there and I tell my story, and Mr. Mansfield comes up here, and if you look at the questions he asked me, were they about the crime? They weren't about the crime. He pulls out a picture of me with my beard. Look at this guy. Oh, he was staying at Cots. Like that, it makes me, that makes me a murderer because I'm staying at Cots? How does that play into it? He asked me all these questions that none of them really have anything to do about the crime. It's literally trying to, again, I look, a certain way, I live a certain way, or I live someplace. Again, what's that have to do with anything? Other than trying to confuse you to the facts. The facts are pretty simple, He even says, everything says two people. Everything. Everything in this crime, it says two people except Travis. That's it.
And he was one of the two.
And if I'm Travis, yeah. And Captain Phelps goes ahead and tells me, this story. Let me tell you a story, because you're the driver, and you picked them up, you drove them down there. They got out, they did this. Yeah, and you're right. He didn't know about felony murder when he's given this story. He's fully believing that Captain Phelps is going to take care of him. That Captain Phelps is going to make sure that he doesn't get charges on this crime. That's what he's believing. That's true. But again, he doesn't know about felony murder. So now he's tagged with that, right? Well, now the only way to get out of that is to give you somebody else. That's it. And I am upset. I am very upset. I can't tell you how much. It's cost me 6 years so far. Anyway, so let's see. We're going back to Paula's testimony. We went through the consistency on that. Again, when she's in the hospital, she's in a state of, again, she's just gone through this horrible crime. She just saw her friend get killed. And yeah, we don't know if she's on medications. We don't know anything about it other than, yes, she says one thing, and at this time she says something else when she gets, again, a chance to think about it. Actually calm down, maybe not be on meds, and actually think about things. Mr. Mansfield, again, you want to talk about bringing up things that don't mean anything. Okay, yes, Paula and I become friends, and yes, she takes a trip to California, and you allude to her lifestyle, but she was staying at Cots or something like that, but now, but then tries to throw in the fact that I have a wealthy wife. What's that have to do with anything? Has nothing to do with anything, but he's going to throw that in there. Again, this whole corroborates thing. What corroborates Travis's story? That's what you got to look back at. What really does, other than his own testimony? Other than the police he told, right? He told his story to the police. Now, whether or not they wanted to believe it, that's up to them, but at the same time, it's the only thing they're using against me. That's it. And when he had his chance, he has me up on the stand. He can ask me anything he wants. And yet, not one thing proved I was lying. Not one. And then he asked me again, going back to the police station, Did you tell the same story 6 years ago? Yes, I did. My story hasn't changed. Unlike Mr. Mansfield said, Travis's story hasn't changed the whole time, but I watched it change on the stand. Literally, it went from one day it was this and the next day it's that. But mine hasn't changed over 6 years, and I haven't taken a deal. I haven't taken a deal to do anything, because again...
Objection, Judge, and proper argument.
Okay.
I'll sustain the objection.
All right, let's see. Okay, and that's the other one. Travis says he goes to get cigarettes on the video for Florida Keys Electric. Who's to say that's true? Who says that's true? Because me personally, you know what I want to, I would actually submit? Again, if he just committed this crime with Roy Wilson, he's going to go up to, to the Tom Thumb to get cigarettes? Or is he going up there to check out what happened and where Rory is? You know, because I mean, he left Rory behind supposedly, right? Well, wouldn't you kind of wonder what happened if you were him? Wouldn't you want to go check it out? Make sure that, did Rory get busted by the police? Is he going to be talking? Who knows? I don't know. I know he came back with Rory Wilson. I do know that. I know they don't have me on video doing anything, not a single thing. Right? No physical evidence. Right? So there's no physical evidence putting me there. There is no video evidence putting me there. There is no forensics evidence putting me there. Nothing puts me there committing this crime. Right? Nothing actually puts me even, again, if you want to talk about, the definition, I looked up the definitions, that we have for, felony murder and the other charges. I don't even have to be there, right? But okay, what's to say I had anything to do with it even if I wasn't there? There's nothing saying I actually, sat here and conspired with those guys. No, it says that at all. Right? And again, for as much as Mr. Mansfield doesn't like my story, he hasn't shown anything that says it's wrong. So, okay, and when you talk about who's going to be believable, yes, and okay, Paula Belmont, yes, she does eventually realize that again, that voice did not match mine. And it may have been because we became friends. I don't know, right? I really don't. I'm not her. I can't tell you that. But I do know that, yes, she realizes that that was not the same voice she heard, right? Okay, I like I said, I can't speak for her. As far as, as far as Paula's friendship and my friendship, I told you yesterday on the stand how that happened. And yeah, when I couldn't talk to her and she was telling that stuff to the press, you don't think it sat there and I'm looking at this woman and I'm like, she doesn't owe me a thing, not one thing. And she's up there telling the media this stuff. And yeah, it was hard to sit there and watch that and not be able to talk to her. And you want to know what the first thing I said to her? First thing I said to her is, you're an idiot. That's what I told her.
Objection, Judge. Facts, not evidence.
All right, we'll sustain the objection.
Okay. Anyway, so to suggest that Paula has any motives other than, again, trying to give what she knows about this crime. Matt was her friend, too. Now, I'm not her only friend. Matt was her friend for a very long time. And if she thought I had anything to do with it, she did testify to this. What was the words? I could burn in hell like the other two. Yeah. She's, so no. The thought that she would actually be in that picture with me, making funny faces at the hospital. Do you really think she would be doing that if she thought I had something to do with this? It's like, it's insane. And maybe that's why I am so angry. It's like,
he's doing okay here, but he needs to stop referencing things the jury isn't aware of.
I go through 6 years and this is what they bring you. And this could be anybody. It doesn't matter. I just happen to be the guy. I happen to be the guy that's the one they want, right? Okay. And they say, we can get this guy to say he did it. Okay. I don't even see the logic in that. If you've got, going back to the backpack, he saw me running down the street with this backpack and I got things fumbling out of it and all that other stuff. Am I found with the backpack? No. He comes up with a story about, how it mysteriously ends up in his trunk, but he never tells you anything other than that. He doesn't say I put it there, and sure enough, again, I didn't. He says I helped him, but there's nobody who saw that either. right? Nobody can prove that. Nobody was there to see it, but that's what he says, so it must be true, right? No, actually what is true, though, is he had that backpack up in Big Pine. And yes, it was part of the crime. And according to, again, Danielle Malone, it was not just thrown into a closet. It was actually placed up underneath of an air conditioner, right? Not like you just threw it in there. It meant more like you meant to hide it. Now, again, because Travis tries to say, I'm the one, right? I'm the one who had it. No, I'm not. And I keep on going through all these things that he says corroborates this stuff. I'm sorry. Bless you.
Well, then she exploded. Boom.
You know, and then, okay, he says he wasn't shown those videos. You know, he wasn't shown the Cosme videos until after his confession, right? Or he wasn't shown until after his confession. Yeah, it's true. He gave a confession, but he doesn't actually talk about the different things in the videos until after they show it to him. He confesses he was there. He takes, I'm the getaway driver. Yes, just what you said, Captain Phelps, I'm there. I'm the getaway driver. He says that he confesses to. But he doesn't give the details until after he sees the videos. That's what happens after that. Because, there's a difference between the confession and the videos. So, okay, then we go back to the vacillated thing. We already covered that. And let's see. Oh, that was another one. Paula. The prosecutor liked using Paula's statements when he wants you to believe they're true.
This is good.
But then he, again, when they're about me, when they actually have something to say about me, then they're not true, right? So it's only true if it backs up the prosecutor's story, not mine, right? But I will say this, is Paula did say that she wasn't sure, but Travis could have been the guy who was with Rory Wilson earlier that day when they came over in the afternoon. She says that. Now, she wasn't sure. She didn't know Travis. That part everybody agrees to. And could she positively identify him? Not at that time, right? But she does say that it could have been, Travis. So yeah, Travis may have been at the Treehouse earlier than the prosecutor suggests. Then we go back to, let's see. You got to forgive me. I am not as polished as the prosecutor. I'm not a lawyer. I think we did this when we did the voir dire. I'm not a very good, I'm not the best public speaker or anything like that. But I did come here, and yeah, I thought it was important that you see me for me. I don't know. I don't know if that's smart or not. I do know it was very frustrating at times, and I apologize for that. I'm not the best. And but we're almost at the end here, guys, as far as things go. Yeah, we already did this as far as I haven't been able to tell you the whole story, and that kind of.
Here comes an objection.
Judge, to this line of questioning.
Well, it's not questioning, and
sustain the objection to that argument.
Well, I would suggest this, that yes, as we can see, I don't want it to seem like I'm being untruthful just because I can't say something.
Objection, Judge, improper bolstering.
I will sustain the objection.
Okay. Okay. Paula says the knife is Rogers.
And the gist of it in.
Yeah.
The jury's hearing that.
Again, it's hard for me because he wants to talk about, my conversation with Paula.
Improper argument, objection.
Well, I believe he's referring to the McDonald's.
Yes, I was.
Okay, so we'll overrule the objection. So.
Daggers from Tucker at Mansfield.
I was talking about that. And going back to that, again, the prosecutor submits to you, there's no way I could have known whether or not Matt's blood, whether it was Matt's blood, Paula's blood, whoever's blood on the knife. But again, I was there for, I don't know, it was a long time, being interrogated all night. That's all I can say. I was there for a long time. And yes, I came into contact with people who knew things that I don't. You know,
He's
so
gonna object again.
submitting to you that there's no other way I could have known that is very misleading. And that's what look, when you guys go back there, I do think we made a great choice as far as the jury. I do. You know, we've tried to find people who are going to look at this and look at the evidence. And when you go back there and you look at the evidence, you know, don't believe my words, don't believe his words, I guess. You know, look at the evidence and see what it says. You know, the evidence in this case, I'm not, you know, maybe, you know, again, you don't have to like me. You don't have to think I'm, you know, I don't even, you may think I'm the biggest.
Objection, Judge,
whatever.
to the pandering.
Well, I'm going to overrule the objection.
Anyway, what I'm asking you to do is just look at the evidence. That's it. You know, look at what it says. And if it says that, you know, I did something, if you think that, man, I did something based on that evidence, okay, fine. But if you're going to, you know, again, I look at it now and I'm like, really? It comes down to whether or not you believe Travis. You know, that's what it comes down to. And whether or not you believe me, I don't know. You know, I'm not going to tell you what to think. You know, this whole corroborating thing, that's for you to decide. It really is. Do you think that evidence actually says I did something? You know, if you don't think it did, then man, I would submit that's reasonable doubt. I don't see where there isn't reasonable doubt in here, but that's not for me to decide. You know, I know what I did that day. I know what I didn't do that day. You guys don't. So I'm going to have to trust you. You know, I'm going to have to trust that you're going to look at the evidence, you're going to look at the videos, you're going to look at all this stuff. And then you're going to decide. I mean, you know, I can't tell you what to think. You know, but what I can tell you is, I can tell you that it's not as the state would suggest. You know, they say they've made their case, they proved every element of their case. How is that proof? How's one man's word against another? How's that proof? You know, so I don't know. I mean, like I said, I'm not going to give you a whole big slick speech, but one of the things when I was talking about the lawyers and whether or not I needed lawyers, and maybe I did, I don't know. But I'll tell you this. I felt the truth doesn't.
Objection, Judge.
Overrule the objection.
I felt like.
Sidebar?
Yes.
We don't know what he was going to say, but apparently Mr. Mansfield does, and he doesn't like it. Mr. Mansfield is quite frustrated with this. Nicole, Matthew, now we need to look at the camera and say, and I want to thank Matthew Harris Law Pro Se Trial Tips for helping me defend my innocence in this case. Matthew Harris is a good friend of the channel. He's been busy with court cases. We've missed him here for a couple weeks, but Matthew Harris and Nicole Goodman, both lawyers and friends of the channel, been with us for a long time. Love that. Matthew Harris and Nicole also have their own YouTube channels. Matthew, I might say, Nicole, is doing a lot better with his channel than yours as far as regularly posting. So I'm going to give you a little elbow on that. We need some more content from you, Nicole. It's great stuff. Let's see. Yes, there we have the links to Matthew Harris, and I think there should be one to Nicole here in just a second. There's Nicole's right there. Boom. As well. Little channel shame going on. Katia, remembered your name.
Anyway, back to that. Look, I told the truth. I gave you guys everything everything you could need as far as what they want to bring. You know, I didn't object very much. It didn't stop them from putting things in.
Your voice up, Mr. Tucker.
Oh, I'm sorry.
It's a...
So again, I gave you as much as the prosecution wanted to show, right? And while I didn't put on the defense I wanted to, I didn't. But there are reasons for that too, and I can't talk about them either.
I can't talk about them either.
But here's the one thing, and I'm going to leave this at that. You know, I'm not going to sit up here and go through everything again and just rehash this stuff. What I am going to tell you is that Mr. Mansfield said, don't be afraid to find me guilty, right? Don't be afraid of it. And what I would submit is that you should be afraid not to find me guilty. That part, no. But you should be afraid that, man, any single one of you could be right where I am.
Objection, Judge. Golden rule violation.
I'll sustain that objection. But
Well, apparently I need to study up on my closing arguments, but I think you guys got the point.
Yes, they did.
There's no evidence in this thing. We've already talked about that. Every single witness they brought, not a single one says anything other than Travis or Danielle Malone, who is basing it off Travis. So, Paula, you can believe Paula or not believe Paula. That's up to you. I mean, again, I can't tell you what to think. I can tell you that, yes, she did vacillate, to use the prosecutor's word, between different time periods, and there's reasons for that. It's not like, it's not like this whole thing hasn't had things that have happened in between, right? But anyway, I am trusting that you're going to go back there and you're going to look at the evidence and base it on the evidence like we talked about. And I did tell you at the very beginning when we did Boy Dyer, I was like, there is this presumption of guilt, and now people have a tendency to think you're guilty, right off the rap, and yeah, the presumption of innocence is hard. It really is. But does the prosecutor prove their case beyond a reasonable doubt? I don't think so. I don't think there's any way they proved it beyond a reasonable doubt. Other than that, I gotta say, I think you know how I'd probably be feeling right now. But the best I got is, we put on a case, and they put on a case, and all I'd say is all that show and all that thing you see, someone's putting it up in PowerPoint. Not a single thing that was up there couldn't be explained by Travis being the guy who was there. That's it. Simple. It made it very complicated putting me into this thing. But now, two people, it's real simple. That's what the evidence says. It says two. All the witnesses say that. All the evidence says that. So it's up to you guys to decide. I'd just like to thank you for taking the time, and for listening and for paying attention and seeing what this is. But at that point, I don't think I have anything to add. I wasn't coming up here with a speech. I just was going to come up here and discuss what happened. Anyway, I thank you for your time, and like I said, I hope you guys can just go back there, look at the evidence, and look at it for what it is. See it for what it is. But other than that, thank you for putting up with me, putting up with this. But I think I'll go ahead and let you guys decide. So, thank you.
We're going to put a poll up as far as deliberation time. How fast do you think the jury is going to decide this? Because that's
so the
what
state has an opportunity
next.
to make a rebuttal argument.
After the rebuttal, they have a few minutes.
I don't really think so. I think
Judge's like, no, you don't get another 5-minute break.
We have 28 minutes that is max that you have. So,
thank you, Judge.
Tucker went under his time.
Jury, I'd like to thank you for your patience and courtesy and attention during the course of this trial.
Bifurcated close.
Participation in this process is both important to the state of Florida and to also Mr. Tucker. Now, my colleague, Mr. Mansfield, said, the devil is in the details, and I'm going to stress that fact and just highlight a couple of different things to rebut some of the things that Mr. Tucker tried to represent to you. I would submit to you respectfully, there's a big difference between not being able to ID a second guy and years later saying it wasn't Mr. Tucker that was involved. There's a huge difference in that. The judge at the end of this case is going to give you some instructions, and one of those instructions deals with weighing the evidence. He's going to tell you it is up to you to decide what evidence is reliable. You should utilize your common sense in determining which evidence is the best evidence and which evidence should not be relied upon. Again, the devil is in the details. What is the motive for Travis Johnson to come onto this witness stand and point the finger at this defendant, Mr. Tucker?
What is the motive?
Mr.
How long do
Tucker's
you
correct.
have?
Travis Johnson was there. Travis Johnson owned up to this robbery that went bad, that turned into a murder that resulted in the death of Matthew Reed Bonnet. Travis Johnson's statement has been consistent since 2017. Travis Johnson also told you this defendant was involved in this case. That is uncontested. Again, devil in the details. Anethea Clay. This defendant, Mr. Tucker, keeps stating Anethea Clay. She's a murder suspect. They never investigated. Deputy Malone, on the other hand, said she was a person of interest. We never had enough corroborating evidence to go and put her or place her or involve her in this crime. Devil in the details.
But where's that evidence?
Let's talk about the motive for Travis Johnson. He didn't have a motive. He had no bad blood with this defendant. They used to hang out. They used to drink together, do crack cocaine together, smoke marijuana together.
Good guy.
However, the defendant states, my colleague, Mr. Mansfield, never impeached me one time. Well, I would submit to you respectfully that he did get impeached. Okay? The defendant was asked from the witness stand, Travis Johnson, Mr. Johnson, go ask Mr. Johnson. He told the police, actually the sheriff's department, go ask Mr. Johnson, he'll back up my story. Did Mr. Johnson back up his story? As a matter of fact, this defendant from the witness stand specifically stated that he was upset with Travis Johnson because he didn't back him up. Devil's in the detail. Paula Belmonte, that's a tough job that you have once you go back there.
That's the impeachment?
Many different statements from 2017 to the present. Couldn't ID the defendant. Only saw him from the side of his face. Don't know if it was him. Not Travis. Not sure if it was Travis Johnson, but I know definitely it was not Tyrone Tucker. Okay, well, I'm here to submit to you, ladies and gentlemen, the most damaging piece of evidence in this case is the conversation that Paula Belmonte testified to or was read into the record by Mr. Mansfield. And that is the conversation that she had with this defendant at the McDonald's the day after he was interviewed by the sheriff's department. They sat at the McDonald's and ran into each other by chance after he walked from the sheriff's department with slides on that were given to him. Runs into Paula. He went there, remembered to use the Wi-Fi. He runs into Paula. They start talking about the crime. Paula tells him what's happening, and he's feeling really, really bad for her. But he informs her, hey, the sheriff's department found the knife, or they found the knife, and she was really happy to hear that. And she said, oh my God, that's great. It has my blood on it. What does this defendant tell Paula Belmont? No, it had Matthew Reed Bonnet's blood on it. We know the Monroe County Sheriff's Office didn't provide that information because this defendant...
Objection.
Well, I'm going to sustain that objection because that's not facts and evidence. They can certainly make an inference, but to suggest absolutely that's the case.
Restate. We know for a fact that it was proven on this defendant's examination of Angela Oslowski that the DNA results on the knife did not come back until months after that meeting in McDonald's. So I submit to you, ladies and gentlemen,
I will overrule that objection. That was within my previous ruling. The last argument stayed within, so I'll overrule that.
Remember, cops are allowed to lie to you in
again, devil in the
interrogations.
details, ladies and gentlemen.
So they could have told him that
how
they
would
know
this
that knife
defendant
was used
know
in the murder because
to
it has
tell
Matt's blood on it.
Miss Belmonte whose blood was on that knife? I would submit to you, using your common sense, that the judge is going to instruct you in a minute. It was because he was there. It was because...
I'm sorry to interrupt. Can we come sidebar?
Whoa. How many riders does this horse have? How many riders does this horse have? This is crazy. Is there a problem here? Why is the attorney who does not have the floor making objections? It's already bad enough that the two of them are teaming up on a pro se defendant. Seriously, two experienced prosecutors tag teaming a closing against a pro se defendant. If they lose this, they might as well just retire because no one's going to take them seriously again. His counsel just, I'm not sure if his counsel objected, but his counsel asked for a sidebar. Tucker's frustrated. The judge is trying to calm him down or give him instructions so anybody can and can't do. He called his counsel to a sidebar. Yes, he interrupted, and now he's, I think he's coaching him on what to say. Honestly, I think he's giving him points or pointers to include. It's like passing him a note, but doing it at the judge's bench.
Again, ladies and gentlemen, the devil's in the detail. Your common sense has to beg the question: how did Mr. Tucker know that Mr. Bonnet's blood was on the knife? I would submit to you, utilizing your common sense and your life experiences, because he was there. Either he stabbed Mr. Bonnet, and at the very least he participated in this crime. That's the only way, deducing this evidence, that he could have made that statement to Ms. Belmont the day after he was not taken into custody by the Sheriff's Department. Now, Travis Johnson,
after he was not taken into custody.
In this case, his confession in this case to the participation in this robbery and this murder were made literally years before he ever struck a deal with the state of Florida. Okay, and I think it's very important to note, as my colleague highlighted, okay, he made a confession and then was shown the corroborating videos. He wasn't provided the details of what happened. He filled in the blanks, as Mr. Mansfield highlighted. He gave a statement in November of 2017, and that deal that he struck with the state of Florida was not entered into until April of 2022. No evidence whatsoever has come from that witness stand that indicates that the Sheriff's Department or any other law enforcement gave him any information in this case.
These are sneaky words.
I know we talked about this on jury selection, and I know Mr. Mansfield went over it quite at length. It's, sometimes in these cases, it's not about the quantity of evidence, but the quality of the evidence. The evidence that comes from in the form of testimony from that witness stand and the corroborating exhibits of evidence that you have seen and can still have an opportunity to review if you choose to do so.
I wouldn't have played that argument. Quality of evidence.
Yes.
So a little more coaching here. This is embarrassing. Honestly, this is embarrassing. We have a grainy silhouette of somebody Travis's height or Tucker's height that's walking down the road with Rory Wilson, and that's their corroborating evidence. It must be Tucker.
The defendant in this case, during his closing
says
statement, asked you not to believe the statements that the state played for you at the hospital the night of the incident. She may have been under the influence of narcotics. Maybe her memory wasn't clear. I would submit to you, using your common sense, her memory would have been more accurate closer to the event than years later. If you really look at all her statements throughout the life of this case, through the life of these crimes, it has been consistent, but for, at the end, she says it wasn't Ty Tucker. At the end, she never said that in any of her other previous statements. Again, the devils are in the detail. Ladies and gentlemen of the jury, I would submit to you the details in this case point to Franklin Tyrone Tucker as a person who robbed, murdered, or at least participated in the crimes that you've heard here. And I would submit to you, when you get the instructions of law from this judge and you utilize your common sense in weighing the evidence and evaluating the evidence in this case, You will have one verdict and one verdict only, and that verdict will be guilty as charged. Thank you. Thank you, Your Honor.
Okay.
Thank you, members of the jury, for your attention throughout our a little bit longer than usual morning session. But as I explained to you earlier, I thought it important for you to be able to hear the closings from everyone uninterrupted, which we've now accomplished. And I'm going to give you a lunch break until 2 o'clock. You know, all the usual instructions that I've given throughout, they still apply. I'm going to spend a little more time with the lawyers during that hour and 15 minutes which intervene.
What happens?
But when you come back, you're going to receive
get the
closing
instructions.
instructions from the court, whereupon you can begin your deliberation. So enjoy your lunch, 2 o'clock, and we'll go from there.
Hey, I don't think he made it clear enough to them that they're not supposed to talk about this case quite yet. They still cannot talk yet. He said, whereupon you can begin your deliberations, but Tucker's frustrated. You can see it. He is, this is bad. I was about to start with a verdict clock, or a watch, but we have to talk about some of the instructions a little bit. I think they have to finalize all the bracket stuff for the printout for the jury. Let's see what happens here.
Okay, the jurors are gone, so I believe our understanding was that over the lunch that the state was going to make the changes to the jury instructions that we discussed during the charge conference. So that would mean to me that we need to get here, 20 minutes, 15, I don't know how long it's going to take you to do this, and I don't want to create unnecessary time pressure.
Judge, I don't think that it's going to take that long. I gave the corrections to Ms. Malcolm. She's already been working on them. I think I just have to draft up the ag assault and the pro se instruction for that.
So if we come back at 1:45, that ought to give us 15 minutes to review.
Yes, sir.
Okay, and we'll have packets for
the court and one for Mr. Tucker. Yes, sir.
All right, so we'll be back at 1:45.
Okay, so jury instructions come after this, and then deliberations, right? Is that going to be the order we're going to be at? Because we haven't done that yet. Oh man, I keep thinking we're ahead of where we are. How did Tucker do on his closing? I'd love to hear what your thoughts were on that. I think there were moments where he hit his stride and his argument was strong, that his rationale, his reasoning was clicking, it was resonating. I would say the downside of that is I do feel that he wrote his closing during the defense's closing. He was responding almost entirely. He was responding to the defense's closing. The downside of that, the weakness there, is if the defense doesn't address something that's glaring and you don't respond to it, then when they come around for round two, they can hit you with it, and you've not addressed it to them. So it can be risky. I think he did a good job covering it. I realize that Tucker's lived this. Tucker's lived this since since a couple days after this happened. This has been his life. The events that have happened to the people, all those things that we haven't heard about, that is very much present in his mind. And so when he makes a reference to something, and he's talking about Paula Phelps, or why, there's a very good reason, it clicks in his head. He knows why. The jury doesn't know what he knows. The jury doesn't know what we know, and we don't know nearly as much as what he knows. This is why it helps to have a lawyer to make this argument, because they can look at it through it, using training as from the vantage point of somebody who has not heard this story before, who it's the first time through, and they understand what needs to be explained and what gaps need to be filled in for them because they don't have that prior experience. I think he did well. As far as pro se goes, he is the best pro se defendant we have ever watched on the trial. There are moments he's done very well. I think he improved throughout the trial, which we generally see. It's a rough place to learn the law, but he did improve throughout the trial as well, even making timely objections during closing that were sustained. against the state. That's awesome. That's huge. So often we hear the judge say, it's not testimony, it's fine, just let him go. You've got the two polished lawyers ganging up on him. That's awesome. Hey, what's that? Oh, yeah, I'd love some. Thank you. Egg rolls for lunch, I think, out of the freezer. See, Karina says, all right, he did well for the most part, but it didn't seem like he was well prepared for issues that he could have said. He got in some turmoil a little bit and he repeated himself a few times. He did. But that also goes to his, look, I'm not a lawyer. And this is the funny part. He had so many improper comments that he made, like his statements that...
Call from
created by EJF.
Hey, EJF, let me finish this thought, and then I'll welcome you in. Is that all right? Okay. Hold on. He had so many thoughts.
Yeah.
He had so many arguments where he would say, there's a reason why I can't go into this, and they don't want you to know this, and they were objected to, and they were sustained every single time. It was wrong. But even by making the argument and then the objection, he got it in. The bell was rung. The jury's like, why can't he talk about that? Why are you guys ganging up? I'm curious. And you're like, no, don't talk about that. Objection. You can't mention that. And then the state in their closing, they're like, and you didn't see any evidence. They didn't say there is no evidence that they say you didn't see any evidence from this witness stand. They couched it in these little brackets from this stand. They qualified it. And yeah, it's sneaky words. EJF, thank you for calling. What's on your mind today? How do you do?
Okay, so two things, I think. One, I think you did a great job, especially for being so emotionally invested in the outcome of this trial, because it is literally his life. Mm-hmm. It's kind of like how surgeons don't operate on family members. It's hard to take yourself out of that and be able to see rationally. I think you did great. That's a good take on that. And then I have one other question for you. Yeah. His wife said when she called the other day that one of the reasons they decided to do the pro se was to get the attention on the case and that, bring light to the case so that it wouldn't be swept under the rug and it would be on camera. Right. Do you think she was right? Yes. Would we be here watching this case if he didn't do that?
If this was not a pro se case, there would be no video.
Yeah.
This is a little.
It would be totally.
It's a no name. As far as his wife is a notable figure, I guess you could say. But as far as that, the participants in the trial, they aren't known locally. Beyond their local world that they operate in. It's an old murder trial. It's not fresh on the radar. There's so many other things going on. There are so many other huge cases. But you say pro se in front of a murder trial. Right. And all our ears perk up. Yeah. And we're like, yeah, I want to see that. It might be a train wreck. It might be awesome, but I want to be there for it. So I think it worked.
Yeah. And as awful as this is, it's the reality that a lot of murders from this, how do I say this group of people don't always get the attention that,
Yeah, if you have,
do you know what I'm saying?
If the story is that a drug dealer, stabbed one of his clients, or a client stabbed a drug dealer, that's not front page news, right? That's like and in other news, and you flip through so that the facts of the story, if you view it like that, two drug dealers, that drug deal went bad, robbery ended in murder, happens all the time.
Right, but Matt's life was still important.
Yeah. I agree, and they haven't mentioned him at all. I would say a couple of you pointed this out. This for a murder trial. Have you ever seen a closing where they don't mention the victim? I mean, it's like we're charging with murder, and none of us know what Matt looks like because he hasn't been featured.
You're right. They haven't put a single picture of him up there. There were a few times during the trial when I had to try to remember what his name even was.
Yeah. And the prosecutors got it wrong several times. They struggled with names throughout this. They were swapping names.
Although the devil's
devil's in the details, right? But there were times that you will hear them say Tucker instead of Travis or Travis instead of Tucker. And Paula and April, I think, got swapped, interchanged a couple times, and Rory and Travis and Rory and Tucker. The names have been like shuffled like a Rubik's cube, and as stories are told, you're like, oh, I think you meant Travis. It's just a mess.
That was in the details.
Yep. EJF, thank you very much for that. Appreciate the call. It's always good to talk to you. We'll see you.
All right.
Yeah,
Have a good day.
Bye. Jamie says, love it here. 5 months. Thank you. Thank you, Jamie. That's awesome. We've also got Gerda K says 3 months. Time flies when you're having fun. Thanks for the fun, Gerda. Thank you. If I missed any of the other messages that came through, there might have been a couple super chats as well. And I'm sorry about that. I was engrossed in the closings. They were awesome. Here we go.
Call from
Jules.
Hello, Jules. How are you doing today?
Hi, how are you?
Good. How's the weather down in Florida? Is it warming up today?
It's almost 80 degrees.
That's awesome. It almost doesn't feel like it was nearly freezing last week.
I know. I had to put my AC on last night.
Yeah.
Anyway, I have to tell you, I was quite surprised that he did as well as he did in his closing. I was afraid he was going to blow it. The only thing I'm disappointed in is I wish at the very end he would have said, I did not do this. I was not there.
It wasn't me.
I think that, it wasn't me. I think the jury really needed to hear that. And I don't know, maybe he was all caught up in the whole reasonable doubt. I think he did a great job on the reasonable doubt. And the state's attorneys, oh, Scott, they were so bad.
the opening statement, the most reliable evidence you heard in this case was from Travis. I'm like, excuse me? Excuse me? Their informant who lied to them, then changed stories, admitted, thank you. Egg rolls have arrived. They're too hot to eat right now, but I'll hold them. It just seems like that's the one you're going to go with. You're not going to say our investigator, our detective was most reliable. Our DNA expert,
right.
the evidence you heard from the medical examiner was the most reliable evidence. You're going to go with Travis Johnson. He's the top.
Who got a plea deal.
Yes. And in the closing, what reason would he have to do this? What reason would he have to point the finger at Tucker? It's like, well, I can think of about 99 to life reasons that he would want to point the finger at somebody other than himself.
Do you think? Well, I have a question, Scott, for you. I don't know. Do you think it was a bad look on the state's attorneys with all the objections and then calling for a sidebar, especially to consult with each other?
I think there was more to it than the consult. There was a time when he took a break and went back and whispered with his. It does look bad. You do the optics of, if you're just weighing the scale of the two sides of the room, you have two heavyweights, and I'm not talking about his size. I don't realize that Mr. Mansfield's a sizable character, but you've got two heavyweight lawyers on one side, seasoned veterans of the court, and you have this other guy who is trying to find his way blindly. And, he's got the walking stick and he's bumping around and making mistakes. But throughout the trial, trying to be respectful, apologetic when he does something wrong. And he's just like, he looks sincere. And then you have these two other guys that are just there to smash him. And it's, I think that wasn't lost on the jury. They've got to be looking at and saying that was the weirdest case I've ever heard of. I mean, if they've ever watched a trial before, if they have any experience, if they've ever served a jury before, and they say, sorry guys, I was on a case before, and I've seen evidence before, and this is not it. This is not evidence. This is a lack of evidence that we're seeing. But so hopefully we've got somebody on there that's got some jury experience.
Hopefully, and if I was on there, I would have no choice but to say not guilty. But that's me, and you never know what a jury is going to do. You just don't know. I don't know, but I think that the state ended on a bad note today, my opinion.
I agree. Thank you very much, Jules. I'm going
You're
to
welcome.
pontificate a little bit more here, and we might take some more calls. But
have a great day, everybody.
Thank you, Jules.
See you after lunch.
See you.
All right.
Bye.
Bye-bye.
I will say there were a couple things that Mr. Tucker said. Like I mentioned before, there's always been those little comments that seem to go too far, or seem to be worded in a way that's not favorable to him, that didn't need to be there. And one of them was when he said, if I were to tell you something, that would be a lie too. He said two at the end. I'm like, that means there was something else that was a lie. And I think if you go back and look at it, there's another way to look at it. But it was just an unfortunate phrasing that could come back and bite him. And I know Mike mentioned that. Big Mike goes texted me, and he heard that, and he's like, I heard that little too. I wonder if that's going to come back to bite him. But I listened as well. Coops just gifted 5 memberships. Thank you very much, Coops. I appreciate that. My girl Angie says 9 months. I love this group. Glad to be here. Thank you, Scott, and everyone for making this a great channel. Thank you very much, my girl Angie. Thank you. Congratulations on 9 months. That Orange Courthouse is not far away. We also have Dreamscape says, I think those lawyers were peeved that a non-lawyer showed them up. 5 months there, Dreamscape. Thank you very much. Yes, they were frustrated. They are very frustrated. They have all the law and all the experience, and they were at times very flustered doing this. It was funny. T says, I can solve a Rubik's Cube in under 40 seconds. I taught myself during lockdown. You and my son, T. My son has one, I think he got one that you push, the phone's ringing. You push the button and it shows you the colors, and then they go dark, and it's like all the same, and you have to solve it.
Dana.
Okay, hang on 1 second. Dana, welcome. This is RA. How are you doing?
Hey, Scott. Thank you so much. I will not take a very long time, but
that's okay. You don't have a timer yet. It's just Ivan so far.
Well, I know you're so busy, but I just wanted to maybe give a little bit of like, you know how like let's just say you have to have like a conversation with your kids or with, your spouse, and it gets heated, and you think you got all your points out, and you walk away and you're like, I should have said that. Why didn't I say that? And you're angry. Yeah. Imagine what's in this guy's head after years of like studying this case. And then of course there are so many like side things going on that he couldn't talk about. But if you look up this case that's going on, so I think hyper focusing on him saying, I didn't do this. I feel like the way he, just like the little things that you catch, I catch that too. But I feel like people phrase things differently. And I feel like the way he presented things, like, I feel like he thinks that's obvious. Now, we watch trials as outsiders. Like they're just things that we want to hear. But even we've heard how many times, like, I don't know if you guys, like the Bradley Yawn case, and, these guys are like, it wasn't me. I didn't do this. I did not do this. Well, that's what you expect to hear regardless. So I don't know that it would have made that much of a difference. I get that some people think that's like a mic drop, but in my opinion, I feel like everything he was saying, he said, I was asleep. Like I passed out. So I think that he thinks that that's a given, even though I understand sometimes people feel like you need to hear those words, but then I think we hear them, we've heard them. So I watch interrogation videos and stuff. You hear that so much that I hear it and it doesn't even faze me, because it's like, that's what you expect somebody to say when they're saying they're not guilty and fighting. But that was just my opinion on that.
Dana, that is a great take. I appreciate that. You have a great voice and great analysis. We'll have to get you on here again, maybe as a guest sometime.
I always appreciate you taking our calls. I truly love being in the chat, and when I get a chance, I'm going to join. But I just wanted to say, I just wanted to give a little bit of clarity to that, because I know that that's something that people feel like, yeah, he didn't say I wasn't there. But I just think that sometimes, I'm sure he's going to beat himself up for that, but I feel like he thinks that's a given. I think that people should be. Go ahead.
I was going to say, I think he probably is happy with that. He did have plenty of time. He thought it over. He had all his points. He hit them. He did a good job. I don't think he's looking at himself now. He switches to his lawyer hat and he's like, well, I should have done that.
I agree. So, I do think that people should be outraged that
this
the
could
state
happen.
Would go through. I really do believe that. I really do believe, and I've watched cases, but I think that it really should. He's right. It should scare us as citizens that I'm not saying anything about the police department and obviously there are some issues there, right? They're noted in cases, even though it wasn't brought into trial.
Sure.
Yeah. So I do think that it should be very scary to us as citizens that if we get a target on our back for whatever reason, and they want somebody to target you and they get their sights in on you, that they will fully go after you with no evidence and bring it to this level. I think that that's scary. I think that should be infuriating and scary for us.
Yeah, and Tucker brought it up. It was objected to, and it was rightfully objected to because it's not an appropriate argument. But he did say, you as members of the jury should be scared because this could be you. And
I do agree with that. I really do, just as a lay citizen and watching this. And I get it that he definitely comes across in some, I feel like yesterday, I've banged my head against the wall so many times because sometimes it's the repeating himself and talking, but I just feel, first of all, I have ADHD, if you can't tell by me doing the same thing. So why don't I not? Yeah, but I do think I can't even fathom. I have a son with special needs that keeps me really busy, and he's nonverbal, and he can't, he can't do anything for himself. And so it's my brain all the time is thinking is he cold? I got to put a blanket over him. Did he eat? When's the last time I've given him water in his G-tube? All of these things. And I'm a whole mess all the time. I can't even imagine trying to manage my life plus a murder case and then keep my thoughts straight and come across, dress the part for for court and make sure I don't step on anybody's toes. And I'm an I'm sorry person all the time too. I pace. So I think that's just a lot of pressure. I know that he did it to himself. I recognize that, but I also think that you got to give a little grace in this situation. And I respect the fact that he decided to get more eyes on it by going pro se. I hope it works out for him. I hope that it works out. But I thank you so much, and I'm sorry I took so much time.
Dana,
me apologize.
Dana, why don't you have your own show? I'm not saying that in a bad way. You have a great voice. You have a great analysis. Where are you starting your YouTube channel?
I just told you I barely make it through. I don't even know. I think my son non-verbally looks at me every day I can't believe you're in charge of me. I can't believe that this woman is in charge of my well-being. How did that even happen?
Well, Dana, thank you.
I can't even imagine trying to manage anything else.
Thank you very much.
I'm so grateful just to have your community. Thank you so much, Scott.
Appreciate
You're awesome.
it. Call anytime. Appreciate you.
Bye.
Bye. I've missed a couple calls during that. I apologize. Thank you very much, Dana. Great analysis. I'm on board with everything she said. That was really insightful. I appreciate that. And props to her. She didn't mention it. She said nonverbal. I'm not sure if it was autistic or something else. But props to her for caring for a son that has some special needs. They are a blessing and a challenge at the same time. Amazing kids. I don't have any in my immediate family, but my close relatives, we have some that are in that category. Oh, we've got an international call here. Let's take this
call
one.
From
Welsh lady.
Welsh lady, how are you doing?
Hello, Scott.
Hello, how are you?
I'm a bit on a lag, I think.
A little bit. It's a long connection all the way over to Wales.
It is, right. So I'm going to make it quicker than my email I sent you, okay?
Your email was great. It was very long, but you're right. They did hit all those points.
I hit on the judge with his attitude towards the beginning and the middle of the trial, and then I was surprised, mind you, by his turn yesterday, so that did take me back. But the prosecution, like I said, two seasoned prosecutors to be behaving in the manner that they are. We're not just watching Tucker on trial, we're watching them. They're coming through the screen too. And I haven't found them very professional in comparison to other cases we've watched.
Yeah.
And today, I don't think they did any more for me than that. I think they were quite petulant at times, and with the sidebars.
Yeah.
And with Tucker, there's something I noticed about Tucker you said, about the way he speaks. And he says, as if he puts himself in the crime, right?
Right.
What if this is because he's read all the discovery, and he's read as, well, we went into the treehouse and we did this. And so he's kind of relaying it still.
Mhm.
Does that make sense?
Yeah, definitely. If this, I mean, this has been his reality. He's dug through this. This has been his only reading material for the last 7 years.
Yeah.
Has been police reports and depositions and, you know, everything that's happened and the dates and calendars and watching videos.
Yeah.
This is his life. And so I think,
Exactly.
so I give him credit for that. At the same time, it comes back and bites him a little bit because I think believes that other people might know all that as well, or at least understand or be able to connect the dots the way he can because of his familiarity with it. And so I think that that hurt
and
him.
the other thing I think that hurt as well with him, as there was another thing that obviously I'm in the chat, I see the chat, and I see so many people saying, well, you got to say, I didn't do it, I wasn't there, it wasn't me. And I want that, but then it made me think back to yesterday, and when he was on the stand, and he wanted to speak about his own test and his own interrogation, and they said it was a self-serving hearsay statement, and I'm wondering whether he may think, I'm not able to say I'm not this and I'm not that, because that's self-serving.
I bet.
That's just something
almost,
I wondered.
You're right. Almost everything he wants to say is not allowed in court. All the stuff that is so pertinent to him is not allowed. And what a frustrating thing you basically got the hands tied behind your back and then you have to defend yourself. It's awful.
It is. It is awful. Thank you for having me on your show. Thank you for all the lovely people in chat. Go on then.
Before you go, can you say the longest word you know in Welsh? It might be a city name.
You want me to say the places that... Listen, I'm from South Wales, so we speak a little bit differently, but you were on about the Lanfair with the train station, I know. That's the place with the go on the end.
That's the one.
Right.
Oh, that's wonderful.
I can say that panhead is in order, and that's a cup of tea. Panhead.
I'm going to need the translation. I heard cup of tea. Thank you very much, Welsh lady.
Yeah, it's a cup of tea.
It's a cup of tea.
You take care, Scott. Thank you, everyone. Take care. Bye-bye,
see ya.
Mrs. R.A. Bye-bye.
Bye-bye. That is great. That is great. The accent is wonderful. All right. I know there's like the longest town name in the world is a Welsh town, and it's like the sign is just like board after board after board, just like nailed to each other wide because it's just all, and they're all L's. It's like the whole town name is L-Y-L-L. Yeah, it's a funny name. Someone's going to type it in chat, I know, and then we can view it together. I'll post it. First person in chat that types the town name and gets it right, I'm going to go ahead and post it. But anyway, wonderful. I appreciate all the takes on this and the insight. Oh, there it is. Culperistic. I'm going to show this one. Boom. I think this is it. And then I lost it. I lost it right around Googery. But it looks like something like Chernobyl will stand till us go gawk. Someone typed it. I bet, Culperistic, that you did not copy and paste that. You just typed that from memory. Please tell me that's correct. All right. Let's see. Someone typed it. That might have been another one earlier. If you typed it before, I think someone did. There were some comments that I think actually the spam filter cut it out because it recognized it was not a word. So why is the chat not updating? I think we broke chat. I think we broke chat. That was too big of a word. All right. That town's name is wider than the train station. That's incredible. Thank you, KKD. Good to have you here as well. You sound like a Beatles record played backwards when you pronounce that name.
Is that correct?
That's correct. All right. Let's see. We have just say go. That's they abbreviate it to the last 6 letters. That's cheating. It's cheating. I think it should be a law in that town that anytime you mention the city, you have to say the whole thing. I turned the sounds on, and you guys are playing them all. Let's see. All right. Where were we? We're currently on break. Let me show you where the court's at right here. Boom. There they are.
Somebody just sent me a video of roaches fighting. I don't know who won.
I don't know who won. I promised I would take bathroom breaks today. I will. I'll just, but I don't need to yet. I can't just take a break when I don't need to. I do have lunch today. I've got 2 egg rolls to eat, and they're almost cold enough that I can pick them up and eat them like a heathen, because utensils are not for egg rolls. We are where we're at. We are in the trial. We have ended the closing arguments. The state has had both their opening and their closing, at least their part 1 and part 2 of their closing arguments. Mr. Tucker was sandwiched there in the middle. Mr. Tucker went, I would say he took about half the time that was allotted to him, maybe a slight bit over half the time. And the state used the majority of theirs. The jury is going to hear jury instructions. I think they have to work out to make sure the paper is all right. They're going to come back. The lawyers are going to come back first. They're going to make sure all the instructions are correct. The jury is going to be read the instructions when we come back from lunch, and then they're going to be sent to deliberate. And so we have a poll out right now. I'm going to go ahead and close it because we've had a lot of people vote on it already. We've had about 1,620 votes right now. This is a poll for how long will the jury deliberate. We said less than an hour. We have currently at 16%. Actually, the voting still open, so this is fluid. 16% say less than an hour. 1 to 3 hours at 60%, and 3 to 6 hours at 14%. With "will be here tomorrow" with an extra B, only 9%. So, looks like the majority of us think there will be a verdict tonight, which is Wednesday when we have all the meetings. So. Of course, there's going to be a verdict on Wednesday night, so I might have to skip my meeting. But I'm the driver. This is the problem. Hank Blatt says, "Hi, 4 months. Welcome, Hank. Thank you very much. Appreciate your support for 4 months. When is the last time you did the water ASMR and mine did the laptop? Hydrate. I'm out of water, Cachette. If you could send a note to Mrs. R.A. that we need more Deer Park water, that would be great, because I can't drink anything else." Let's see. What shall we do while they're deliberating? We may be doing some court hopping. We've got a couple trials going on. Judge Wolf has a murder trial going on that we may be jumping over to. It started yesterday. We might be picking that up. Let's see. We've got another call coming in.
Call from
EMF 42.
EMF 42? Is that who it is?
EMF. It's an honor to talk to you, Scott.
EMF 42. It's an honor to talk to you as well. I still missed your name. It's a little fuzzy in my ears.
Oh, it just Murphy, but no Y.
Oh,
Murph, and then
Murph.
42.
I thought
is
you were
like
saying
the universe
letters
and everything.
Murph 42, like from the Douglas Adams Hitchhiker's Guide to the
You got
Galaxy
it.
reference. Never read that book. Don't know what you're talking about.
It.
Orange. Okay, go on.
I highly doubt that.
What's on your mind, Murph?
First of all, I've really enjoyed watching you grow so quickly. I found you during Maya, and it's just amazing to find this community. It's a great place. I have a question about the new jury rules in Florida.
Okay.
Didn't they change, you don't need it to be all or nothing? And is that only for death penalty cases? I was upset by that change.
Let me look. I know there was a change, but I thought it switched the other direction.
I'm hoping it will behoove Mr.
Hoping it's in his benefit. Let's see.
I really do. But I fear that it could be, it used to be all you need is one guy and now you might need 4.
Unanimous juries are no longer required for Florida death penalty sentences.
Okay.
It's just death penalty, I think.
Well, that's good. I guess.
Which is weird.
I'm not wild about that either.
So you'd need unanimous to get life in prison, but not to get death.
Right. Doesn't that seem counterintuitive?
I think what they're probably addressing there is the fact that that the death penalty in general is becoming less popular, and a lot of people who may sit through a trial and hear somebody hear testimony that means somebody is guilty of murder and they're being charged and it's a death prosecuted with the death penalty, they might say yes, he's guilty, but I'm not okay doing a death penalty for anyone. And so you might have somebody who says, no, I won't vote that because of that. I think that's what they're getting at. But it does seem strange that they have, under Florida's Constitution, criminal convictions require unanimous verdict, but then not for the death penalty.
I do know that it was because of the Stoneman Douglas shooting, and I think people are pretty upset that a very, very young adult wasn't given the death penalty because there was one holdout juror that might have misled them, saying that he or she would vote that way and then decided not to. And so, of course, one case means let's change the whole law forever and ever.
Let's make law based on an exception. Let's do that. This is a good idea.
It's
What
just,
could possibly go wrong,
you know,
right? Unintended
we can
consequences.
Florida,
man.
That's it.
Murph, that's crazy. Thank you very much for that. I'll have to dig more into this a little bit and see why and what. I haven't read enough about that. But thank you. Any more thoughts on this before we let you go?
I'm just stunned that there's no Supreme Court to come in, and I'm just stunned that one guy can go, nope, I don't want it like this anymore, and nobody intervened. They're just like, yeah, that's good with us. Like, it just doesn't make
Sounds
sense.
good.
But the world is so complicated now.
It makes sense, according to the prosecution.
Yeah,
it makes
right.
sense.
Right. But you're amazing. Your wife is awesome. I really enjoy you, and I can't wait to bother you again in the future.
Wonderful. Wonderful. Do that. Thank you so much. Good talking to you.
Have a great day.
Yep.
Bye-bye.
Mohabbat22, welcome to the gallery. Brand new supporter. Thank you. Make sure you take a seat by typing ! Seat in chat. We have reserved seating for members. Let's see. Where are we at? I missed another message. Let's see if I can find it here. Where was it? Hank Blatt. I got that one. Did I miss somebody's message? I'm sorry. I'm doing terrible at this.
Have them send someone with more experience.
Boone back here said the name we were talking about, the town name means the Church of Mary in the hollow of the White Hazel near the fierce whirlpool and the Church of Taisilio by the Red Cave. That's a lot. That's a mouthful.
Call from
Alice.
Is it Alice or Alex?
Alice.
As in...
like in Wonderland.
In Wonderland. That was going to be my reference. Alice, how are you doing today? What's on your mind?
Hello, I'm all right. So I am a Floridian, so I have some insight
So
on...
you give that disclaimer right there at the front?
Yeah, for the death penalty thing and Key West.
Oh, yeah, please let us know. What was the death penalty? So explain that one more time just so we understand. No unanimous verdict required for the death penalty? Is that only on the sentencing, or is that separate from the conviction for murder?
So the death penalty is kind of a two-part trial. So first, you have to be found guilty, and then they have a second part for if you are going to get the life sentence or the death penalty.
So let me spell this out then. That means the first part, to see if you're guilty of murder, it still has to be unanimous. 12 jurors agree.
Yes.
But then on the sentencing phase, that's when it doesn't require 12 people to agree for a death penalty.
Yes.
That's a little better.
And the change was made because of Parkland, because it was said that Nicholas Cruz supposedly, because we weren't in the jury room, that there was one holdout, and it became, everybody that I know in Florida, and even people I know outside of Florida, were absolutely horrified that someone said no because of how graphic it was.
Right. That makes sense. Thank you so much for the clarification. Thanks for breaking the mold when it comes to Floridians as well, as we're watching some crazy things in the news with various different cases around Florida. So appreciate that.
Yeah. With this case specifically with Tucker, I noticed some confusion in the chat. Tucker is extremely Key West. Like, that is just default Key West person. the lifestyle, everything, it's extremely common. How he speaks, it
to me, it wasn't very shocking because that's just how people seem to be.
So he may have resonated with the jury, who are probably also from Key West, in that area, because that's how it works, better than the prosecutor did.
Personally, to me, I would not be friends with him, but his actions and the way that he behaves, it's not to me, he doesn't come off as badly as some of the chatters.
Yeah.
And the way that he's over-explaining himself and keeps repeating things and it's not quite clear, to me that comes off as somebody who just, when you do public speaking class, it can be very easy, but as soon as you have to present something that actually matters, you get all stuttery and you can't find your words.
Every day, I understand how that goes. Yeah, I hear you. Yeah, great thoughts.
That's
great.
how it comes up to me.
Thank you very much. I appreciate the insight. Thank you so much. Stay cool down there in Florida. So enjoy the good weather.
We're trying.
All right. Have a good one. Thanks so much. We'll see you.
You too.
Bye.
Bye.
That's awesome. Let's see. Vicky says, 1,000%. I did radio for 8 years, and I hate public speaking. Samantha Terry just comes in with her 12 months of support. As jury member, one of our great mods as well. Absolutely fantastic. Thank you so much.
Call from
Patty B.
I can't hear.
To accept,
Patty
press
or
1.
Hattie?
To send a voicemail.
Hello, is this Patty?
Yes, hi. I'm super nervous.
Hi, I'm nervous as well. I was afraid I got your name wrong. I was thinking it was either Hattie or Patty. So, how are you doing, Patty?
You got it right. Good. I just want to make a quick comparison because I watched the trial before this one where I was very nervous about the jury not coming back correctly because there was no certain cause of death, and that was the main point. They couldn't prove that cause of death. And it ended up coming back a verdict of not guilty for that, but they did come back guilty of concealing a death. So we, and my point is maybe we just need to trust the jury and believe that they will do the right thing, because if they follow the law and evidence, maybe they will come back with the right verdict. But then again, juries are unpredictable and you don't know.
If they come back with a not guilty verdict, I hope that camera in the courtroom rolls for an hour until everyone is out of the courtroom, because I want to see Tucker grinning from ear to ear and shaking hands with the prosecution afterwards saying, good try. Good try.
I really want the prosecutor to get his butt handed to him. I think he was very condescending, rude. The objections through the closing, he's pro se, he should get a little leeway. Yeah. And this prosecutor is just cutting him off, you know. We shall see. That's what I wanted to say.
Thank you so much. I appreciate that, Patty. I will say that I thought some of the objections, some of the things needed to be objected to. There were some really, I would say, egregious errors that if that was another lawyer doing that, I think we would have heard the word mistrial being thrown out. So I think he did get some leeway there, but still, I'm not a big fan of the prosecutor. Patty, thank you so much.
I don't think anybody is. Thank you. All right, bye, guys.
You should never feel nervous. It was easy, right?
Yeah, I just turned my TV off the phone and just figured I'd call Face My Fear and just do it. So Thank you so much.
And
for
now
being
next
kind.
time will be even
Bye,
easier.
Pat.
Thanks, Patty. We'll see you.
Yeah.
Bye.
All right. Bye.
All right, I forgot to read this one out. I am captivating. Eve5 says, I'm still loving it here. You can't get rid of me now, RA. Thank you very much for 10 months of support there. I am captivating. Appreciate that. Let's see. We're going to work through lunch. And I have to say, I was about to, while Patty was talking, I was about to taste my lunch, right? And let me show you. I'm looking, I'm like, oh, that looks good. And then I turned it and I look, someone has already taken a bite off the end of my egg roll.
Call from
Megan Easton.
Hey Megan, do you have a little story you want to tell us while I eat my egg roll and a half?
Oh my goodness, yes. I have so many stories.
All right. I'm going to let you talk while I try to get a little bite of lunch in. Go ahead.
Okay. Now, what story should I tell? Oh, I have stories for both. So my new doctor's appointment went great. Turns out my doctor's great.
Okay, let me give you some guidance. Tell me what you think about the case so far. What do you think about the case so far?
Okay. I think that Tucker did a good job. He did a good job. I think if the state, if they find him guilty, I'm going to be very angry. I'm going to be really, really angry because they didn't prove it beyond a reasonable doubt.
Megan, you're killing me. Oh, this is funny.
I know. I'm laughing too. It's okay.
Yeah. Let me bring Mrs. R.A.'s on here. She wants to join with us. Are you okay with her joining as well?
Oh my God, I love Mrs. R.A.
Okay, here we go.
Of course.
Thank you. Okay, who is this?
This is Megan Easton.
Megan.
This is Megan.
Okay, so.
Hi, Mrs. R.A.
Hi, how are you?
I'm doing well. How are you?
Good. I'm just standing in here so Scott can stuff food in his face right now. Okay, so tell me, how do you think this trial would have gone differently had he not gone pro se? How do you think it would have affected his odds of winning?
If what?
If he had gotten a lawyer and not gone pro se, how do you think that would have affected his odds of winning or losing this case?
Oh, I think he would have absolutely won. Absolutely. But I don't even think we'd still be here if he had a lawyer.
So you think he slowed it down to be pro se?
I do. I think he heard his case. And I'm going to say this. I've been on the other side of the law in the past, and being innocent, I would have taken that deal of time served because, I mean, you just do that. You just take, if you can walk away scot-free, that's what you do.
So I am a little behind on that. They offered a deal that said, hey, we're going to say you're guilty, but the time you served is sufficient and you can walk away. Is that what they offered?
Yes.
And he said no.
He said no. He said he wanted to take it to trial and defend himself, which, I mean, I understand wanting to clear your name, but I also understand that freedom is a lot better than jail.
Yeah.
And it is. It's a lot better. I mean, the brain is not that good. The beans are really bad. So I understand, but, you have to play the pros and the
food
cons.
reviews on jail? Is that what I'm hearing, Megan?
I didn't prefer Bean Day. That was never my favorite. The only sandwiches,
That's funny.
Megan.
Soggy bread.
Megan, that is
Oh,
awesome.
Yeah.
Is there anything else you wanted to share, Megan? Thank you so much. I appreciate it.
No, I wanted to get the microphone all warmed up for future because she's about to call in, I think.
All right. Sounds good. I've got somebody calling. Thanks a
All
lot.
right.
We'll see you. Bye.
Thanks, guys. Bye-bye.
I missed that last thing she said. She needs to get a microwave.
Call from
VTEAM.
To accept, press 1.
Hello, I've got V-Team on the phone. This is Scott.
It's Vicky McCullum.
All right, Vicky, how are you doing?
I'm good, thanks, and you?
I'm halfway hungry. What's on your mind?
And where are you calling from?
Sorry.
What is this accent?
From South Africa.
Oh,
Awesome.
sweet.
Vicky, that's great. What are you thinking of the court case today? What's your takeaway with what we've seen so far?
My main question is how nobody has brought up that no person in their right mind would pay a getaway driver who left them at the scene.
They should have vetted him better.
Literally, that is the biggest piece of evidence.
This
if
is like-
he was supposed to do the job and he didn't do the job, why did he get paid?
It's like tipping. You do Uber Eats, right? And your driver shows up and he's eating your pizza.
No, this is a good point,
And you're like,
though.
well, you're here anyway. Might as well give you the money.
No, but she's saying, hey, they paid him
Exactly.
for something, and if it wasn't for driving away, what was he getting paid for?
I wanted to use the example of somebody else eating your lunch because I think
Okay.
this is all right. You ate some of
came
my
out
lunch.
of the bag like that, honey. I think we've got grounds for lawsuit right there.
Vicky, yeah, that is a great point. Add to this. Think of this: $50 gas money for driving 50 yards. You can throw a rock from one to the other. They're very close. They're not far apart. You can't really throw a rock,
Yeah,
but they're
I can't.
They're not that far apart, and they needed a driver. Yet they walk that distance all the time. The argument, it just didn't make sense.
That doesn't make sense. What were they? Okay, so give us an idea here. What do you think they were paying him for?
Well, the thing is as well that he said he had a wad of cash in his pocket and then needed $50 for gas money. That doesn't add up either.
You're saying that his story is all convoluted and cobbled together. Oh, and I still can't speak to the mic properly. Sorry. Can you hear me better?
That's much better.
Okay. So are you saying that you feel like his story is full of holes?
Yeah, and it's the easiest thing that he could have pointed out, that he didn't have to go into all of the other confusing things. If I was on the jury and someone said, would you pay $50 to someone who didn't do their job? Easy answer, no.
Right.
You did half the job.
Yeah, but you're probably dealing with unscrupulous people here. You definitely are dealing with unscrupulous people here. What are they paying him for?
Yeah.
Maybe to keep quiet, and $50 would not do that.
Yeah, that's a great point. Vicky, thank you so much. Thank you for calling from South Africa.
Yeah, excellent insight.
Call anytime.
Thank you, and petition to get a Wi-Fi version of the burner.
Yes. Something that's cheaper for you guys to call. Thank you so much. I will do that.
Sorry.
All right. We'll see you, Vicky. Bye-bye.
Bye.
All right. Yes, I need to do a WhatsApp version of the burner phone. We might get there.
I'm pretty sure WhatsApp is just for people who are trying to scam you. That's like the legal description of WhatsApp.
It's the Telegram one that they use. Let's see. Krista says $50 won't keep me quiet for 4 minutes.
I can spend that in less than 4.
Yep. So, Mrs. Ari, are you admitting to eating my egg roll?
I admit nothing.
Is that what I heard?
No. I think that it might have been poisoned. I'm protecting you.
See, WhatsApp is our primary service here, says Vicky. It works. It works. Vicky, I have WhatsApp. The problem is, from how I see it, I think it gives away like my phone number, like my other phone number, and I don't want that.
And our bank account.
Yeah, that would be even worse.
Call from
Hope in Tennessee.
Hope, this is Scott. How are you doing? Welcome.
Oh, I'm good. How are you?
I'm doing well.
Enjoying your lunch?
I did for briefly. I ate the half egg roll. I have not eaten the whole egg roll yet.
Well, yeah, the factory ate the rest of it.
I know. Seriously, what is with these crappy factories?
I'm not buying this. I'm not buying this for a second. Hope, what's on your mind about the case today?
Well, I'm 100% supportive of Tucker. You know, they have not proven anything as far as his guilt. But last night, just, surfing how I do, I run into his interview. And I'm telling you, he could have been impeached by what he testified about his knowledge prior to going into that interview. He said he only knew that someone had been stabbed in the parking lot of CVS. But on this interview, he starts right out by just unloading the tea that he knew about the drama in that treehouse with Paula, that Anathea.
But is that after he'd been interviewed, like at the police station?
No, it was the beginning of the police interview. And he said that before he was arrested, he didn't even know what that raid, not arrested, but detained.
Didn't know what the treehouse was.
He didn't even know what that raid was for. He assumed it was for drugs. But he gets into that interview after the raid, and he starts out just going on and on about how many times that Matt had been murdered, that he had been stabbed 7 times. Now, I don't know if that's true because I've watched the majority of this, but not every second of the evidence.
But that's an oddly specific detail.
I'll tell you, I have not watched this. I've tried to watch this as what evidence is admissible to the jury. And I realize there's a ton of stuff out there. I mean, there's not just, I mean, there's videos, there's people's takes, there's other interviews, there's all sorts of things out there. And the problem for me is a lot of that gets clouded. It gets cloudy, and I can't separate that from the facts if I watch it. So I try to watch just what.
And this
what
is
was
why
observed.
and this, I'm sorry to interrupt, but this is why you, as a juror, you wouldn't go looking for extracurricular, information. Only what is presented in court, which has me just really literally scratching my head right now thinking, why wouldn't these bozos, and I know we're not supposed to call names.
Yeah, who calls names?
No. And that's these bozos, why wouldn't they have impeached him with that interview? Because that is just, it was night and day, because Tucker said clearly he did not know he was under the impression someone had been stabbed in the parking lot.
This is a good question. Why, if they had that, why wouldn't they impeach him? That might be a good question for an attorney. And I think we might have Uncivil Law, Kurt, calling in, that might be able to give his thoughts on this.
Oh, I love Kurt. I actually watch him a lot. So that's awesome.
Good. Highly recommend it.
It's endearing. Okay.
All right.
Well,
Thank you so much for the call.
And I'm going to propose something. This is my conspiracy mind coming right out.
Okay.
But
Get the
tinfoil hat on. Go ahead. It was what?
Is this a psyop? If they have this, I mean, it's insane what they're bringing. Why they brought, how they could even have the nerve to bring this and present it. It's absurd. And I find things that are absurd is like often trying to get people's minds around accepting the absurd.
Yeah. Interesting.
So
that is
crazy
tinfoil
stuff.
hat stuff. I'll have to,
It is,
to
it
think
is.
that one over.
But,
Thank
all
you.
right, well,
thank you so much for your call.
letting me talk.
Not a problem.
Thank you.
We'll
Bye-bye.
see you. Bye.
Bye.
Well, and I said something similar to that. Sorry, what were you saying?
I was going to say we're going to leave some room for uncivil law for Kurt if he wants to
Leaving
call.
room.
Go ahead. Sorry.
I was thinking about how I feel like it or not, there is an attitude out there of guilty until proven innocent. And there's this idea that if you brought this to court, if you brought it to the law, then I got to assume that you have a lot of evidence and he's probably guilty. Otherwise, why would he be here? Right? And I know that's wrong. I understand that's illegal and it's wrong.
Call
We're going
from
to see if this is
Uncivil law.
There we go.
Okay. But my point, hang on one second, Kurt, I'm almost done. My point is that if that doesn't seem to be the case with this particular court case, and so if they start bringing things like this to trial without having the supporting evidence behind it, do we still ride that assumption that they must have something to have brought it this far, or do we start really looking into it and saying, I don't know?
Talking about the presumption of guilt by the fact they were arrested.
Yeah.
Kurt, I know you've been watching this. Thank you very much for your patience. That's my wife, whose voice you hear in the background.
Yeah.
What are
No
your
problem.
thoughts
Nice
as
to
you've
meet
been
you.
watching this one?
Yeah, I don't think the prosecution has anything close to beyond a reasonable doubt. I've been just truly amazed that they brought this case at all, because the only real evidence they have is the statement from their one co-conspirator. And despite the prosecutor continuing to use the word corroboration over and over, they don't have corroboration in a technical sense. And the defendant certainly tried to raise this point, although a lawyer would have gone into more detail.
Mm-hmm.
When we say corroboration in a technical sense, what we mean is evidence that exists outside the person's own statements that can be tied to the defendant. So him drawing a map of the crime scene is not corroboration,
right?
Because it's coming from his own mind. So you can't.
That's
it might be
still a
true,
single
but it's not corroboration, and it doesn't tie to the defendant. So corroboration would be anything. Like it could be a co-conspirator saying, "Okay, I saw him in this mask." Okay, how do we tie the mask to the person? Well, another witness, not one of the co-conspirators, another witness saw him in the mask sometime, or there's DNA, or there's sweat, or he wore it at a Halloween party, or anything. How do we know this is this guy's shirt? Someone saw him in it. He's on tape with that shirt. Whatever the case it may be. So we need something external outside that we can say this is the defendant some way other than it coming from the co-conspirator, someone other than that person.
So, Kurt, I have a question. How important do you think this is that that the defendant brought this kind of stuff up in his closing arguments? Because obviously he didn't. But how detrimental is that to him that he didn't mention this kind of stuff?
Well, I mean, he certainly tried to, so I'll give him part credit. He was certainly mentioning it wasn't bad as a closing argument, and I've actually been pretty impressed by the pro se all the way along. I've seen lawyers do worse, so he's doing fine.
That's a compliment. I've seen lawyers do worse. Let me ask you this: what did you think of the opening of the state when he gets up there and says that the most trustworthy, believable piece of evidence that you've seen is from Travis? Does him saying it make it so in the minds of the jury?
I wouldn't think so. No. I mean, this is a guy who, as they say, vacillated on the stand. Yeah, that's a charitable way to describe it. He vacillated. I mean, he couldn't figure out what the story was? You mean that kind of vacillation, as opposed to the defendant who...
I could feel his vacillation on the Richter scale. It was quite a bit of vacillation.
And it blew my mind when the prosecutor asked him about, didn't you tell the same story to the police? I couldn't believe he said that, because the defendant himself, when he was on the stand in his own direct, as he was given the narrative, tried to say that exact thing. And the prosecutor objected, hearsay. It is hearsay. You can't, the defendant himself can't offer it. But when the prosecutor asks the question, it's a statement from a party opponent. And the other reason the defendant can't say it is because it's buttressing. It only makes him look better. Yeah. So why the prosecutor would ask the questions beyond me? Because you're actively soliciting testimony that makes him look better because it's the same story. For what purpose? I don't get it. Yeah. It confused me.
Kurt, did you get a chance to listen as they were doing a little bit of the charge conference? Going over the jury instructions. Did you hear anything in there that a lawyer might have said, hey, I mean, that's probably a good idea to have that in, or we should add this, or is that not a big deal in your mind for this case?
Probably not a big deal in this case.
Okay, cool.
I'm sure the jury charges are technically sufficient. A lawyer might have poked around the edges, but probably nothing that will raise an issue. And as to this issue that the previous caller was asking about why the tape wasn't offered, I can only suspect the reason is because other portions of the tape, such as him telling his own story, would have been really helpful to them. And there's a rule of completeness.
Yes.
So if you bring it in, it's in for everybody. So why didn't they try to impeach him on these statements? Because, well, then it's in for everyone, and he can be, let's roll that beautiful footage where I told the police everything. It's like you can't object to hearsay at that point because the rule of completeness. So it's in for everybody or out for everybody.
Right, and it could have been the rest of that tape has them telling him about the knife and about the blood on the knife. It could have been that. Yeah. I mean, there's all sorts of stuff that could have come in. So,
Kurt, how serious is it that the judge failed to do the colloquy?
It could definitely be an issue on appeal for sure. Yeah, because he wasn't advised of his rights. Yeah, so there's a valid cause of appeal that has been maintained. Yeah. So that's nice.
So he's got to get out of jail free.
And also, even though it's and well, I don't know about that, but it's definitely a valid basis for appeal. And there's even a valid basis of appeal, although it's really, really difficult to make the argument, is just technical sufficiency of the evidence. Like that's basically what the defendant was asking about, and for essentially a directed verdict. Like there's not enough evidence here. Yeah. And it's like, I think a court of appeal might agree with that. I mean, that's really hard to do, because the jury gets to weigh the evidence, but, is there any fair way that a reasonable jury could weigh this to get beyond reasonable doubt? I have questions. Yes. So let me put it to you this way. Even though I know it's difficult, and even though I would expect to lose, I would not be embarrassed to raise the argument on appeal.
Yeah. Kurt, I know you're following this. I think they're coming back to court. Are you doing any live streams about this yourself? Today?
Okay, so
I did a live stream this morning. I can't this afternoon because I have an appointment.
So,
but I've definitely done streaming throughout. So hopefully, the jury will come back with a quick not guilty. And if they don't, I'm going to be a little bit irritated and disappointed.
Okay. Sounds good. We've got audio coming in from court now, so I'll let you go, Kurt. Thanks so much for calling, and appreciate you, my friend.
See ya.
All right, bye-bye for now.
Bye.
Okay, I'll come back at 2 unless they're here sooner. Let me know. Thank you.
Okay, so they're. I guess the jury's not back. I missed exactly what happened. The jury might not be back. I'm not sure if he's done with the instructions or not, but he's going to be back at 2. That means we've got 10 more minutes. Let me make sure that I'm current on everything. Yeah, I'm current. Okay. All right. Thank you. Thank you, by the way, Kurt. Everyone's saying thank you in chat. If you didn't see that, I appreciate you. It's always great to have one of our great friends in the legal profession who can come in and give us updates and clarifications and educate me and make me smarter. Amber, this is call number 2.
Hello.
If you're good on this one,
Hello.
I might take you off the naughty list. How are you doing, Amber?
I'm okay. How are you?
I'm smarter than I was yesterday, but we don't need to talk about that. What's on your mind?
You're the one that keeps bringing it up. Gracious. Okay, so I just want to do a little disclaimer real quick because I see several people getting upset, and I want to make something clear. When you decide a verdict, whether you decide a person is guilty or not guilty, it is not based on your personal opinion. You have to base your vote of guilt or not guilty on the facts presented in the case.
And the law.
So we have and the law. So we have some people in here that are very hardcore, this Tucker is guilty. And that is fine. If you think he is guilty, that's fine. But if you were to put everything from the trial presented as evidence and testimony, you have to base your judgment off of just that alone. Your personal feelings cannot weigh into that. Yes, you have to use your common sense and all of that happy, good stuff. But when it comes to really definitively saying, is he guilty or not guilty, you have to apply the facts of the case presented and the law in which you're given by the judge. Period. If your personal opinion doesn't match with that, you cannot vote that way.
And
that's not how the jury system is designed.
And the jury has been instructed this. This is going to be covered at the very beginning when they first get there in the voir dire. If they have these strong feelings about something that they're not able to set aside, and they are going to be voting on their feelings on a certain issue, they would not be eligible to serve on the jury. They would be dismissed for cause if that were the case.
Right. So I understand some people think that he's guilty and that he did it. The question is, does the evidence that was presented prove that beyond any reasonable doubt? That is a very high threshold. And if you feel like it does, okay. But don't get upset when somebody saying not guilty is thinking that he's innocent. Remember, not guilty is not the same as innocent. It's not proven beyond a reasonable doubt.
I was looking to Mrs. R.A.
I know.
to see if she wants
me to
chime
say
in.
stuff.
I'm chewing here.
Yeah.
Can you throw me a lifeline?
That's true. I don't know what to say. Yep.
Amber, that's great. I appreciate that. And on the other side, if there are those out there that have their opinions that feel he's 100% guilty, and to them Travis is credible, that's okay.
Yeah.
That's okay, and that's good. And if that's what's in their heart, and they say this is credible evidence, all the rest is circumstantial, it adds up to me, then if you were on the jury, you should vote to convict.
Absolutely. But don't, and that's the thing that I was getting at, is don't criticize somebody for coming to an opposite opinion based off of how they feel the evidence was presented. That's what the discussion is for, and that's what's so great about this community. In chat, on the calls, for the live streaming, it doesn't matter. In this community, we can agree to disagree.
Except
can also
Weatherwatch,
explain,
who says, I vote guilty only
Except
to argue
Weatherwatch,
with Amber and nothing to do with the evidence.
But he's honest, so there are points for that.
Right.
Amber, I appreciate that. Thanks for helping us keep it real on that, and we appreciate everybody in chat being respectful of the opinions both ways.
Yeah, it's tough, especially as we get to the end of a trial, that we have formed an opinion based on the evidence, and if that opinion disagrees with somebody else, it seems kind of inconceivable. That how could you have listened to the same stuff that I listened to and vote the other way? And it feels like before maybe it was analytical or intellectual, and now it's a part of who we are. And so if somebody disagrees, it's not intellectual, it's a personal attack. But, everybody on here is mature and capable of taking a step back and saying, well, we disagree.
Except for Mrs. R.A. I always agree with Mrs. R.A.
This is not true.
Because Mrs. R.A. is always right.
She's always right. I've learned this.
And her clothes are in the dryer.
They are.
Actually, they are.
But this kind of, see, Scott, her clothes are in the dryer. Don't touch them. So this kind of goes to the point of what Mrs. R.A. was saying about, if you're selected for jury duty, you kind of have, it's almost ingrained in people. If you get called for jury duty, obviously the state has enough evidence to put up against this person. Let's see what it's about. You assume that there's enough there to at least be attributed to who's on trial, right?
Yeah.
But you still have to keep that open mind of hearing both sides and staying impartial. There wasn't anything that directly linked Tucker to this case.
This is why, going back to what you're saying, this is why I think it's so important for people to watch true crime. Watch court cases.
Don't watch crime, guys. No.
Watch out your window. If you see a crime, report it. No, but that's not what I meant. I misspoke. This is why it's so important for people to be aware, and why there's transparency in the court system, and why, yes, it should be good to, maybe even mandatory to go down and watch the process work so you understand how it works, so that we can make sure it is fair and it stays fair. I think
and understanding the rules of evidence and why things come in and why they don't.
And the presumption of innocence.
Yeah, and that's a part of being an active citizen, that you got to know how each of the branches work. Scott's trying to decide who to mute right now.
I don't want you to hear me chewing. So I've switched from mic 1 to mic 3, and so it's confusing. Amber, we're going to let you go. Thank you.
Right.
Thank you very much. Appreciate you.
See ya.
Bye. All right.
I don't know how useful I'm being here. I'm trying to let you eat.
Well, I need like half a more egg roll.
That's the thing. You can't eat what you have because of what you don't have.
I'm going to eat this, but when I'm done, I'll need half more.
Oh, all right.
Well. Put Mrs. R.A. on camera. Smack. That's it. Kurt, I ordered a camera yesterday.
Yeah. For another project that we're working on.
Yeah, but it might be used for this as well. It's a court camera. It's a pan tilt zoom, full HD.
Look at the way he's rubbing his hands together, guys.
SDI, NDI,
He's
NDI
so
HX. It's got everything. It's they're very, very expensive. They're the cameras that are used in court. Obviously, when we watch trials, we have pan tilt zoom cameras that can be controlled remotely. It's that, and this has the capability for me to be able to control it remotely. In theory, even across the internet from around the world, if I wanted to. If I had it at a different location, I could control it remotely. So I just ordered that. It should arrive tomorrow, and we might put Mrs. R.A. on camera.
Yeah, so that means that today I will be doing finances and crying, I think.
Yes, I won't be buying any more cameras for a little while. They're super expensive. The controller alone is super expensive for that. So anyway, it's a birthday present to myself. Don't say that. No, I'm going to have a different birthday present closer to my birthday.
So Scott's kind of magical this way. Every time we have something big happen in my life, Scott gets a gift. So like every time I have a child, he comes to the hospital, not with flowers, but with like, I bought myself a new gun. I was like, great.
That happened one time. She got a baby. I got a baby. I thought it was fair. I need to stop this conversation. Please put us back on track. All right. Mrs. R.A., I'm going to mute your mic. Thanks for lunch. Let's see. This person's been calling a lot. Hang on.
Jimmy Lawson.
Jimmy, welcome. Good to have you here. Please save me from this conversation. What's on your minds?
Thank you, R.A. This is Jimmy.
Yeah.
I've been with you a long time. One question. Was Tucker the only one that had a job?
No. Let's see. Well, yes. Tucker was roofing. This was, I don't know. Okay, the lifestyle, they were living on boats, and it's basically, I think, almost retirement, and you just work when you need to, I think, at that point.
Right.
But this was right after Hurricane Irma. It happened September 10th. This was November 17th. Hurricane cleanup goes for months, and this was a doozy. So there was a lot of work.
I live in Florida, R.A. I was up here when hurricane.
You know more about blue tarps than anybody. so that's what he was doing, and I'm not a big fan of charging for that, because I work with the team that organizes the volunteers that do the same work he was charging $300 an hour for, but. At the end of the day, people need their roofs tarped, and if someone's willing to do it, and they need to be paid to do it,
Right.
It
I
is what
was
it
just
is.
saying he's the only one that had a job at that time.
Yeah.
The
He
guy
had
didn't
money.
do, but I mean, it was, you could spit as far as they had to drive. I just don't understand all that.
Yeah.
And I know we have a good old boy system down here. Here's my thing. If the police did not like him, they will find any way they can to get you out. I know. I live in Florida. We definitely have a good old boy system here. I've been involved in it.
You're saying he was a marked man, and this is just the method for how they were going to get rid
You
of
know,
the
they
problem.
may not have liked his attitude like most people in this chat. They think he's arrogant. That's fine. However, the same thing applies. If they don't like you down here, they will find a way to get rid of you. I know. I've been part of that. Wasn't me, but I was involved.
A lot of people saying you're speaking the truth. So he's a true conk.
I
He's a true
am.
conk.
I've lived here for 60 years. I know how it works. I had to call the sheriff one time just to get somebody back home and make a real deal with that.
Yeah. This is sad, and I think here's what I think is going to happen if he is found not guilty, which I hope is the case, because I don't believe the case was made against him. If he's found not guilty, I hope that doesn't mean that it's the end of our insight. The media just doesn't walk away from this one and says, "Well, that was interesting. Pro se, he won. That was nice. Next." I
want them to do what they're doing in the Karen Reed case. I want them to go through all the Ellie down there.
Yeah, it deserves another look, and from an outside agency, I'd say if he's found not guilty, which I believe he will be. But
yes, sir, I agree with that.
Lauren just says, Recovery Addict, you said egg rolls, and now I'm ordering Jack in the Box egg rolls. I didn't know Jack in the Box made egg rolls. I bought them at Sam's Club, and we take them out of the freezer and into the microwave. But Jack in the Box sounds better.
I love egg rolls.
If we're very fancy,
I
I'll
can't
stick them in
believe
the oven.
somebody took a bite out of it. Miss R.A., did you take a bite out of
What? That's
egg?
there's no evidence to tie me to that.
Yeah, I should have DNA tested the bite marks, or at least
Yep,
the teeth prints.
DNA.
Jimmy,
Kiss her and find out if she took a bite.
Jimmy, thank you very much. It's great talking to you. I appreciate your insights as well. Appreciate it, my friend. Thanks for the support.
You too, R.A. Thank you.
Mm-hmm. Bye.
Bye, y'all.
So, Scott, I have a question. And that caller really brought it up to me, and I apologize. I haven't watched the first part of this trial, but it seems to me like they arrested him based on his story, that he was the one who opened the door, and that was it. Like, did they have, why did they choose him? What is tying them? Like, what was the process there?
There's a lot to go into, we'll see this. There's a ton of stuff outside the evidence that's been presented in this case. There's a lot of stories. There's a lot of interviews. There's a lot of relationships and interactions that we
Full
haven't
on
gone
Miss
into.
Marple. Okay.
Full on. Yeah. There's a docuseries in the making here. Okay? There's a book. There's a series that can be written about this and the different angles and what was involved. And I forgot your question.
I'm just wondering why they arrested him in the first place. Why did they think he did it?
I think that was part of it. I think he was in the area. And I talked over who it was.
Press
Do you hear who
1.
that
To
was?
send a voicemail, press 2.
I'll accept it anyway. Hello. I missed your name because I talked over it. This is Scott. How are you doing?
I'm good. It's Violet.
Violet.
Violet?
Miss Violet?
Miss Violet. All right. Welcome. What's on your mind? Sorry, my ears are not working today. I need to get them cleaned out or something.
I'm trying to stay on the fence.
Okay.
I don't like this guy.
Okay.
He's not trustworthy. He's not a nice guy. He's a drug addict, and he annoys me. However,
isn't the last one the worst?
I want to hear the other side of this. Go on. What's the other part? However,
the evidence they presented, the young man Travis and the woman at the hospital.
Hey, hang on just 1 second. They're coming back from
on the record, so the
from court.
modifications took longer than
I'm going to pause them for just a
because
second.
I think we're going to.
Okay, go ahead. Let me finish your thought, and then we'll jump up and catch up with court. So
Okay, so the Travis and the woman in the hospital, neither one of those two are reliable.
Yeah.
So if you take those two out, they've got nothing.
I agree. Then Tucker said this in his closing. You might not like me. You might not like my lifestyle. But in the end of the day, it's the evidence that you have to rule this on.
Yeah.
Yeah. I wish he would have said that he didn't do it.
Yeah, I was looking for that as well.
But would we have believed him? I don't know. Maybe.
Miss Violet, thank you very much for your call. We're gonna jump back up. We're about 30 seconds behind on the video, but thank you very much for your call.
All right, be safe.
We'll see you. Bye.
Well, I think when we review them together, we probably may have a couple more modifications, but I'm having the deputy, the bailiff, blast copies.
You can bail on me, Miss
Right
Violet?
now, because I didn't want to be late. And he's doing the favor, the courtesy of blasting copies for Mr. Tucker, for your honor.
Okay, well, that's too bad because I hate to start deliberations too late. I really have never
They're not
liked
ready
that.
with the paperwork?
Sometimes it's unavoidable, but I was thinking we'd start at like 2, maybe the instructions take 45 minutes. Jurors start deliberating at 3, that's reasonable. If we got to spend a lot more time fine-tuning these instructions, we're going to start deliberations later and later, which only means the potential to be here later or to carry over till tomorrow. It becomes more possible. But so what? The bailiff is making copies now?
There's a soundbite. He's like, the bailiff should be pouring my coffee and nothing else.
Judge, the other option the court would have, I don't know how the court feels about it, send the jury home and start fresh tomorrow morning.
Well, I'm not necessarily adverse to that, with a couple of caveats. I do have that docket tomorrow morning, the arraignments, and there might be something else special set and motion calendar, so that goes from 8:45 to... Oh, you're right. We have inmate plea.
Yeah, no arraignments.
Oh, the arraignments are Friday.
No, the following.
Oh, okay. Excuse me. Okay, well, that's then more flexible. If we've got inmate plea, that actually would enable me to just, set those cases back, let's say, an hour, and unless we instruct the jury now and start deliberations tomorrow, or you instruct the jury tomorrow and start deliberations, or we just forge ahead. I'm happy to consider any of those options.
Given the importance, and again, I apologize, given the importance of the accuracy of the instructions, it would be the state's preference to send the jury home for the evening and let's have a charge conference, and let's agree on what the actual instructions, any further changes, and I will come in with a perfect copy of instructions in the morning. We can instruct the jury and then have them deliberate after your morning session.
Or a perfect copy later this afternoon.
Or a perfect copy later this afternoon.
And so what's your input on this question, Mr. Tucker?
I would like, again, you're talking about it is very important. The jury instructions are very important. And if the state feels they want to add things to what we already have, yeah, I'm going to want to take a look at that. And we're going to have to go over that. And I would agree with the state at this point.
Well, okay, that's reasonable. Here is...
It's going to take some work, Your Honor. That's all I'm saying.
Yeah, I know, I understand. Here's what I try to avoid. We've spent, the better part? Well, now it's 2.5 weeks, let's just say. Now, if we go over these and make some modifications, and I give them, maybe the jury goes out at 3:30. So it's already 2/3, 3/4 of the day, and then we're going to ask these people to deliberate over the dinner time. To me, that's not ideal. It's more ideal to give them a fresh start. They have the whole day in front of them, basically, and there's not that same pressure of time and fatigue. that's...
I would agree, Your Honor, because, look, considering it's, it definitely involves my life here, I don't want them rushing to make a judgment just because they want, because they're here late. I don't want them to do hungry. That. So,
Neither do I.
I would agree.
And to the extent that we can manage things to avoid that, I'm all in favor of it. So I think and I understand the state would be in favor of that also. They come in, I once again apologize, explain my thinking and reasoning, and tell them to come back 9 a.m. tomorrow. In the meantime, I will just have my office communicate with the attorneys who are representing the defendants who have inmate plea tomorrow. I can either set it off to the afternoon or put it on start at 10 o'clock, and we'll instruct the jurors tomorrow morning, and they can deliberate all they need. Okay.
This is bizarre. We need these sound effects. Oh, man.
They're in the jury room? You asked them to come in first.
So we are pushing this out one day. Tomorrow is going to be jury instructions and deliberation only, because the state is not ready with the jury instructions. Apparently they want to add more to it. I didn't hear what that is. Have they already added it, or is it there's additional stuff they want to change? I thought we had decided on it. It's just an issue of brackets. If you lost in the poll, that only starts, the timer starts when the jury's charged and sent out to deliberate. The judge is growling at everyone. I've heard bears that are quieter than this.
All jurors present at court.
Thank you. Please be seated, members of the jury. Welcome back to the courtroom. I hope you enjoyed your lunch. We had a full session this morning with the closing arguments, and I laid out for you what I, in good faith, believed was a feasible and prudent schedule. Unfortunately, I'm going to change that schedule, and I don't even know if I should say unfortunately, other than I don't like to say things and not carry through, but sometimes circumstances dictate such. As I explained, the next step is going to be to give you the law that's instructing the jury. After that, you would start your deliberations. Looking at the instructions and what remains to get them in proper order, I don't believe that you would start your deliberations till anywhere 3:30, 4 o'clock. And I think that's too late. I don't think that's the best way to have you start jury deliberations. We've been here for, 2.5 weeks now? You've received a large quantity of evidence. You've heard arguments. And so for me to say, okay, members of the jury, start your deliberations at 4 o'clock after that day and then bump into mealtime, I don't think that's the ideal way to do it. I did indicate that we have time. This is one of the reasons that we slated the necessary time. So what I'm going to do is I'm going to ask you to come back at 9 tomorrow. We will, at that point, give you the instructions, and then you will be able to start your deliberations, I won't say early morning, but mid-morning, and have the however long you need. So I'm sorry if I was unable to stick to what I originally thought would be the way to proceed, but I'm satisfied this is the better way to do it. So apologize for any inconvenience. Thank you for your attention, your flexibility, your patience, your understanding. So
You're wondering if they need to come back tomorrow?
the alternate, yes. Again, I appreciate everybody's service, including the alternate service, and
only a single alternate?
Could be. I certainly hoping not, but I've seen cases where an alternate is needed right up to the 11th hour. So if there's some special circumstance other than putting in a time and not being able to pursue some other important things, but I greatly appreciate your continued participation. So, folks,
the alternate's
sorry, but we'll see you tomorrow, and I think
We appreciate it.
I heard a juror say, "We appreciate you, Judge," or "We appreciate that judge," or something. Look at the growls from the judge. It's like a hibernating grizzly having a nightmare.
Okay, we're going. So for the record, that was the second alternate who inquired through the bailiff, and to me, did he need to come back tomorrow? And you heard what I informed him, that yes, we just never know what could happen. So so now does everybody have the latest revised set of jury instructions?
I did provide Mr. Tucker a set, Judge, but I'm looking through them, and they appear to be totally out of order, and I apologize to the court, Judge.
Well,
the bailiff didn't collate properly.
The verdict forms have been corrected.
Well, did you need to go back to the drawing board? Did you need to look at these packets and get them in order? I mean, tell me what you want to do.
I would like to go back to the drawing board, Judge, and
okay.
If you could just give me some time, and Your Honor could come back out and I'll have a correction.
But you said we might need to do more corrections. Are there some we could do now that would save a third time? Or I don't know. I mean, but we do have time, so we don't have to, rush. So tell me, you're more familiar at this point with the state of the instructions than am I.
Judge, here's what I would request respectfully. If I have my notes, the problem is I left my notes here and the courtroom's locked, and I didn't get them until like 10 minutes I was supposed to be here. If you give me an hour to go back and incorporate the notes that I took from Your Honor this morning into what I have in front of me, I think I could come back with an accurate package, Judge.
Okay.
Judge, and one other, this morning you mentioned 2.7. Is that accurate?
I already gave that.
Okay.
That was the closing argument instruction.
Okay, just wanted to make sure I don't...
Yeah, and we don't need that. That's just, that's the one I already gave about both the state and the defense have now rested their case. You will now hear, don't worry about that.
Very well, Judge.
Okay, so it's 2:19, so we're talking about 3:20. Is that what?
That'd be fine, Judge. And I have my laptop. I can work on them from right here.
Any problem with that, Mr. Tucker?
No, that's fine.
Just want to know why it wasn't done before. That's all. That's the only problem.
So this latest copy that I got here, this I should ignore.
Yes, sir.
Kurt, thanks for trying to answer all the questions. Matthew, you're on deck. All right, so the judge bails for sixth time today, and once again the state is trying to prepare the jury instructions, which are still not right. And apparently they sent the bailiff out, which I want to get the soundbite. They sent the bailiff out to make copies, and the bailiff made copies, but they're not collated correctly, so everything's messed up. So we have more problems. I don't understand what they're trying to change about these now, because I thought we had an agreement. We went through the charge conference. We had an agreement. We went through everything, and everything was decided. Then they were supposed to make just the corrections with the brackets. Delete the extra period. It was all punctuation. It was just a little bit of last minute changes, and then suddenly they're like, we need to start over from scratch. We need to give us some time. We've got some issues with this. I don't know what's the matter. This seems wrong. I'll tell you this. It seems wrong that the state got a pass on this, and Tucker got raked over the coals for not having the day planned out when he had a plan, but then it was shot down. It seems frustrating that he got pretty much worked over by the judge. And I realize the judge the last 2 days has been Mr. Nice Guy. I don't know if he's just getting, Wheaties for breakfast and he wasn't before or what, but now he's all happy. He's all cordial. He's all nice. He's considerate. He's patient when he was not before. And it's something in that reflecting pool. I'll show you the reflecting pool. Actually, that's not it. This is a counter for J Hatch, but let me get the reflecting pool available here. There we go. The reflecting pool we have in the thumbnail image right down here near the bottom. We have that here because the judge, when Mr. Tucker was making his argument and suggesting that he was going to file a motion to disqualify the judge, and he even went to the length to say that Tucker had talked to the Chief Justice, and within like a minute of that coming out, the judge says, I'm going to go back to my office and reflect on this. And when he came out, he was a different judge. I don't know what he saw in his reflection. I don't know if he has like mirror, mirror on the wall, who's the fairest judge of all. But he changed. He's a changed man. And so we put a reflecting pool on our thumbnail, which is getting a little bit crowded. You guys said we needed to add one more thing on here. Let's see. What was the other item we needed to add on the I know agreements don't count. There was something else we were supposed to add a burglar. Was it a burglar? I thought there was something else. I mean, I'm thinking like Hamburglar, but I'm sure McDonald's would sue me over that. Jay Villa says, new subscriber found you via Kurt. It's Uncivil Law. Hello, everyone. Jay Villa, thank you very much. Kurt is a wonderful friend of the program, a fantastic lawyer, and a great YouTube creator as well. So I'm glad you have found us, and I'm glad you found him. It was great to have him on the phone here just a little bit ago. That was wonderful. Very, very insightful. He's a smart man. A copy machine by the butler. Oh, don't tempt me. Here we go. Let's go full screen here and see what we have in the way of copy machines. Let's see. We want the graphic ones. I'm thinking this one's probably the best. Butler is making copies. There we go. Does that work? It's a little hard to see. Is there a better drawing? Oh, how about this guy? Is this too cartoony? The eyes are sort of similar with Eeyore. I'm trying to keep it all in the same sort of genre as far as artwork goes so we can remember the different things that have happened. Copy machine handing the copy to the bailiff butler. Right there. I'm going to shrink that down just a tiny bit more. There we go. You guys mentioned burglar. Unless it's a really good... Too many B's. How many B's does burglar have? There we go. This guy's good. This guy's really good. Hang on, I need to move this so I can... How's that? There's a burglar. All right. There was one other thing, and I miss it. All right, ignoring chat. Yes, I'm sorry. The devil. Yes, thank you, Homeschool Ground Zero. Everyone's been saying this. Bear growling on the devil. We need the devil. So, not like deviled eggs, but oh, this is him. This is him. We got it. Devil's in the details. There we go. I don't know. That guy looks. That's a little too creepy. I don't want to be looking at that over and over. This is better. I think we need to make him small because he's in the details. Right? Is that fair? Devil's in the details. All right, bear. Hibernating bear. I need a B in there. B button does not work. Disclaimer. Hibernating bear. Can I get rid of the background there? No. Not seen. This one might be good. Because he's yawning, and it makes you know he's making a sound when he yawns. Where would the hibernating bear be? Down here in front of the CVS? By the reflecting pool. That's appropriate to have it by the reflecting pool. It used to be a little bigger. All right. Speak now or forever hold your peace. Had a dumpster fire. Bear climbing the tree, growl, SVC. Are we on verdict watch? We're not. How about a motion to make the prosecutor drink Fireball until he understands? That sounds good. What's with him and Red Balls? He's like, Red Balls, Red Bull, Adam, something. I don't know what he said about Adam, but it's crazy. I should put a box with the word details on it and put the devil inside. You realize I'm not creating any art here. It's strictly clip art. So a details box is what we need. Box has to say details and have the devil inside. That's like next level stuff. Let me think about that one before we go forward with that. Tom Thumb, we have Thumb already. We have the Thumb represented down here by the truck with the judge and the investigator. We've got just about everything on here. The late note, the pot plant, today we added the doorknob, which is a jar. We've got the cowboy hat for Woody. Fireball, SVC, the cameras. I think we're good on that. All right, we'll leave that where it is. Okay, we're waiting for them to come back actually to court. The prosecution is making some subtle changes to the instructions for the jury. We're not in verdict watch yet. The jury has not been charged. They will not be charged till tomorrow. They still have not been read the verdict or the jury instructions and the verdict forms, which will happen tomorrow. The crack and the plant are my favorite, says Nosy. I see what you're going after, Nosy. Nosy Rosie. The drugs are your favorite. The judge is represented like 3 times. It's things that happen, not so much people. Where's your signature to sign your artwork? I'm like Blanksy, or Banksy. Does he ever sign his stuff? It's just you'll recognize it by the fineness of the artwork. No one could recreate that unless they had Canva and a mouse. Hey Travis, we put a Travis in the vehicle, even though that was not in the case. We didn't know where else to put his picture because he is part of the case. Uncivil Law explaining why his chat appears different than everyone else's. His name is highlighted. Once you're over 100K subs, YouTube deems you credible and grants you the check mark. No, grants you the the gray box. Don't think we have a backpack. Banksy signs every single piece with his real name, though. That's what I'm saying. I just have to put like an RA in the corner. Woohoo! Uncivil Law. That is great. Spilled backpack it's difficult to do combination images like that. Greener's like, and here I am, stuck at 99.9K. Greeners, you're so close. Any day now. We got Fireball. Fireball's in the image. It's actually up there by the moon. You'll see it here later when we show you. All right. Is there anything else we need to talk about while we're waiting for this to move forward? Realize we're almost done with the day for this court. I want to hear that. I don't want to leave right now. I realize there's some other murder trials going on. Judge Boyd is I think in session right now. Judge Wolf in Tennessee is hearing a murder trial that started yesterday. We've got another one up in Thurston County. I think a trial that was yesterday. The video is still available on that one. We've got options to go to, but we want to see what the pause was. Why we have to wait here. Why they want to change what these jury instructions are. What was the big thing they saw was a glaring mistake or a problem that they weren't ready to release the jury without correcting. Crumbly is still in jury selection, to my understanding. The Jennifer Crumbly trial. That's the mom of the shooter, the school shooter. Which, by the way, Ethan, I think was the son's name, the school shooter. I think he filed a motion. Originally, we thought he was going to testify against his parents.
To accept, press 1. To send a voicemail,
but he's
press
appealing,
2.
and now he's going to remain silent. Hey, this is RA. Who's on the phone?
Hi, this is Carrie Bear.
Carrie Bear, how are you doing?
I'm great. How are you?
I'm doing just great.
So I just started. I found your channel recently, and it's a great community there.
It is.
I'm currently in school. I'm in graduate school for social work, and it's really heavily. We learn about a lot about social justice, and I think that's why I'm very fired up right now.
Okay.
Like a red ball.
like a fireball, red ball, something like that. You've got wings, whatever it is. Go ahead. Tell me why.
We've already talked about, kind of victim blaming that was going on with Paula, and how the focus hasn't been on the victims here. And I don't know if anyone already brought this up, but it really irked me in closing when the prosecutor was like, you don't have to like these people. These aren't people that you may invite to Thanksgiving dinner.
These are not your people. You're not like them, right?
Right. And I'm thinking that's a huge assumption to make of jurors that you really don't know. You don't know what their background is, who their family members are, what they've struggled with in their own lives. So I was just curious to see what you think, what kind of effect you think that has on the jury.
Well, if he misread the jury, and if they are if Tucker is their sort of people, then he has a big problem on his hands because he's alienated the jury. Even if they're not, even if the members of the jury, live a different lifestyle or associate in different circles or have different activities in their spare time, whatever it is, and they probably do because everyone's different. You weren't the only one that picked up on that when he first said that. A lot of people are like, "Oh yeah, what way to shame the victims and everything," and a lot of people saw that. And they didn't have to be in that group to see that. So he might have already done the damage and hurt his reputation with the jury because of that. So I think that was a mistake on his part.
It's just really disappointing to me because I tend to have this idealistic viewpoint. And I think, they're there for the victims, but it really doesn't feel like the focus is on the victims at all. It's just going after this one man for whatever reason.
Yeah, for one reason. The Tucker says he did it.
Right.
Oh, victim shaming instead of jury shaming.
I just had to get... I just had to get it off my chest because I was so mad, especially since Tucker had to rest his case because we weren't doing half days anymore.
Yeah, and now we're doing a half day.
Yeah.
Yeah. So tell me this, with your expertise, where you're going into to this field, what is your goal with your work? Where do you want to work? Where do you see yourself?
So I plan to get my LCSW, and I kind of want to split it. I want to do half therapy and then half more of macro work. And my interest is with autistic people.
That's awesome. That's awesome. That is really, really cool.
Yeah. I was actually diagnosed as an adult, and so I want to help other people now.
That is really neat. I love it when people make their profession something that helps people. There are a lot of ways to earn money, right? But not every profession is what we might call a helpful profession.
Exactly.
Some are just not as helpful. But thank you very much for doing that. Good luck to you in your school. Hope it goes great, and look forward to hearing from you again.
Thank you.
All right. Have a good day. Bye.
Bye.
Call from Meanie Banana.
Hello, Meanie Banana. How are you doing?
Okay. I just think there's more to this case, and I think that possibly, and this is just speculation, they may have made a deal with the wrong person, the defendant, and they're trying to pin this murder on somebody that maybe not had a real big hand in it.
I've seen some messages from chat. Are you? I think you're on the side that you feel that Tucker is guilty, right? If I read that right.
I think he is, but I don't think they've proven it. I mean, being guilty is one thing, and proving it is another thing.
Yeah. Interesting. Sorry, I'm getting. People are sending me funny pictures. As far as the closing, let me ask you about this. What did you think about Tucker's closing in how he spoke to the jury? Do you think he hit everything as a juror, that the answers that you'd want? Did he hear what you wanted to hear there?
Would he? No, because I really don't know why they would pin it on him unless it's a big conspiracy. What reason would they have to just say, oh, he was the one that did it?
Yeah. Well, what reason does Travis have to say to that? I think we said 99 to life reasons is what he has to pin it on somebody else, because that gets him out. I can't discount that. You're saying that you think that maybe it should have gone the other way, and maybe that they should have tried to make a deal with Tucker to point the finger of blame at Travis. I don't think we have the evidence, or we haven't heard the evidence there that would support that I know of. But interesting idea.
Yeah, that was just it's kind of like you're missing a whole piece to this whole argument.
So
I think there's more there.
There's more questions out there for you, but still not enough to convict, though, right?
No, I wouldn't. I would have to, as a juror, I'd have to vote not guilty because of the evidence.
Yeah. Meanie Banana, thank you very much. I appreciate that. It's always good to talk to you.
Okay, thanks.
Yep, bye-bye.
Bye.
Appreciate that. Lego My Brief says, I applaud Tucker's efforts to pro se. It went okay. It went okay. It really did. This is interesting. Said this need to be a postcard. We can start collecting them like old recipe boxes. Do you collect those? I just collect old boxes.
Becca.
Hello, Becca. This is Recovery Addict. How are you doing?
I'm doing good. How are you?
I'm doing great. What's on your mind today?
I was wondering why the judge didn't stop the state from adding more, since they had already gone through everything.
I think we used the analogy of the Monopoly game and rolling the dice, and the next person hadn't rolled yet. We hadn't really started the next part yet. And so as long as we're sort of between that, the next person hasn't begun their turn, he sort of can go back. That's why Tucker was able to go back and provide testimony when the judge sort of cut it off. And then he's like, oh, wait, you want to testify? We can go back. Even though I told him it was closed, we can step back. So I think he didn't make an error that way. It does look bad. it looks sloppy to the jury because they're like, dude, this judge tells us one thing and then something else all the time. I'm surprised that the judge didn't chastise the state a little more than just saying, oh, you're using my bailiff to make copies now. I'm surprised there wasn't more of a correction, especially when there is an expectation of professionalism. These are officers of the court. They understand how it works. He gave them directives and checked in on them about this. And are you ready? Is this done? Is this ready? It needs to be ready at this time. They knew this. He told them specifically when David, the second prosecutor, was talking to the judge, and the judge was saying, are you ready with those? And he's like, well, I was going to correct them later. He says, no, I want you to work on them during the closing. Okay, because Mansfield's going to be up talking. You should be working on these. We need them right after, and now they're not ready. So I'm surprised that they sort of got off with a little pat on the back, so to speak, as far as punishment. Nothing else.
Yeah, it just looks really bad on the state, especially after, the closings have happened, It's like all of a sudden they want to add their little thing in to maybe, get Tucker.
This is all I can think of. They want some wording that's different. There's something in there they're not happy with, and so that's why I want to pay some close attention to this, because the jury instructions can make and break a case. These are very, very crucial, and what we had before was basically a copy paste from the template instructions provided by the Supreme Court, and so they just copy and pasted everything that was relevant. They stuck them in there. And now they're saying, wait, we're not quite ready. We either want to add something or change something or have it worded differently. And I want to compare and say, what was it before and what is it now? And I hope the judge does this for Tucker, because this is a difficult thing to do. Tucker might not understand the legal ramifications of a change of a couple words, but even just a few words in a sentence, removing the word or and or something like that, it's huge. It changes the entire meaning. So I hope the judge is very cautious and careful with this, especially after we reached a conclusion and a consensus, and now we're going back to rework it.
Me too, because I really feel like it could make or break his, the jury's decision.
Yeah. So we're gonna hear. I think today we're gonna have them finalized here in a little bit. They're supposed to be done with it. We're watching the court. We're listening right now. As soon as something does, pop up in the courtroom, we're gonna take it. Right now we're still looking at the seal on the wall. But as soon as they come back, we're gonna listen and hear what those changes are, and then the jury will hear them tomorrow. The jury doesn't know what's happened. All they know is they haven't been in the room for a long time, so they're completely in the dark about this. They don't know that we've gone back and forth, other than what the judge has told them. So we'll see how it goes tomorrow, I guess. Becca, thanks for the question.
We'll see.
I appreciate it.
Thank you.
Thank you for the call. We'll see you. Bye.
Bye.
Call from
Maryland. The jury's decision.
Oh, it just dropped. I think it was Maryland something. Maryland, if you call back, turn off your TV and then call back again. We'll see if we can take the call. All right. Lots of great comments here. Reverend Beasy says, thank you, Megan. I appreciate that. I'm a bit fired up at the moment and scared I might be offending someone. Reverend Beasy, we love you. You're amazing. Grab a zebra. Grab an emotional support zebra. Take some deep breaths. It's going to be all right. I realize some of these topics get personal very quickly, and experiences, that you've had. So hang on one second.
Call from Maryland C.
Maryland C. This is Recovery Addict. How are you doing?
Good. How are you?
Doing great. What's on your minds today?
Yeah, I was hoping you wouldn't ask that because my mind is a very scary place to live.
Okay, so give us the edited version.
Okay.
Something YouTube friendly.
No, right. I guess when Mrs. C had said something that it just kind of sticks in my mind when she said that we tend to go into these trials with the idea that this person is guilty, and I'm like, we actually do that, which is sad. I can give you 3 words: Salem witch trials.
Yeah.
That you have to have.
If you think you haven't, I mean, just put yourself in the mindset. You're driving down the road and you look over, you see police pulling somebody over, and you think, I wonder what they did. Right? You don't think,
absolutely,
they've got the wrong car. That's not the thought that goes to your head. You think, I wonder what he did. What's that guy? Was drunk driver? Who is that over there? Was this? Why did they stop him? Was this a road rage? And that's our go-to is not that guy's innocent. That guy's innocent. He's done nothing wrong. There's this presumption of guilt because we see somebody in handcuffs or we see somebody at the defense table. We see somebody pulled before the court having to defend themselves, and we just immediately we jump to that. We don't default to not guilty.
Right. And, if you look back through history and like the one caller was saying, like social justice, now we have all these big words that describe what happened in history with like Salem witch trials and a lot of other trials that the system wasn't set up as such, where you have like a jury, a prosecution and rules. Now we have all that and we think that we're better, but we're still those pack animals that tend to get into groupthink, cognitive dissonance. We have all these big words now.
Yeah.
But we're still like zebras when the monkey in the tree decides to, signal and everyone's panicking and running and they don't know why. They just do it.
They all run.
They all run, which is why I'm like, you don't know where my mind goes. I'm in Animal Planet. I'm in history. I'm kind of all over the place. But I just wanted to make that point and to kind of remind people that, they have to really kind of go back to what the evidence is. This was settled in my mind after the prosecution settled their case because there is no evidence. The rest is just garbage to me. It's just noise. Yeah. They didn't do it just because the guys at Duck Dynasty decide to chase bullfrogs and cook them doesn't mean that they're making a witchy poo called, quadrant or whatever. They're not doing that.
I hear what you're saying there. Thank you very much. I'm looking here. There's some movement in the courtroom. I'm not sure if it's going to result in the judge coming back out.
That's good. I just wanted to get that out of my mind. Put it on someone else.
Thank you so much. Appreciate the call. Have yourself a great day. Bye. All right. Let's see. Reverend Beasy, I was showing the zebra there. That's why I said grab a zebra, and zebra immediately responded, grab a zebra. That's funny. Let's see. How do you prove yourself innocent when you don't know what happened? Yeah, this is what gets me, and this is frustrating. These prosecutors have, I believe, it's my understanding, these prosecutors have been on the case for a long time, and they know this case pretty much inside and out.
Call from
AWOL.
AWOL, hold on one second. Let me finish this thought, and we'll jump to you. Is that all right?
Yes, sir.
All right. So these prosecutors know the case inside and out, and they know all this other evidence that Tucker wants to bring in. They know those events. They know those facts. They know what's happened. They know what's on the tape of the interview and what they said to him. They know, if you watch the interview, and I've been told this from many different people, I haven't seen it myself, but many people, they even sent me the link and said, this is where the detective tells them they found the knife and it has Matt's blood on it. They know that exists. They know that's a fact. But because it's not allowed here in evidence, they're arguing and telling the jury, how else would he know? That is dirty. That is wrong. That is so frustrating. They know how else he knows. AWOL, thank you very much for being patient. What's on your mind?
What's up? A few callers called with, and they go, he must be there for a reason. I respect everybody's opinion, 100%. Yeah. But that thought scares me because it's like, must be there for a reason. That's a scary thought for someone in the jury to have, that if he's in this courtroom, there's a reason why he's here. Yeah. For example, the Khalif Browder story. For those that don't know, it's a documentary called Time. I don't know are you aware of that?
I'm not familiar with the details on that.
Yeah, it was just a guy walking in New York. The cops suspected him of stealing a book bag, which he did not steal. They brought him down. They interrogated him and charged him with the crime, and then they kept moving his trial. I think he spent 3 years on Rikers. He never did it. And he ended it, if you know what I mean. For the sake of the channel, I won't say what it is, but he ended it. You know what I mean? Yeah. But that thought of he's here for a reason, we all prejudge. We have to, and it's not a racist thing. We prejudge. It's fight or flight. It's a safety thing. Now, if I'm on a jury, yeah, we prejudge, but you have to put that aside.
Right.
But also, I don't want to say that, oh, that person's here for a reason. I don't know until you shouldn't formulate any opinion until you hear the evidence. And if you go into the case like that, and they presented the evidence that they presented here, I'm going with not guilty, and definitely I don't know.
Hey, well, I'm with you on this, and I think first of all, I know that I prejudge, that I look at this because I drive by the guy on the side of the road and I think, what did he do, or wonder what they pulled him over for? You know, that's my go-to. I also think that in a jury setting, if I'm called, I can set that aside. I think I could look at a case and say, you know, it doesn't matter what I think. It doesn't matter what my impressions are as far as, you know, the first impression of seeing the defendant. That has nothing to do with how I should vote, and it should not hold. You know, I'm not judging auras here. Okay, I'm looking at evidence, and so I'm with you. I just hope everyone's able to do that. That's the purpose of what you're supposed to do when you're on a jury, is be able to set that aside and view it based on the evidence presented in court and the law the judge gives you.
Yeah, like when I see how people, I could see how you could dislike, not you per se, I'm just saying people in general, how they can dislike a judge or attorney, they don't like the way they talk. That's okay, that's an opinion-based idea or thought.
Yeah, you don't have to be their friend. That's your choice. You don't have to be friends with them if you don't like them, right?
Yeah,
that
but
has nothing to do
everybody's
with,
doing a job.
Lock them up.
Right, and everybody's doing a job. The prosecutor's doing a job. So a jury, you're doing the most important job.
Yeah.
You know, so I feel like you should be able to set that aside. So that's all I wanted to say. That thought is just a scary thought of he should be here for a reason. You're outside of court, prejudge all you want. I have no problems or quarrels with that. But in a courtroom, I think that should be set aside. As hard as it is, you should try your best.
Hey, Walt, thank you very much. Appreciate those words.
Thank you.
Have a great day.
Thank you.
Bye.
Yes, sir. You too. Thank you.
Bye.
Call from
Unholy Saint.
Unholy Saint, welcome. Good to talk to you, my friend. What's up today?
So I was just calling. This is the first time calling in. So I think Tucker knew about it. I think he knew what was going down.
Okay.
I think he knew. I think Travis knew he knew about it. Just hard for me to believe that they all stayed together and he didn't know that was going to happen. I don't think he was there, though. I don't think there's enough evidence that proved he was there. I just think he knew what was going to happen.
So let me ask you this: if your gut feel is that there's something more there, that he knew about it, is that enough to convict?
No, I don't think there is. I don't think there's enough evidence for the jury to say that he was there and involved. I just think Travis is trying to save his own life and point the finger.
Yeah.
Because he knew Tucker knew about it.
Interesting. Thank you. I appreciate that.
Yep.
You say it's the first time you called, but I've seen you in chat a ton. I'm surprised you
Yeah,
haven't called
I've been in
before.
chat. I'm driving through Utah right now, so I can't chat. That's why I called in.
How's the weather?
It's not bad. It's dry and it's actually pretty good. It's about 44 degrees here.
All right, cool.
So I'm a little bit south of Beaver right now. So.
Oh yeah, nice.
But
I like that.
It's nice out here.
Fun area. Great fishing over there if you ever stop. Thanks a lot. Drive safe. We'll see you.
Yeah.
All right.
Take care.
Bye.
Bye.
Call from
Nina, Canadian.
Nina, Canadian. How are you doing?
I'm doing well, thanks. How are you doing, Sky?
I'm doing great.
Good. I think what I'd like to say is there are people that are in the middle on this and trying. Really, when I spoke with you yesterday, I think some people had the impression that I was saying he was innocent or guilty. But really, we are at exactly the point. What I feel, and I've learned this from LawTube, it's in the jury instructions. Just like you said, this is the law. It's not about emotion.
Right.
And I've learned that in the past year from watching you guys on LawTube and being part of the community. And that's what I would go in with myself. And I think there must be others in our group that have learned, like you were saying, we naturally go in and we're judgmental, right? We're judgmental. And I agree, like that's our nature. But I'm hoping that it's that we're getting better at not being judgmental, or hopefully we're learning not to prejudge the person when you drive past them.
I'd hope so. I hope that we see this and we can, recognize, like I see in myself, I see mistakes all the time. I make mistakes. I say things that are factually wrong. Okay. But sure. when I'm made aware of that, like I was yesterday by my good mod Amber, I acknowledge that, and I try to become better. I try not to make the same mistake again, and acknowledge that I made mistakes, and keep my mind open to the fact that I will make mistakes in the future. When it comes to judging a case, that means that just because I 3 witnesses in, I think, hey, something's fishy about this guy. Doesn't mean that at the end of the case, I thought it was fishy before, he must be fishy now. I can change back and forth. I can vacillate. I can reverse my position after I, listen to other evidence. I hope that we're all able to do that, and I hope that everybody, all the viewers, all of us as viewers in LawTube and everything else as we watch trials, take that away so that when we do get called for jury duty, we can be like, hey guys, this is how it goes. It has to be based on the evidence. It has to be fact. I hope this does actually have an impact on people, and it does change things for the better.
Oh, it's a learning platform. This is a really wonderful learning platform. And I think even in the scenario you said, maybe we have someone close to us that has to be a juror, and we can help inform them in so many more ways.
Just
and really what's key about
during
all
the trial. So don't talk to the juror during the trial.
Of course. No, prep. No, I mean prep. Yeah. Exactly.
Yeah.
And I really think that this is key, this very moment. And if I went in there, I'm not presuming he's guilty. But what I listened to the, I actually haven't heard everything this afternoon, but the beginning of the closing arguments for this, and for the state, and they were very clear in saying, like, it's up to you deciding the credibility of the witness.
Right, and they'll be told that as well, I think, in the jury instructions, or they were already. And that's not even up to me. I'm not going on those emotions. But when I sit down and read the words on the document that says, this is our state law, so it's going to vary state to state. This is our state law. And do you find that what was presented in this case meets this? Meets that standard.
Yeah. And what I learned from the case with the Payne, the girl that in Georgia that had the incident with the man
driving
dying,
where she ended up shooting the other person. Yeah.
Thank you.
Can't remember the name of the case either.
Name, but
Sorry.
Payne, P-A-Y-N-E.
Sarah Payne.
But Sarah, thank you. There were the 3 different counts. 3 different counts, and they had to say, if it's this, it's not that. If it's not that, then what about this? And so I learned so much from that case, and here we are again. And I think if I was in a jury room, I'd be a voice of saying, okay, everybody, let's just pay attention to what the law is, what's written here, and how do we weigh the credibility of what we've seen?
You might make a good foreman, a jury foreman. I think my chosen career profession here would get me kicked off any jury panel, so I'm not sure if I'll ever get to serve.
Oh yeah,
but
no, I don't want to do it either. So thank you.
Thank you so much. Appreciate it, Nina. Have yourself
a great day.
Bye.
Ciao.
All right. Great comments. I love hearing all the different accents and non-accents, as some people say. Greeners was saying Canadians don't have accents. I don't know what you're talking about, Greeners. We've got a lot of calls coming in still. I'm missing most of them, so let's see if we can reach as many as we can during this break.
Katie.
Hello, Katie. This is RA. How are you doing?
Hello.
I'm all right. How are you?
I'm doing just great. What's up?
Good. Oh, man, this is crazy. So I'm not a fan of Tucker, really, but the state didn't prove their case at all. I think I actually found him a little more likable on the stand than I did for the rest of the trial, if that makes sense.
Yeah, he sort of grew on you then towards the end of the trial. How did you like his closing?
Yeah, is he wearing the same thing every day?
No, he's got a couple different outfits. He's trying to wear some respectful attire, and I mean, you got to realize he doesn't live there. It's not like he has his full wardrobe.
Yeah.
You know, he ships down his closet with him. He lives in Oregon, and he's traveled down here, so he has some clothes he's rotating through for court. But so just
when he said that he lived in Oregon, I was like, I'm like, okay, well, that makes a little more sense why you're a little bit later at times than if you were just here in Florida. His closing, I thought he did okay. I agree with some of the other callers where they're like, I wish he would have said, I didn't do this more. But I think like some of the other callers that they were kind of like, I can make him sound a little more guilty at times. But I just don't think the state proved it.
Yeah, I think the state feels the same way. I think that's why they're trying to get their last shot in here at the jury instructions, and why they're trying to just, if they can tip the scales just a little bit in their favor, that might be enough. So we'll see what they come back with and say here in a little bit when
they're going to feel pretty. They're going to feel pretty bad if they lose to a pro se defendant.
I'm telling you, that's funny if that happens. They're going to be memes around the office like crazy in the district attorney's office.
Oh, for sure.
All right. Thank you so much for the call.
All right. Well, thank you so much. You guys take care.
Yep. We'll see you.
Bye-bye.
Call from.
Hey, Brett.
Hey, Brett. This is RA. Who's on the phone?
Hey. Yep.
Sorry, I missed your name. Is it Hey Brett or Brett?
Yes, Brett.
Brett. Okay. Sorry. Brett, this is RA. Thanks for calling in. What's on your mind today?
No, just my question is, and this has to do with this case and the Murdoch case. When a jury is told, don't talk to someone, boom, 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 and they do talk to someone, shouldn't that come out when? It shouldn't come out after the trial?
Well, it should come out, and however it is, the judge gives them instructions saying if you see anything happen, if you have any concerns, let me know through the bailiff. So that should come out during the trial, and what they do from then on differs. It doesn't necessarily mean that because say in the instance of what was the trial, the Treehouse case, where the juror was in the elevator and shouted out, "We love you," to the prosecutor. Doesn't necessarily mean mistrial, but it might mean that juror is no longer on the jury member is no longer on the jury. But sometimes it means a mistrial. It might be in Murdaugh's case. I don't know where that's at right now. Have they decided yet? It might, if the interaction could caused a problem or could have caused a problem, it could be a brand new trial. But
so what I'm saying is, why is that an issue now? After every time he sent them back and said the same thing, he said the same thing. Why now would that be an issue if they
with the jury here on this trial
broke? Well, I guess I'm talking about the Murdaugh.
Okay.
Yeah. I realize that's not the one you're on now.
No, it's okay. It's okay. I'll try to answer it as best I can. You're talking about Becky, right? The court clerk, Becky. The interaction that she had with the jury. The problem is if the allegations that Mr. Murdaugh is making through his attorneys are true, that during the trial and possibly during deliberations, Becky interacted with the jury and basically told them what to think by saying, "Oh, this is a good guy," or "This is a bad guy," or gave some impression that certain witnesses were believable and others were not, which would influence or could influence the jury. So if that's true, then that would definitely have an outcome, have bearing on the outcome of the case. And then it would be, up for a mistrial. It's highly inappropriate to do that. That's why we isolate the jury. We used to sequester them all the time. Now it's becoming rare to have a jury that's sequestered, but we used to, lock the jury up in a hotel, and feed them sandwiches until they came to a verdict. But now it's very rare that we see that.
Okay. So the juror that comes forward with this supposed thing, it has broken their I can't think of it. Their oath. Because they heard something they shouldn't have, and they went into trial and they said, when the judge said, "Have you talked to anyone?" Nobody said anything.
It's a problem.
Supposedly,
yeah. It means a juror either lied or failed to disclose something they should have.
Right. So I'm wondering why is that happening now? If they heard it, if someone talked to them, if they talked to them in behind the bars, so to speak, why didn't they say, "Hey, raise my hand"? Yeah, someone said, or this gal right there, who's our court
Becky
clerk. Yeah. Why didn't she say something? Why didn't they say something then?
It may be that they didn't think it was wrong, that they thought, oh, our just little chatter in the hallway was just polite talk. But afterwards it comes out that the polite talk was more than polite talk. So I don't know enough of the details to be able to tell you, but hopefully they get to the bottom of that, and we might end up with another long Murdaugh trial as a result.
Right. I know it's another case, and I'm loving this one, but I just had to ask that. It's been killing me.
Not a problem. I appreciate the call.
Thank you. Bye.
Thank you. Bye. All right. Let's see. I missed a couple questions. I think the younger DA gave the second round so he could have plausible deniability about the knife issue. Otherwise, it's misconduct. Ooh.
Call from.
Oh, you leave us
To
guessing.
accept, press 1.
Hey, this is Scott. I didn't hear who's on the phone. Who am I speaking to?
This is Ed.
Ed? How are you?
Ed C.
MC.
No, Ed C.
Ed C. Sorry, it's a little hard to hear.
Yeah.
What's on your mind?
I know. So I'm been sitting here listening to all this going on, and the one thing that keeps coming up that's actually funny is everyone says, "Well, why are they trying to pin it on him? Why are they pinning it on him?" These guys don't care who they're pinning it on. They just want a conviction.
They want a feather in the cap.
And and this guy, he's been going so hard. And when I first came into the case, I'm like, oh, a pro se, look at him, he had to have done it. And it took about 10 minutes of listening to what the prosecutor had that I went, no, this is wrong. They're just pushing. And if this is such an egregious case, why did they give the one guy who flipped, what they got, 10 years? 10 years or something?
5 years, time served. Four
and then
and
they want to
change.
give this one, Tucker, they tried to give him the same deal.
Yeah.
And Tucker's like, I'm innocent. Why am I going to go with time served? So I guess this case wasn't important. They're trying to hide something else going on because down in the Key West, everybody knows everybody.
Yeah.
So if they want to bury it, that's what they're trying to do, bury it.
Something's fishy here, and I hope it does come out after this trial. Whatever the outcome, I hope there's some more analysis of the situation. First of all, I hope.
Well, Tucker said his wife was a multimillionaire.
Mm-hmm.
So that means they got money to really, if they want to push this further after this trial, then it ought to be a test.
Yeah, I don't know. I mean, she may be wealthy. She's associated with a brand that's obviously done well. So I don't know, but I don't know how that works. I'm not telling people how to spend their money, but it would be really sad if they had to, because if it only came down to somebody who had money to be able to take this issue higher. What about the person who is in the same situation and doesn't have money? Do they just rot in prison? Do they not?
Yes, and unfortunately, there's a whole bunch of people in prison for that same exact reason.
Yeah.
I mean, look at the hurricane. You remember the boxer?
I don't.
Oh yeah, that they even made a song about him. It was back in what, the 60s, 70s. He was a black man. He was a famous boxer, and the cops in Jersey or Pennsylvania, I think it was, wanted to get rid of him. So they set him up for a murder and a robbery. He had nothing to do with it. He spent almost his entire life in jail.
Yeah.
And then they finally realized later on, after I don't know how many, 20, 30 years, that he was innocent, and he was let go. So yeah, it happens.
Yeah. It's terrible. We need to fix that. We need to fix that.
Yeah. Also, you got to make your thumbnail an MTF. Sell them on.
I'll sell them on what I've got, like a Coinbase wallet. I'll stick them in there. I don't even know how NTFs work, honestly. I tried to buy one once.
I don't either. I just keep seeing it.
I think I donated money to a Nigerian prince at the end of the day. I don't know how to buy an NTF, so it's.
I think he might be the cousin to my Saudi Arabian prince that I donated a bunch of money to.
Crazy.
All right. Have
Thank
a good
you.
one.
Appreciate the call. We'll see you. Bye.
Call from
Cam.
Hey, Cam, are you there?
Yes, I am. Hi, Ari.
Hey, how are you doing?
Did you enjoy your lunch?
I did. It was a bit brief. It was like one bite short of a full meal.
I was listening. So I'm a little upset. I'm like this. I wish, first of all, for me, I feel that he's not innocent, but he was not proven guilty. So with all the evidence. I was really on the fence with that for a long time. But I wish he was knowledgeable enough to stand up when the state stepped up and said they need more time to add more to the instructions and ask for a directive verdict at that point. I mean, this is enough is enough.
I think the directed verdict is not the right motion there, but I think he should have objected and probably would have had good cause to do that and say no, but instead he took the side saying, yeah, this is important, we need to get it right. If they say we need to fix it, let's do that. I'm like, no, we had it right. Now we go back to the drawing board, and the state can say, oh, I made a mistake, it will be much better for us if the wording's in XYZ way. And maybe they made a mistake that he could benefit from, but they're getting a redo. You've got to realize that this is all weighed against him. Okay, the scales were tipped against his favor from the beginning. He's a pro se defendant. He's up against a system, a well-functioning and educated, licensed, practiced system, and he's not in the advantage here. So giving them another shot, another crack at it, is probably not going to end well for him.
Correct.
I mean, they're not in there to say, oh, we forgot. There's this part that the jury should be instructed about. That if they feel like this, then he should be, not guilty. They're not putting that in.
Yes.
You know it's going to be another way that the jury can be like, well, I guess under that light, maybe we do convict.
Yes.
So.
I'm with uncivil law. I'd be so disappointed if they come back with a guilty.
Yeah.
Very disappointed based on the evidence.
Yep.
The lack of evidence, let's say. Yeah. Thank you, Scott. You have a great day.
Thank you so much.
Chad. I love you all.
Thank you.
Bye.
Thank you. Bye. All right. Let's see. We have, yes, Ivan has my Bitcoin address. I don't know what you can do with that, Ivan. Does that give away money? I don't even know.
Call from
I don't know how it works. Let's see. Is this Leisha? Is it Leisha on the phone?
Oh, Seashell.
Seashell. Okay, Seashell. Can you turn your TV down just a wee bit? That'll work a little better.
Yeah.
It'll be confusing.
Is that better?
Yes, that's perfect. What's on your mind, Seashell?
Okay, so I have some questions because I'm a little late to this.
Mm-hmm.
So if he's found guilty, what is he facing exactly?
Life in prison. Life in prison
Life.
without parole
So
is the worst it can be.
That's a big thing. I just feel like they don't have enough evidence.
I'm with you on that.
But, I don't know. It's like you don't know how to feel, but...
It's frustrating. I will say I've got questions about this. There's all sorts of things that didn't sit right with me. Like you, I'd like to think that in life I'm not going to do the same things that Mr. Tucker has chosen to do in his life, but that's his life and he gets to live it, and
right.
I'm living mine. We probably wouldn't have, bumped into each other a lot because we do different things during the day. First
Probably
of all,
not.
I can't afford a boat. He likes to live on a boat. We probably wouldn't see each other that way.
Right.
But that being said,
And then
you can't convict somebody because they make different decisions than you in life.
no, and
unless
it's
there's
just
evidence.
what's that saying about one person? What's worse, like one innocent person going to jail or 100?
It's better that 100 guilty men go free than an innocent person
Yes.
sent to jail. Some
That
variation
resonates
like that.
here.
Right.
And it's just scary and I also wanted to ask you, I found the prosecution to just be a bully. He's very unlikable, even if the evidence is on their side. It's just that he was unlikable. I didn't like how much he objected. I don't know.
Yeah. I think there's obviously bad blood that existed before
Yeah.
opening statements in this trial, and we're seeing the end result. And I don't know what went down. He could have triggered them on his first interview, and they're like, "We're gonna get this guy, man. He's taunting us." Or something.
Yeah, that could be it.
I don't know what it is. I have no idea because I haven't watched that evidence.
Right.
But you know that there's some bad blood there, and this is just boiling up now to the surface.
Oh yeah, they are. Yeah, both sides are, and the judge too. I think is just wants to be done.
The judge has gotten better. I mean, other than his growling, I mean, he's turned full grizzly bear mode on his growls. And but as far as being in control of his emotions, his responses. Sorry, there's something happening in court still. Well, just people moving around.
Oh.
He seems to be more in control and more patient, but I want to know why. The inquiring minds
What do we
want to know.
think of the court decor, by the way? The lime green door and the lime green walls and the green carpet.
I think we need a poll. Help me write the poll. We'll put this out to the group.
Okay.
Let's see. The question is going to be, what do you think?
What an
of
odd
the
choice.
Key lime courtroom.
Yeah.
We have to have the answers be movie quotes. So let's see. I'd buy that for $1. You know what? Guys know what movie that's from. I'd buy that for $1. No.
Oh, I don't. Maybe I'm too young. I don't know.
Let's see.
I mean,
I'm looking at
don't
chat
feel
here
young.
for some more answers here for more one-liner quotes that might work. It was RoboCop. Thank you very much. D Killing Spree. I appreciate that. Or DC Killing Spree. Is that the one? I have questions about your name now, but all right. Let me. I'll let you go on this. I'm going to build this and answer your question in a poll, and then we can vote. We'll vote on this. But
okay, I will vote on the poll, Scott. Thank you.
Sounds good. All right. We'll see you.
Bye-bye.
Bye. I'm not sure if somebody put this in chat or not, but I'm going to go with the Jim Carrey line. I've had better. Let's add another option here. Let's see. I need some movie quotes. If you guys can help me out, we need 2 more movie quotes for the
Call
poll.
from
Chris.
Hello, Chris. This is Scott. How are you doing?
I'm doing great, thank you.
Good. What's on
I
your mind?
just have a quick question.
Mhm.
I just have a quick question for you. I've been following this trial, and I think it's a crazy trial. And my question is can he still file for a directed verdict or a motion to remove now that everything's all said and done?
I think technically he could still file a motion to disqualify the judge if he got that in. That's still anytime during the trial he can put a halt to that. It would be short-lived, I think. Sorry, I just got a quote. I need to put this in. We're going to do show me the money and add one more option. He's going to have a chance to do a JNOV motion, I think, which really won't stand on anything because the judge has already sort of ruled on this after all the evidence was in, so it can't change it.
Oh, okay.
But Sorry, these quotes
Well,
are so
thank you for taking my call, and thank you for everything you do, and I'll keep watching.
All right, thank you so much. I'm sorry I didn't answer your question very well. All right.
That's all right.
We'll see you.
Bye-bye.
Bye. Basically, I think his chance to have the judge rule this one out is pretty much past at this time. We've got the poll questions up right now. What do you think of the key lime courtroom? We've got 4 different movie lines that you can choose as your answer. 1 is I'd buy that for $1. 2 is I've had better. 3 is show me the money. And 4 is you can't handle the truth. So I'm not sure. Oh man. So there. Let's see. Yeah, well, that's just like your opinion, man. I'm unsure as how to answer. It's okay. Just choose one that. Which one do you choose if it's I love lime green? That would be probably show me the money. I think it would be the choice if you like it. It's not easy being green. A Kermit the Frog line. The poll will be a huge indicator of the ages in chat. Yeah, for those of us that remember having an avocado-colored refrigerator, this is not quite so bad as that, right? Neon key lime avocado green, says Michelle's Mixed Media Madness. I wish you'd put You're Killing Me Smalls on there. Bravo Chick says, yeah, I voted correctly then. It's all right. So many quotes. Let's see what how the polls are doing. Got 345 votes right now. It's close. No, it's not. One's almost double the other. Oh, court. We're back in court. Shh, everyone sit down, behave. We'll keep the poll running for a little bit.
Okay, good afternoon. I'm back.
Good afternoon, Judge.
Good afternoon, Judge.
How are things shaping up?
I think we have everything in order, Judge. We just emailed Ms. Violet one sheet of paper that we need to just insert in each packet, and we're good to go.
You need 3 copies of it?
Yes, ma'am.
Judge Jones, just so the court's aware, part of the problem was some of these instructions changed in December, but evidently the website hasn't updated. You have to go to a different location to find the update, so we had to.
I'm not buying it.
We weren't aware of that until today.
I understand instructions are rarely easy.
Well, we were informed, Judge, that I guess the principal instruction changed in December of 23. We had actually included the one off the website, which ASA Britt brought to our attention. He said that's the old instruction. So, what is this?
Well, my book, the instruction coincided with what your initial proposal was.
The judge's book is wrong.
Judge? Go to the judge. All right. Yeah, Judge, our book as well, but evidently the books aren't reflecting the December changes.
Thank you. So Mr. Tucker has a copy here?
Not yet, but I'm sure they're going to
I'm going to give it to him right now, Your Honor.
Is this it right here?
That's our copy.
Thank you, that's Tucker.
No, I like the fat one. I'm just kidding. There you go.
Okay.
Thank you, sir.
So most of these are going to be identical to what we reviewed previously with some of the cosmetic changes and other changes. And apparently the only big change is the new principal instruction.
Well, the principal, and I remember I omitted Agasol. I have that in as well.
All right, so let's systematically go through these. 3.1, Introduction to Final Instructions. 1.6, Pro Se Defendant. 3.2, Statement of the Charges. Introduction to Homicide, 7.1.
He's not reading them.
Okay, unfortunately, the package I have still sees in the brackets in 7.1.
It still has the brackets.
Me too.
And the manslaughter too.
The judge is saying that line from a fun movie called Galaxy Quest. I've got one job on this ship. You've got one job on this ship, Mr. Attorney.
Yeah, 7.1. Print out the wrong one. It's right here, it says crime charged. That one's fine. You must have printed out the wrong one, Judge. We have a corrected version right here. We'll send a copy to Ms. Violet. Or I can print them out at the office, Judge.
No, if the clerk doesn't mind helping out here, anything we can do to accomplish this now would
What
be appreciated.
Jim Bob. Love that line. By Grapthor's
We have
hammer.
taken out
What a savings.
parentheses, crime charge, brackets, or third-degree murder, more manslaughter, all that had been agreed to be removed.
They gave the judge the same copy he had before. No changes. Said, here you go, Your Honor. We've delayed court for 4 hours.
2 copies, Judge. Here's a corrected version that I'll give you for Your Honor. And I'll place the 2 copies in my packet, Mr. Tuckers.
You sent something?
Yeah, it's 7.1, just 2 copies.
We're going to close out the poll about the courtroom walls. What do you think of the key lime courtroom?
It definitely feels small.
The winner is You Can't Handle the Truth. Followed closely by I've Had Better. And then we had a tie, neck and neck, 11% for both of I'd Buy That for $1 and Show Me the Money.
Well, I'll wait till you get yours, but the one I've been handed does appear to be what we agreed upon earlier.
Who just swore? Was that the judge? Did you hear that? Tell me I'm not the only person that just heard that little mumbled under their breath curse word.
Oh, okay. Oh, to make a copy, I would have to scan it or all.
Okay.
I'm just waiting for something.
Everyone with headphones on heard it. Did someone say the S word? Yes, they did. I think it was the judge.
Judge,
No, maybe it was the.
copy? We'll go ahead. It hasn't come through the email. We'll just scan it here.
We're standing here waiting for the email.
Oh, here it is now.
Okay.
At least the jury's not actively sitting in the hallway. Well, I say actively, but is that a paper shredder or the printer? Good grief. It's like dot matrix. This takes me back to the day. Judge can't call in for 24 hours because he said the S word on the air.
Okay, thank you.
Okay, so is there any objection to the modified 7.1?
Take a look.
I can already see problems with the 3.5.
Tucker needs to compare 7.1 to the old 7.1. And it's probably not a problem. It sounds like they just updated to the more current version. The Supreme Court updated the template.
I gotta say, because I'm looking at it, Your Honor, my copy of 7.1 still has the brackets.
The judge.
I mean, let me make sure I didn't accidentally put the other one over here.
Well, is it rec? The one that I handed up to the court judge doesn't have any brackets.
No, I think
neither does the state's.
I think I accidentally put the other one back in.
Okay.
All right, so this one doesn't have this one doesn't have brackets. Okay, let's get this over here.
Tucker's got like 3 copies now.
All right, so back to this.
All right, so the 7.1 now is in compliance with what modifications that I agreed to or ordered to be made.
Yes, there's nothing new in this one, right, Your Honor?
Right, it's just the fact that the brackets and parentheses and the manslaughter was all removed. We're all removed. So, but now the 3.5A, the principal instruction, apparently there's been a change in the law effective, what, January 1st or December 31st, whatever the case may be is. And so this is the one that is now in effect, which is something that we didn't realize when we did the earlier charge conference. Okay, so I'm looking at the last paragraph here. It is not necessary for a principal to know every detail of how a first-degree felony murder, second-degree murder, robbery, aggravated assault, battery will be committed. So I take it those are the lists of the charges in this case.
That is correct. Including the lessers.
Right. Then, unfortunately, I see in the 5th sentence from the bottom, did help the parentheses name of crime occur. And you see there's parentheses and it says name of crime and there's not any crime.
Right, Judge. I'm sorry. All those crimes have to be repeated. Where it says name of crime, that list has to be inserted there.
Lacey Ann, welcome.
Making corrections as we speak, Judge.
You follow what I'm saying? Mm-hmm. Okay.
Do you follow what I'm saying? Get it right this time. Matthew, I'm betting. I realize that I'm just making a call here without knowing the facts, but I'm betting both of these people are not in their first trial. That's just my gut feel based on the cut of their suits.
I'm just also curious where this principal instruction is inserted here. We're putting it right after the introduction to homicide. I didn't think that was where it was in the initial package. Not that that's etched in stone, but I wouldn't think it goes right after 7.1. One step at a time.
Judge, the thing is it applies to every crime, so I don't know if we put it in the very beginning or should we put it after, before all the crimes are, before they get the instruction as to each and every crime. I think the principal should maybe be the first thing they see before they go into each and every crime.
I understand that has some logic to it.
We just 3.5.
Okay. That list has to go in everywhere.
So they got a little addition in there that says the person under the principal rule doesn't have to know everything that happened in the crime to be charged. That is very helpful to them because Tucker definitely, according to testimony, did not know everything that happened. So that is a helpful change for the prosecution.
Good thing we sent the
I think
jurors home.
Judge says, good thing we sent the jurors home. I think they use the current law. Say, for example, you might have somebody who's being charged with murder and it takes years to take them to bring the trial. In the time between when they're charged and when the trial begins, the state does away with the death penalty. What happens then? Do they say, "Oh, we arrested you already, so we get one more shot"? thinking that happened in Colorado, if I'm not mistaken. But it might be another state. Tucker can object. I don't think he'll win, though, because the changes are changing to the standard instructions as per the latest updates from the Supreme Court in Florida.
No, not yet. She's doing it now, David.
Anna, if I might. The thing I'm a little bit dismayed by is that, I remember Mr. Mansfield has already explained the principal theory to the jury using the old one. I'm not so sure. This one seems a little different. I'm not so sure how that applies.
And Judge, what I read to the jury was number 1 and number 2 at the top. All the stuff at the bottom is what's changed. What I read to them is it's not inaccurate. It's not a complete recitation of the instruction, but I made my point with numbers 1 and 2. The jury will get the complete instruction. It should have no bearing on it.
I honestly don't remember exactly, Your Honor, so I can't say otherwise.
Well, I trust that Mr. Mansfield, as an officer of the court, would be, accurately reiterating what transpired, number 1. Number 2, I feel that if the instruction has changed, which it has, then I'm obliged to give the most recent one. And number 3, ultimately, the judge gives the law. So it's not unusual for attorneys to, argue the law, but ultimately the law comes from the judge, and whatever the attorney may have said as to his or her understanding isn't binding unless there was some deliberate misstatement, which there wasn't. I don't believe that it would.
I'm not saying there was, Your Honor. I wasn't accusing anybody of anything.
No, I know.
I just want to make sure that we didn't confuse them or anything like that.
I'm not saying that you're accusing anybody of anything. You bring up a valid point. Ideally, we should have had this beforehand.
I'm sorry.
We didn't. I don't believe anyone is prejudiced by virtue of it being changed to the most recent one from what we thought was the law previously. I don't think Mr. Mansfield's recitation of certain parts of it was misleading or a misstatement, and ultimately all I'm trying to do is make it clear that the law that I instruct upon and also I'm going to give them is really what counts in terms of what's applied. So I understand your point. I don't think it's a bad point, but I don't think it's going to jeopardize the fairness of the proceedings.
Okay. Greeners, did you mean to say trust but verify?
Well, that's fine.
Or did you mean trust but verify?
That's why we do these charge conferences. Any other input on this principal instruction?
No, other than that, I mean, I don't see anything that highlights anything or that makes it.
Me neither. So then the question becomes, where do we insert it in this litany of instructions? So I don't necessarily think it's necessary to read it 4 times. I think 1 time is
I agree, Judge. I would agree.
Adequate. So then it could be right after the statement of the charge is one place to do it.
Judge, that would be the state's position, because that's right before we start going into the charges.
Statement of the charge, 3.2, 3.5a, principles.
Hey guys, I would agree.
Thank you. Felony murder, 7.3.
Do you have more brackets here?
don't see any problems.
No problems from Tucker.
Thank you. I don't either. Robbery. Okay. So robbery 15.1. So we've changed now because previously I thought the charge was robbery with a deadly weapon while masked. So now it's just plain vanilla robbery.
Judge, I had a note. I thought you had indicated, or I thought we as a group indicated we were just going to go with robbery. Isn't that correct?
No, that's not what I understood. That you're the one robbery with the deadly weapon and robbery with a weapon, and Mr. Mansfield said we're not going to seek plain robbery as a lesser. That's where we left that off. It was robbery with the deadly weapon, robbery with a weapon, no robbery. Initially, the request was
no
robbery
deadly.
as a lesser included. Then Mr. Mansfield, right? You said the state's not seeking robbery.
Yep, that's correct.
So drop the robbery charge.
Oh, no, I actually got it.
Ay.
Thank you.
But wait a minute. Is this just so this one's just part of the felony murder instruction then? Oh,
And then this is the robbery with a weapon.
okay.
Correct. It also has the quotation.
So maybe I'm the one who's getting ahead of myself then.
That's it, Judge. I'm sorry. You're absolutely correct. The one that you're looking at is the underlying charge for the felony murder charge.
Right. So that was the qualifying offense.
Yes, sir. That's correct.
Wait, so we're getting rid of robbery and keeping robbery?
Yeah, but robbery stays here because my mistake. I assumed it was moving on to count 2, whereas it's part of the felony murder element. They have to find the robbery, so therefore this belongs there.
Judge, I would point out, I'm looking at the robbery instruction on the second page. I believe we just need to make one correction to the great bodily harm definition. It needs to have a quotation in the front.
I don't know what happened here. A lot of these corrections we talked about haven't been made. I mean, robbery, there's the brackets again.
Dismiss the case with prejudice, Your Honor. That's the only thing we can do at this point. CAG, the Law 101, this is the number of times that Mr. Tucker's been instructed as to the
robbery
law.
as part of the felony murder. That we were going to take the brackets off this paragraph starting with the third sentence. The law does not require. There's the brackets. And we were going to take out.
Your Honor, Your Honor, if
Yes, sir.
I might, I'm pulling up, because since we had there's some new versions of the stipulation, or I'm sorry, new versions of the jury instructions, and I'm looking at some of them that may or may not need to be included in here. I'm looking at the definition of accomplice. I'm looking at the weighing of the evidence. There's new ones on both of those.
We already have weighing the evidence. That's.
I just don't know if we have the new version or we have the old version.
I don't know, but I asked earlier about any specials or additionals, and I'll certainly readdress it. Right now, I just want to readdress the things that we talked about the last time that haven't been fixed.
Yeah, I'm sorry, Your Honor.
That's all right.
I figured I'd look up the new
Bailiff's out of here.
Since we were adding the new version of that one. I figured there might be new versions of the other ones. That's all. Because just like Mr. Mansfield and Mr. Alvarez, I was going off of the old stuff too, so.
Hang on, did they just fix that door? Did the door handle just get adjusted
See what I'm
down?
talking about?
Yes, Judge, we've already corrected it, and we're sending it over to Ms. Butler right now.
The trouble is, the second page, there's a problem on the last sentence with the same brackets.
Hold that email. Hold that email.
Or threatened to be used or intended to be used. All that bracketed material hasn't been, the brackets haven't been removed. On the second page of the robbery.
I see, Judge. Ours has been correct as well.
We could make a compilation of all the judges' size, and it would span hours. It would span hours. And now we get this slurp in the gulp, too. Doorknob is, or the door lever is still up. Handle, I should say. Yes, let's make this a drinking game. What could make this better? The state has to drink for every mistake they forgot to correct. Well, we are in Key West where everybody knows your name, so I think that's appropriate, Cheryl. So the judge reminds you of Cliff, the mailman from Cheers, his voice.
John, are we using the new version of felony murder too, or the old one? Okay, just want to check.
Everything's brand new. They also omitted an Oxford comma. That's a capital offense.
What is trouble?
This is crazy. I'm reading Homeschool Ground Zero's stuff, and then she's here at the door as well. We'll see you. Drive safe. Do you want to bring me something sweet and cold and yummy? I was thinking like either a Wendy's Frosty or a large Oreo M&M and maybe Reese's Peanut. No, just large Oreo Blizzard. Should we do a quick poll and see if Mrs. R.A. should bring me a large Oreo Blizzard?
Thank you, sir.
Mint chip blizzard, please. So 6 full. I want ice cream. I wandered the house. We have 2 freezers, right? Well, actually, we have 3. The one is completely empty because it's in the Airbnb. But our other 2 freezers, we have a full freezer
one looks
and a
clean.
small one. And there's nothing good in the freezers. There's all sorts of food, but there's nothing like, I want that. Good. I've been craving something
Legally
sweet.
interlocking counts.
Sorry, Judy.
Looks like the word 1 has been replaced with the number 1.
I think we're good there, yeah.
Frosty is better, says Jinx.
When
I like
there are
Frosties.
lesser included crimes or attempts, 3.4. We've got the second degree murder, not the manslaughter. 7.4 murder, second degree.
Bravo chick. Just remember, the channel's called Recovery Addict. We can't have like a channel drink, a default channel drink. Oh man, I'm gonna need a blizzard tonight. If she doesn't bring me one, which I'm guessing she's not going to because she's running errands. Bobby, we almost went ahead with jury instructions this afternoon. It almost happened. The state then came out and said, wait, we're not quite ready. We have to make an update and change. And they made the changes, but the changes didn't have the updates.
Now? Yes, sir. I didn't see anything in there.
Let me just look at something here. Yep, all right. Aggravated assault, 8.2. See something that looks a little strange.
I did catch it just now, Judge. We're making the correction. We're taking out the
4 with a lowercase a next to it.
That should have been there.
Mr. Mansfield is so mad at David right now. He's so frustrated because this was David's job. He's like, I did everything in this case. I carried the whole load. I brought all the evidence. I crossed the witnesses. Your whole job was just to prepare the jury instructions.
Made with a deadly weapon. And then I also see victim in parentheses without the name. If you look at the paragraph immediately below 4A, or 4, look at the third line, actual fear on the part of parentheses victim. See that?
Yes, sir.
The judge is doing paralegal work right now, and he's not liking it. They literally copy-pasted a form letter, forgot to update the blanks. They left insert victim name here in the wording, and they handed it to the judge. Oh, man. They only had 6 years to put this together. Well, in their defense, it did change in January. So, you know, this is a new month. Of course, they didn't have it ready even before they knew it had changed in January. I'm thinking these are cookies, right, Princess Buttercup? Butter sugars? Mr. Man feels like, David, you're embarrassing me in front of the judge. You know I'm up for re-election. How can you do this to me this year? I don't know if he's elected or not. I don't know. I don't think he's the chief. I think he's a lesser DA. I think at this point the only thing that would be appropriate is to play some background music.
Modifying that act assault?
Yes, Judge. It's been set.
It's been set up here? You don't have it yet?
We're running around in circles here. There's more paper on these desks than the entire case file times 10. That is an agricultural assault, isn't it? Thank you, Adam. Music is always the answer. If Tucker could pull this out, and even if it's just like half humorously, just say, you know, Judge, glad we took the time to get this right. The devil is in the details. That would be hilarious. That would just be like a zing.
No. There it comes now.
My old lawyer sent me a letter thanking me for letting him handle my divorce. I was already divorced when I hired him. Well, talk about claiming credit that isn't due. I don't know what circus music would be. Butler Bailiff is pouring a new one for the judge. The judge is like, hey, Bailiff, another round for me and the boys. Let's serve it up.
Well, you're taking the A out. The alignment is just one space off, but I don't think that's substantive in nature. You can see that the There's one space to the right of the other does, but like I said, that is not a reason to redo it. But the A has been removed, so. Any objection to this?
No, sir.
Okay. So now, battery, that was fine the first time around. Aggravation of robbery by carrying a knife.
So, butter sugars, they're not a cookie?
Aggravation of felony by wearing a hood, mask, or other device to conceal identity.
Love you, Buttercup, but I'll pass on the slobbery kisses. My cat would not approve. It's like Judge
3.7, plea of not guilty, reasonable doubt, and burden of proof.
Would you like to revisit your previous ruling on the JOA?
3.9, weighing the evidence. Mr. Tucker, you were mentioning something about...
I actually looked at it, Your Honor, and it seems like the state has already gotten the new revised version of 3.9.
Okay.
Had a divorce lawyer charge me to withdraw after I settled everything without him. We had a doctor that charged for delivery and it wasn't there.
3.10. I see a bracket number 2 here.
The judge's spirit animal is definitely a horse.
Bracket 3.10, paragraph 2, third line, exhibits and evidence bracket.
I actually have 2 brackets in mine, Your Honor.
Oh, you're right. In the line 2, and have seen in the form of exhibits and evidence. There are exhibits and evidence, and so that would certainly not be bracketed. So you see that?
Yes, Judge.
We have to eliminate that.
I've got the Maya counter running, and I can show you where we're at on that. I have not got it going on its own webpage yet. I think this number's a little bit off, but Mrs. R.A., when she unplugged the router that was running this counter right here. She unplugged that, and that's what caused the hiccup where the network was trying to communicate and it bogged down. That's why we had the spinning wheel of death earlier today. But so the number should be, I think, about 10 or 20,000 higher than that because it's been offline. We have to update it. But we're going to put that live. It is over 208,000, about 208,700,000.
My packet, I'm sorry, once we get done with this, doesn't include the robbery with a deadly weapon or robbery with the weapon. The packet I was given up here doesn't include the robbery with a deadly weapon. Now, you did put the robbery with a weapon up here, but I don't have the robbery with a deadly weapon in my...
Judge, it's contained within that one. If you look at the top of the second page, it says...
That means they're dropping the charges.
That the robbery was committed with a knife, then you should find that it was committed as a deadly weapon.
I'm sorry. I guess I shouldn't skip ahead or skip behind.
That's okay. The robbery with the weapon instruction, do you have that one, Your Honor?
I do.
At the top of the second page.
Yeah.
It basically incorporates deadly weapon as part of this instruction.
Incorporates, but not as a separate charge?
So again, let's do 3.10, and then we'll go back to this because that's a different approach than what we discussed earlier.
Okay.
It may be accurate, but it's different.
So we're on 3.10, Your Honor?
Yes, we are.
Rules for deliberation.
Yeah. Yeah.
We're taking the brackets out right now.
Okay.
Ivan sent me a picture from his store Fireball is apparently $1.99 each, or there's a price cut special today only, 2 for $3. Good through February 6th. Ivan, it just tells me something. I'm not a drinker, as you know. But if you can get 2 for $3, I'm thinking it's not very good. Just want the interest accrued. Barbara, I can put that on. We'll do the math. Can you send him in? I'm going to have my son see if we can update it and put those numbers on.
Revised one by email.
There needs to be a motion for sanctions. Mama Bug. This is great.
Is it the 8.2?
No. It's the 3.10.
Yeah, that's the last one.
I'm not. I have no. I don't drink alcohol, so I don't know.
Send it over now.
Can you show me how I can see the formula on this webpage? What's the command? What? I want to see the text on the side, the formula, the programming.
Did you send that email? Okay.
Okay, about the Fireball and me saying it's not tasty. I'm just saying that if I was to buy, like, say, a large Dairy Queen Blizzard, Oreo Dairy Queen Blizzard, I'd be paying like $5 or $6 for it, I think. Maybe a little more. I forget.
It's taking a long time to get here.
Cinnamon flavored antifreeze, says Petrified.
Okay, I don't know what's going on here. Huh? Oh, okay, it's coming through now.
My son's fixing the software. He's trying to run a server. So hopefully it'll update here in just a minute. Katie says, my great-uncle Ralph Med and his brothers invented the Dairy Queen Blizzard machine. Katie, I like to think that if I go out and buy a Blizzard today, you and your family get a few pennies. Hopefully that's the case.
Of course, the ink is much darker, but I guess that doesn't matter.
He's complaining about the dark ink.
On this one, most of the ones on the Supreme Court website are rebold. I was emboldening them. I can
It's all right. It's all right. I just...
Judges, why is this page in bold? Why is this in bold?
Yes, we're good on this one.
Okay.
The money counter is right here.
Another one coming through? What is that? What's coming through?
Judge Owen, I noticed on 3.13, which is the last
We haven't
instruction.
gotten to it yet.
We just sent it.
Actually, I'm looking at 3.10 still, and it came out all in bold. I don't know if you want that, Your Honor.
Well, it's darker than some of the others, but I don't believe,
I don't see where it's a bad thing.
I don't think anything is going to be highlighted to the exclusion of something else, but I did see the same thing. But the problem has been corrected.
Just the last correction that the state will be making is on 3.13, submitting the case to the jury.
Famous last
Go down to
words.
the bottom of the page where it says A.
The last correction we're going to make.
I was going back to robbery because in my packet I didn't have outside of the felony murder robbery, I didn't have a separate robbery charge. You brought it up to the bench, but what the original packet had was robbery with a deadly weapon, then robbery with a weapon. We had two separate instructions, is my recollection, and now all we have is robbery with a weapon. So
15.1.
Adam, it's been a great 11 months. Thank you, my friend. I like that you put the 11 in brackets, or you made the 11 out of brackets.
So the original package.
What did the counter start at? 200 and... Let's see. 208 million. See, it's only gone up by a couple 100,000. I think it's only gone up by a few. So 2086, 61 something. I don't remember. It's got to be more than that. 2085. Post-judgment interest rate is 9.09% on the Maya settlement or Maya verdict, but it accrues annually until January next year. Like there's a daily rate that accrues all this year, and then January next year it switches to daily. It's a weird little thing they've got set up. The judge spelled it all out in the document. It's higher math. P. Will, for real, if you have an option to put it in like a Google Drive and share the link, that might work better as well.
I think we need to go back because...
Uh-oh. We're on a redo again.
Seeing some discrepancies between the original submission and this submission. So let's just go back.
If you're waiting for the 208 million to roll up to 209, it goes up by like what, 15 million a year or something? Because 10% of 208
This
would
package,
be 20 or
after
20.8.
second-degree murder, it goes right to aggravated assault.
Correct, Judge. You're
18
missing
million?
something for robbery with a deadly weapon.
Well, here's robbery with a weapon, and maybe that's what we had to begin with, but then there were other instructions you also had originally.
I think the correction you made.
Oh, wow.
Is that the judge's head big in the desk or his papers?
Your Honor, do you have 15.1 robbery with a weapon?
I do.
Okay. And I think that addresses the finding of a deadly weapon on page 2.
Fair enough.
So that might be the instruction that is needed there.
Fair enough. But what about this aggravation of robbery by carrying a knife? That
appears later in the packet, I think.
It does? Not in the package that I've been given.
3.3A.
Mr. Tucker, you have 3.3A?
That's what I'm looking at right now.
Aggravation of robbery by committing an aggravated battery, 3.3C.
There are papers everywhere.
Do you have it there, Mr. Tucker?
No, I'm looking at, I've got robbery with a weapon. And then on the second page, yes, Mr. Mansfield is correct. On the second page, it says, if you find the defendant and his or accomplice carried a knife in the course of committing the robbery, and that knife was a deadly weapon, you should find him guilty of robbery with a deadly weapon. I think the rest of those are fine, I think.
Judge, which is the one you're saying you don't have?
In the original package,
You want to go over?
So I have robbery with a weapon and robbery.
Yeah, we have robbery with a weapon, and then as
I
Mr.
had aggravation of a robbery by committing an aggravated battery. I had aggravation of a robbery by carrying a knife. I think,
Judge, we took that aggravation.
The aggravation with the knife is still in there.
Yes.
Okay, it's not in the package that I was handed, so I'm just trying to...
You don't have this one, Your Honor?
Mr. Mansfield.
Not in the latest package. It was in the original package. Aggravation of robbery by carrying a knife. Okay.
You have that.
Huh?
You have that in the second package that I gave you?
No.
What I'm saying.
No, I don't.
Okay, then it must have been
I don't have aggravation of robbery by committing an aggravated battery.
Right. I think we decided we wanted to take that one out.
Okay.
Just make sure, Mr. Field, we want to take this one out, right? This is the one we discussed.
Okay. This is a mess.
Yeah, Judge, there's enough interrogatories for the jury that this is not going to have any impact whatsoever.
Well, that's fine. But nobody told me until I noticed it was missing. So I'm assuming the defendant is not objecting to taking away aggravation of robbery by
have it over here.
By committing an aggravated battery.
No, I'm not objecting to that at all.
All right. So then what we need is 15.1 and 3.3A, right?
Yes, sir.
Okay.
15.1 is robbery with the weapon. 3.3A is the aggravation for the.
Okay. All right.
What was it? Aggravation for what?
All right. So now we can go back to where we left off, and
I have a cautionary instructions.
Cautionary instruction, 3.11. Verdict, 3.12. 3.12A, single defendant, multiple counts or informations. Submitting case to jury, 3.13. But the verdict, huh? Okay, what was the, oh, I see some brackets here that are...
The state's already said they're not going to make any more changes, Your Honor.
One? Yes. And
he says, "Stay up there, David. Stay up there, David. Get away from me. I don't want the stench of your failure to rub off on my shoulders in this otherwise flawless case," says Mr. Mansfield. "Stay up there."
3.12. Okay. Oh, perfect. I was just flipping that.
now,
Leslie Culver says, these can't be understood by the judge, or is it confusing to him? Wouldn't they confound a jury? The judge understands the individual instructions. It's that they're not formatted in the way they've decided to format them. They're leaving parts out. It's a form letter. Think of like a Mad Libs. If you've ever done Mad Libs where you fill in the blanks.
Tucker,
some of the
was
blanks
there
haven't been
anything
filled
else that you were requesting now? I know you mentioned something earlier.
No, I mean, that was the one, the state already got the new version in there, so it's fine.
Okay, so now what I'd like to do is start from the top and just go through these again so we're all on the same page. 3.1.
From the top,
1.6.
everybody. To your places.
3.2. 3.5A Principles newest version.
Hold on. 3.15A?
No, 3.5A. If I said 1, I misspoke. 3.5A.
It goes right to 7.1, the introduction of homicide.
No, you should have after we agreed that you agreed to this as well, that right after the statement of the charges, we would then read the principal instruction 3.5A.
It's just out of order.
Okay. All right.
He's spreading it. He's taking up the whole desk, trying to collate this mess that the prosecution
All right,
has
so
handed
then
him.
we're on to 7.1, Introduction to Homicide. Felony murder, 7.3.
We do have a devil in the thumbnail now, yes. New thumbnail.
First degree. Robbery, 15.1.
Prosecutors need a Samantha, is what they need.
3.12D, legally interlocking counts.
We're keeping robbery to the weapon, though, aren't we, sir?
When we get to that point, that robbery was included in the felony murder instruction because they have to find one of the qualifying offenses. So after robbery, 3.12D, legally interlocking counts. 3.4, when there are lesser included crimes or attempts. 7.4, murder second degree.
If the jury could see what was going on here, they would never believe.
15.1, robbery with a weapon.
From the state. This is how you ran your investigation in your case?
3.3A, aggravation of robbery by carrying a knife.
I thought that was included in robbery with a weapon.
No, it's a separate enumerated instruction. Okay. State you're with us here. 3.3A, aggravation of robbery by carrying a knife. 8.2, aggravated assault. 8.3, battery. You don't have battery. Well, that's not good.
Are you sure you don't have it? Maybe like in the other.
I'm looking right now.
Could be in all the other copies we sent you. Everybody is shuffling papers.
Yeah, we'll get more copy, Judge, and we'll just.
Well, I probably, from the last package, I've
got a couple spares as well.
Yeah, they gave me a copy here. It looks fine.
So then.
Thank you, Bug Duggar. This is messy.
3.3E, aggravation of a felony by wearing a hood, mask, or other device to conceal identity.
Yes, sir, I got it.
You got that, State?
Yes, sir. Hood, mask, or other device to conceal identity. Got it.
3.7, plea of not guilty, reasonable doubt, and burden of proof.
Yes, sir.
3.9, weighing the evidence. 3.10, rules for deliberation. 3.11, cautionary instruction.
I clicked on the Creative B link for
3.12
Debbie, and it took me
verdict.
over there in chat.
This is where the verdict forms should be inserted then. This is when I read the verdict forms. So,
Hey, no more clowns. Happy
Excuse
to talk
me?
about it. I'm not promoting alcohol. I've said over and over I don't drink alcohol.
yeah, but before we get to that, this is where the judge
we do say
reads
no-
the verdict
no
forms.
caps in
Once
chat.
I get to the end of 3.12, it says the necessary verdict forms have been prepared for you. And then I take these and they say they are as follows, and I display them and I go just systematically through explaining the format, reading the words. So I take it there wasn't any change we were looking for previously with the verdict form, and they're basically unaltered. So count 1, count 2, count 3, and count 4. So,
Everyone's hearing what? Barbara Streisand in their head
insert
right now.
those at this point. Then I go to 3.12A, single defendant, multiple counts or informations.
Kim, oh my gosh, I've been missing my RA family. Hi, chat fam.
You're with
Trainings
Mr.
and a
Alvarez.
funeral.
Yes, sir. Okay.
And RA today. Today's my hubby Larry's
3.13,
birthday.
submitting case to jury.
Happy birthday, Larry.
Yeah, that's what I got.
Larry,
Okay.
hubby of
State.
Kim R.
Yes, sir.
Happy birthday.
All right, so you're going to make another copy of the battery for yourself. This is my copy. This is what I will instruct from, and this is what will go back to the jury.
Perfect. Yes, sir. According to your list.
So I've had my assistant have the inmate plea docket set till 10 o'clock. So I certainly don't anticipate this taking any rush beyond 10 o'clock. If it does, obviously the other docket will wait. But what I expect is that we'll instruct them, we'll excuse the alternates, we'll send the jurors back to deliberate. Now, we'll have to discuss, is this whole unit going back there in terms of how is that going to be done? That's always a point.
Well, Judge, you know, there's no reason why I couldn't. I think the thumb drives are pretty easy to put in. If we can figure it out, I'm sure they'll be okay with it.
Your Honor, I would prefer all the evidence go back there, so yes.
Yeah, that's the plan. I'm just saying that I just want to pay attention to all the details that normally we all concur. And in this instance, that can be wheeled back. And if they have any questions, I can certainly ask me, but it should be fairly simplistic.
Get in touch with Carrie to make sure that its internet functions are turned off. So all I can do is
Hey, no more clowns. I'm happy to have the conversation with you.
So
Sorry,
I
the
don't
mods
know
are
if he's
deleting it.
here
It's all right.
now, or if not, we'll get him tomorrow
I'll
morning.
address this with you.
So otherwise,
because you've got a legitimate question. I'd be happy to
once we
answer it. So
finish,
hold tight.
we send excuse the alternates, give the jurors the evidence, the jury instructions, the verdict forms, and then basically they're deliberating. At some point in time, depending on how long it goes, we routinely would offer them lunch. There's a fund at the clerk's office, and if it gets close to noon or a little before, I'll ask Deputy Riccio to provide menus, and there's
he serves water, he makes
they can
copies,
order,
and
food will
he's
be
your
delivered.
waiter.
As I said, it's from a separate fund. They're not buying their own lunch, and it's delivered, and they
We have
can
a slush
eat while they're
fund over the
deliberating.
clerk's office.
Gary was in his office.
Okay, well, he'll probably be tomorrow, or we'll get one of the other assistants. And I'll be up here on the bench, basically handling pleas and sentences, and if there's a question or a problem, or when there's a verdict, and if it's in the morning and I'm still doing court, I'll just cease what I'm doing and shift gears. So I don't see any problem in kind of doing those things while the jury's deliberating.
Yes, sir.
And sir, where would you like me to wait while I'm waiting for the votes?
Where?
Yeah. I mean, is there a
Well,
specific place or?
I've never been asked that question before, but that's a fair question. You, basically what I tell folks, lawyers, defendants who are at liberty, if you don't have to stay here, but if you're going to go somewhere, we have to be able to contact you, and same applies for the state, so you can return within a reasonable time. I mean, like, hopefully 5-10
office is right down the street.
5-10 minutes. We have to have a phone number, and if we got a question, we got a verdict, I'll ask the bailiff, has everybody been contacted? They'll have a way to contact them, and everybody returns.
Hey, Judge, put us on that contact list.
My lawyer's office is right down the street. You should have my they have my contact number.
Well, as long as we have a number before, after the jury goes back, as long as we have a number, or we have a number that's good, I don't particularly care where it is, as long as it's good, and they're not going to say, oh, gee whiz, he went up to Marathon or something like that, then you can return within, 5-10 minutes. That's
fine,
it.
Your Honor. I just wanted to make sure I didn't know the process.
Yeah, that's fine. I mean, you don't have to stay here. The jurors are going to be in that jury room. They're going to be under constant watch, which is the normal procedure. Outside, of course. Nobody's going to be in the jury room. And when there's something that we need to address, question, problem, verdict, everybody's contacted, and they're not brought out until we're all here.
Would you like me to leave that number now, Your Honor?
Well, whichever you prefer. If that's more convenient for you right now.
Just make sure.
We always do it after all the evidence has been checked by the...
But if he wants to give it now, if you can help with that. All right, anything else? I think we've covered it in detail.
Like 6 times over.
Sure, nothing from the state. Thank you, Judge, for your patience. These instructions are always highlighted the trial.
Okay, so I think
everybody on all sides has been quite patient. So, in any event,
always.
See you tomorrow.
I'm out of here. See you tomorrow. Okay, so he's out of there. Tucker's providing the contact information. We're going to be back tomorrow. I want to address the issue that was raised. I don't know if it was No More Clowns, and I think it was a different account that came in originally. The comment was deleted. The first comment was deleted because you told a mod no effing way something, and you said spell out effing, not like with an F, but like EFF. We just don't allow those comments in there because it riles up the conversation a little bit. That's why it was deleted. That's why I'm happy to talk to anyone about why I call my channel The Recovery Addict. My history with addiction, which is very different from what is a typical history of addiction, or what people typically think of when they think of addiction, but it is just the same as in the way that addiction can come in many forms, and it's very real. In my case, I just about lost everything because of it. My addiction was not drugs. My addiction was computer gaming, and it took over my life. I just about lost my family and lost my job, everything else because of it. And that's why. And I'm happy to do that. We support everyone who's on the path to sobriety, wherever they're at, whether this is their first day and they're going to go a day without smoking and they're just trying to get through the first few hours. We support that, or whether they've had 15 years and are well on their path. We support all of them, and regardless of what the addiction is, we support that. So I'm a huge supporter of that. I've said over and over, I did not choose the name thinking about that, but my approach to this is one that I feel is respectful, and that's why. Let's see. Scott, I'd also be happy to call and discuss if you'd like. I'm in recovery for me, and that was triggering. I understand. the comment, and let me explain what happened, because I mean, just like I was addicted to computer gaming, I don't prevent anyone from talking about computer games on here. Drinking is legal in a lot of states. We have a friend of the channel, a friend of mine who owns a liquor store. He's in chat, and he sent me a text. And he said, "Look in chat. I sent you this text," and I read the text. The text was about Fireball, because the Fireball whiskey itself, I think it's whiskey, has been brought up many times about in this case as what was being drunk, and there's been arguments, and they've gotten the name wrong several times. It's been an item so much that we included in our thumbnail of this text a meteor or a fireball to indicate that that's what it was. And so I was reading his picture, and he had taken a picture from his store where he had Fireball in like a little fridge, and it says $1.99 or 2 for $3. And my comment about that was, anything that you can get 2 of for $3 is probably not very good. I'm not a drinker. I'd rather pay $6 for a Blizzard than some alcohol. That's where it was on that front. So I apologize if there was any confusion, but I was not doing an alcohol commercial. I've told everyone many times I don't drink. The number of times I've had alcohol I can count on one hand, and I was served it without my knowledge every time. Let's see. We have a lot of people. I'll say this: we have a lot of people in here who are on a path to sobriety, who have family, who are in recovery, or who they hope to soon have in recovery. We're 100% in support of that. That is something we never make fun of or mock. We cheer on all recoveries, all paths to sobriety, no matter where you are on that. So let's see. We have a couple things. And I apologize if the way you were handled, you felt that we were attacking you or not allowing that. I understand. That's why I say that's a legitimate question. A lot of people who come to this channel, the first thing that they say, I was searching for something else and I found you. That's why I initially chose the channel name, because it was creative. I was addicted to recovering artifacts from the ground. That's why I chose the name, but I also do have that personal history with addiction. All right, for me, it was World of Warcraft was the worst, but it started long before then. All right, with that said, let me, and I'll be happy to, I'll take the call off the air. I don't want to have an argument on the air with you. I'm not saying it would be an argument, but I do want to hear what you have to say. Once we're off the air, call the burner phone. I answer it. I answer it 24 hours a day, really much. I would say stick around. This is a good group. If you have, do you concede that you did in effect just, I read an advertisement. I'll concede I read an alcohol advertisement as been texted to me in the context of the Fireball reference for the trial. I 100% did. That's what I was doing. I was not advertising the sale of alcohol. I don't have any alcohol to sell, nor have I ever. And in the same time that I read it, I was saying that it was awful, and I got corrected in chat by a lot of people who like it. But respect. Do hang around. This is a good group. All right, and I'd be happy to talk to you after. All right, there. Let's see. I'm addicted to this wild court, says Pamela. We do love true crime. All of us here pretty much love true crime, or have some connection with this case. Did you get the program working? No, I'm live. Is it working? Okay. It might kill my my stream, so don't plug it in yet. I'd appreciate nothing but kind words for No More Clowns. Seriously, I do hope you stay. I do hope we get a chance to talk. I'd love to hear your story as well, your personal story, and I hope that's good. So thanks. We don't need anyone fighting my battles for me, sort of thing, on the channel. We don't bring that drama to chat. That's what makes us a little bit different here, and I appreciate that. And I appreciate you sharing your opinion. Honest, No More Clowns. Thank you very much. I look forward to talking to you about it. All right. let's see, you guys. No name calling. Seriously, that's not okay. Here's where we are. We have finished for the day. Tomorrow in court, it's going to be it's going to be a mess. First thing in the morning, we have jury instructions, and then it goes straight to verdict watch. The judge has some other business he's going to be conducting in court, which may not be televised, so the feed might have to be cut. I'm not sure how it's going to work because the judge will be on the bench. We'll be doing other stuff. I don't know how that's going to go. We're going to be keeping an eye on it throughout the day. I realize the Crumbly case, they've seated a jury. Verdict, not verdict. We can't go straight from seating a jury to verdict. That would be miscarriage of justice. Welcome, 13th jurors. Thank you for the raid. Wonderful to have you here. We're trying to spell out what's going to happen tomorrow. The Crumbly case, they've seated a jury. We've got Judge Wolf in Tennessee, who is also handling a jury trial right now, a murder trial. We've got a trial up in Thurston, Washington, which I may be able to record or pull before they delete it. I'm hoping to see this, and honestly, Crumbly was where we wanted to go next. That's where we want to watch next. So we're going to see how that goes. Let's see. We have a bunch of people coming in from the 13th jurors. I'd love to hear what happened. I didn't get to check on Brandy's channel at all. I told you I was going to take a break, but then I didn't. I'm sorry. I meant to take a break today. Amanda, we were trapped in the portal. Said Amanda, the portal just didn't open forever. The doors. It's like in the elevator when you get to your floor, but then the doors don't open, and you get that sinking feeling like I might be in here for the rest of the day. Usually I only get that sinking feeling when I go down, though. We have a lot of calls coming in. I was trying to wrap it up instead of going to additional calls. Do you guys want to take a few calls? Let's see. Hang on just one second.
Call from
Tiffany.
Hey, Tiffany, this is Recovery Addict. How are you doing?
Hey, we were talking earlier before they came back into court about presumption of innocence, all that.
Mm-hmm.
And this isn't exactly on topic, but it really bothers me that prosecution states, not just in this case, but others, they'll use the same evidence. Like in this case, they used the knife to convict Rory, and they're trying to do the same thing with Tucker. And it really makes you think they're not trying to find the truth. They want convictions like we've been talking about. And I see it on many levels in this case, and it's really eye-opening that this is happening all over.
Yeah, this is weird. Some of us look like a miscarriage of justice. It's like if you already got your conviction, now you're using the same evidence on somebody else. Well, there were multiple players involved. We know there were at least 2 people involved, so I can see them going for a second conviction. It seemed to be a stretch for them to say, yeah, there were 3 people, because the only evidence we have that there were 3 people is one of the people they know was involved said it was somebody else. That's it. There's no DNA evidence. There's nothing else says there were 3 people other than Travis. And he was one that stands the best. He's got the most to win from there being somebody else at play that he can point the finger to.
And he's the most. I mean, he's the best evidence, so we believe it.
Yeah.
But it does bother me though that Rory was convicted holding that knife, and now it's like, well, just because Tucker's DNA isn't on there doesn't mean he wasn't using it. Yeah. And I get it. Like they're trying to get their convictions. It just seems wrong. I don't know.
It does.
And this is just one level of it, and we see it everywhere. So it's not surprising. It is alarming though, especially when somebody's life is, on the line. Yeah. And in this case, I don't think they're that worried about who died here. It's more, an expedition to make everybody tank. I don't know.
Yeah, it's interesting because I'm guilty of this as well. As we go down, once I've started to formulate my idea, my peripheral vision that allows for other ideas to fit into what I accept gets narrower and narrower. And I'm guilty of this. And for 7 years, the prosecution has been looking at it like this, and all they can see is Mr. Tucker and guilt. So it's the ability to at any point in this process be able to stop and step back and say, let me evaluate my decision. Let me start from scratch as if it was day one again. Now that I know all that I do, will I still get to the same point? Or is there something else I'm sort of excluding because I've got this tunnel vision?
Right.
That's hard for everybody.
I'm probably a person I am very open to receiving information and not jumping to conclusions, but I'd probably be a horrible juror because I don't think I'm not good at making decisions like this on circumstantial evidence. So I know that that's something, even in my day-to-day life, like if I don't know that as a fact, I can't say it for sure. And so that's something I know I would struggle with. And something I'm struggling with here, there is evidence saying one way or another, but I mean, I think there's plenty of reasonable doubt. In this case, it's not exactly, there's not a pile of circumstantial evidence in my, opinion, but I would be a bad juror.
Well, the judge, if you were a juror, he would tell you that that circumstantial evidence carries the same weight as physical evidence.
Same weight, I know.
And
which is why I wouldn't be good with it.
And then he'd also tell you that reasonable doubt is that amount of doubt that it would take that would cause you to hesitate to act. And I know some of those definitions seem a little bit out there and weird, and we don't really think of things in a day-to-day, I want to do this, but I hesitate to act. That's not the language we use when we think about that. But
absolutely.
But if we sit down and analyze, and if you're like, I'm just not sure, that's the hesitation.
Yeah.
That's the reasonable doubt.
Absolutely. And I'm honestly, and you said this too, and many have said it as well, I'm just shocked that it's got to this point on looking at the totality of the evidence, and I'm not looking at outside sources, just of what we've seen. It's shocking that this got to this point with what they have. I'm honestly shocked on that.
Pam's saying that regardless of if Tucker's DNA is on the knife, if he was there, he's guilty. That is the law. Pam, you're right on that. Right. If he was there participating in this, that's the whole principal rule. Right? He could be, there could have been a third person just standing with their arms folded and not touching anyone. And he would be just as guilty if he was part of this, if he was planning, he knew what was going on. That's the way the law works. I just don't think the evidence is...
And I agree. I guess there's not the evidence to say that he was or was not. So I'm not saying I think he's a good guy. He might have done it, but I just don't think the evidence is there. Yeah. So, that's my 2 cents. So.
Thank you so much. Appreciate it.
Thank you.
We'll see you.
All right, bye.
Bye. Taking some more calls here.
Call from
Marilyn C.
Hello, Marilyn C. How are you doing?
Okay, I'm turning down my radio here. Okay. I'm all for, circumstantial evidence, but I don't think that this even rise to that level. For example, I'm probably going to go into other areas, probably not bullfrogs and zebras, but say I have 2 cats, I've got a new one and all of a sudden they're peeing on the couch. Well, I can reasonably say, well, that cat, that new one is probably doing it. But I'm not seeing anything that rises to the level of circumstantial here either. I'm not seeing that they can put that case together based on their evidence. It's just, he's the same size. He has the same shirt. His,
it's very
whatever.
weak.
It's
they had the argument. I mean, this is such a stretch. It's so far beyond circumstantial. It's more like a implied inference is the closest they can get. They say, here's Paula, and she's in the treehouse, and then she meets, Tucker makes friends with her at McDonald's. And then she goes on vacation. Coincidence? I think not. And it's like, really? This is the level of you obviously jump to this.
Yeah, it's a stretch. For argument's sake, let's say that I don't believe Travis, I don't believe Paula, I don't believe Tucker. Well, reasonably, I'd say, well, okay, I don't believe any of them. So what's left? What's left in the coffer here? What is left here for me to presume that this person did this, aside from the fact that he's the same size, he might have, hoodie, how many people have black hoodies? I do. What else? what else is there? You know, there's just nothing really that connects him to this, and the circumstantial stuff doesn't even add up. It just doesn't for me.
Yeah,
So I'll leave that.
We've become accustomed to receiving evidence, you know, the best evidence. We've got like hidden cameras recording things from every angle. We're used to, you know, somebody getting caught on camera or you know, this physical evidence that is so telling that you just can't walk away from it. It's undeniable, right? And we want that.
Well, sure.
Can you imagine back in the day when it was all just, it's he says and she says, and then the jury has to decide? You know,
They have to decide.
Yeah.
Okay, like say I'm going to go off somewhere because that's how my mind works. But, you know, just say that, you know, I have 3 people in my house and I'm missing $5,000, you know, and all of a sudden this, you know, person who is living on Social Security has an extra $5,000. Reasonably, I can say, well, where'd you get that money?
Yeah.
You know, where did you get that extra $5,000, which is half of your yearly income, that you can go take a trip to Vegas all of a sudden and I'm missing $5,000. So, yes, we can speculate. And, you know, the circumstances would suggest that that's probably true. But, you know, is it true? You know, you know what I mean? Like circumstances do weigh in heavily, but I'm not even seeing any of that here. Like, I'm not seeing any circumstantial evidence that says Tucker did this. I don't see a motive. Nobody disputed that he was making the money he said. You know,
I believe in Florida they don't have to prove a motive here. That's not one of the elements. We'd like to see, you know, this is why it would have happened. But even on that front, what the testimony we've heard is that Tucker had money at the time, and so it's
So why would he
that's
possibly?
Gone.
Yeah. Why would he even possibly want to do this and jeopardize, you know, his goal, which was to get a boat?
Yeah.
You know, and live that life. That was his goal. So I don't like him living, you know, really on a very frugal budget does not mean that, you know, he's guilty. It just means he had other goals.
Yeah. Thank you.
That were more important.
Thank you so much. I appreciate the observations, the comments. They're very timely and insightful. So thank you. Hope we can talk again. I've got a couple more calls that are trying to break through. So I'll let you go now. Thank you so much.
All right.
We'll see you. Bye. All right. The phone line's freed up for just a minute. I know there are a couple people that are trying to break through. Congratulations, Miss Schmooby Cakes. 5 years sober here. Congratulations. 5 years is great. Here's to 5 more. All right. We are not in verdict watch right now. We thought we would be. We thought we'd have a verdict by now. But they ran into a roadblock on the jury instructions. The state has sort of messed that up a little bit. And they had to work through the details. It took a lot of working through to get there. The jury's been sent home for the day. They're going to come back tomorrow. Get the jury instructions, and go straight to deliberations in the morning. So we're going to have a morning with them, and then they deliberate.
Whiskey Scambator.
Lucky's getting better. Is that who it is?
Whiskey Scambator.
Oh, sorry, my ears are so bad. Whiskey Scambator, how are you doing? Welcome.
I'm doing good. Hey, first time, long time. Question. District attorney has to approve taking this case to court to actually prosecute.
Mm-hmm.
Is that correct?
Generally, the decision is made in the district attorney's office. I'm not sure if he has to, it's his signature on it. But the charges are presented to the district attorney, and they decide if they want to move forward. So somewhere at that point, that was somebody gave this once over and said, "Yeah, let's go for it."
Yeah, it just really surprised me with the lack of evidence that it's all hinged on Travis's word against Tucker. That the higher ups actually proceeded to push this through to prosecution, along with all the alleged mishandling of evidence. People no longer. Detectives not being there, for whatever misconduct is very surprising. Not a conspiracy theorist, but
was there a grand jury on this one as well? Weather Watch? Was there a grand jury? I'll say this: having watched the grand jury in the BK case, I do think that the grand juries are. I'm not a big fan of the whole way that goes down. The the defense doesn't get to say anything. Nothing's questioned. Oftentimes, the information that's presented in a grand jury is far from the polished information that's presented at trial, and sometimes even incorrect. So if there was a grand jury, I don't like that. At least in Texas.
Yeah, I've heard that as well. I think Melanie Little was talking about a couple of the other cases that grand juries are like, if you can't get something through a grand jury, then you got serious issues. That it's more or less kind of a joke.
It's literally
very one-sided.
It's showing up to a sporting event with only one team, and then playing.
Right.
And if you can't get the win, if you can't get the W with the other team being absent, it's very sad. But grand juries, it seems they always seem to convict. They always seem to to rule that way.
Well, thanks for taking my call. Let's take some others.
Bader. Appreciate you. We'll talk again soon.
All right. Cheers.
All right. Bye. Rebecca, bite me. You dropped right as I was clicking the button. We're gonna wrap up here because I have to go get a Blizzard. I have to go get a Blizzard from Dairy Queen. You know how I once went on vacation one time with my kids. It was actually a work trip, but it was considered a vacation because I took my kids. We went to a hotel and swam in the pool and saw some sights as well. But while we were at the hotel and realized we don't have a TV, we don't watch TV. I mean, I have a television, but we don't watch TV. While we were at the hotel, the kids were watching some movie that we found to entertain them for a minute, and there was a commercial for, I don't know, it was like peanut butter M&Ms or something like that. And my kids are like just glued to the TV. And I'm like, oh, that's funny, you know. And then we left and we went around and we ended up going to a store because we had to go pick something up for something unrelated. And my kids on the candy aisle, they're just like, zoom, peanut butter M&Ms. You know, I've got to have these. And I'm like, holy cow, advertising works. Well, in my head, I've been thinking about this Dairy Queen Blizzard for quite a while now. And now it has to happen. I cannot complete this day without a Dairy Queen Blizzard. So I'm taking recommendations as far as the flavor. Peanut butter possibly. I was going to go with just an Oreo, just a regular Oreo. But let's see. Please listen to voicemail. Ty is trying to reach you. Ty is trying to reach me. Hang on one second. I've got the voicemail. Let me say this. Ty, I would like to talk to you. I realize it's a point in the trial where there's not a lot left to do on your part, but I've said that I don't want to do anything in any way that might look bad. And I'm not saying you talking to the press looks bad. I would like to talk to you. I would love to get some input and some of the information that you have regarding this case. I think it's incredible. I think you're going to be acquitted, and I think we're going to have this opportunity. But I've said that I don't want to talk to anybody. We don't contact the courts. We don't contact the during a trial. We just don't do that. And that's just a personal rule I've set for the channel. I don't know. Now it seems like we're in the safe space because all the decisions are pretty much done. There are no objections left to make unless there's something that's done improperly during the handling of the instructions. But I would definitely like to talk to you after the trial if I could do that. That would be something I'm very much interested in. If you can understand, I realize it's very important for you right now. But I'd like to wait till after the trial's over. That's just how we've run the channel and how I think it's the best way to handle things moving forward with all cases. Realizing that I as a media channel am working with courts to gain access and things like that. And if I'm contacting defendants during a trial, other trials might look at that and not grant me the access that I need to be able to follow trials because of that, afraid that I would do something during that trial. It's optics, it's perception. I realize in this case, where we are and everything, it wouldn't be an issue. But I just thought I'd share that with you. If it's okay, if you can respect the opportunity to wait, I would love that. I realize, and that's not like it would be best for the channel to wait as far as monetary. Obviously, the eyes are on this right now. You've got attention from all sorts of people wanting to hear about this. But this, I think, morally is the right thing to do for the channel. So thank you very much. I would prefer not to chat offline as well. I realize I've talked to your wife. That I think is okay. So if there's a message you wanted to get through me, if it goes through her, that's okay. I just want to keep that line there while the trial is going, because of down the road, it could cause a lot of problems. But thank you. Let me say this. Let's go ahead and wrap this up today. I'll say this also, Ty. You've got a lot of people here in this channel that are appalled with what has happened, that look at what the case that the prosecution has brought, and whether they like you or they don't, or they agree with your lifestyle or they don't, they say it's just not there. We're surprised that we got to trial, that this has taken this many years of your life, that somebody along the way at the attorney's office or the district attorney's office didn't say, what are we doing here, you guys? Honestly, we're professionals. We have nothing. We're appalled at that. We want to look into this a little bit further. We'd like to see that, and I want to do that with you. But no, you've got a lot of support here. Either support for your acquittal, even though if they don't support you personally, but a lot of people who say that if this goes through with a conviction, this would be a miscarriage of justice. So thank you very much. Ty is the defendant. That's correct. Franklin Tyrone Tucker. Appreciate that. And I appreciate everyone else respecting that decision for my channel. I realize that's a call that I've made early on. And I didn't want to stand by that because I think it would help us as a channel. And there, my standby counsel has agreed with me. Thank you. Matthew Harris Law LLC, PLLC. Good to have you here, by the way, Matthew. Thank you so much. Let's do this. Let's play some music. I need to take a break, and I promised I'm going to go get a milkshake. We're going to keep an eye on this. We're going to have stuff to do tomorrow. Obviously, this trial is continuing. There's more happening. The jury's going to be deliberating. They're going to be returning a verdict. I think it's a quick one. I think a quick verdict is pretty easy, even if they sit down and look at all the evidence in the trial. I think they won't be in there too long, because there's not a lot to look at, especially when it concerns this defendant. So it might be a quick verdict tomorrow. Enjoy your Blizzard for me. I sure will. With every bite, Matthew, I'm going to be like, oh, I bet Matthew Harris would really, really enjoy this right now. You guys, thank you very much for being here. This is a wonderful place. I appreciate you guys making this community what it is. I appreciate you in the way you respond to each other, the way we're able to discuss things that we disagree on and do it respectfully. I think that's important to the whole discourse, the whole discussion, and for the greater true crime community in general. Thanks to our mods who do the best they can with the little effort, the little help that I give them. They're amazing. Thank you so much. Tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again. It will be tomorrow morning at 8:45. 8:45 tomorrow. In the meantime, head over to Matthew Harris's channel. New stuff every Thursday. I expect a new video tomorrow, right? I think it's tomorrow a new one comes out. So we look forward to that. You can always take the poll on his page as well. It's my belief that if you get every question right on Matthew Harris's daily law poll for an entire year, you automatically get granted your bar card, your license to practice law. That's just my belief, and I'm probably wrong. You guys are amazing. Have a great night. We'll see you tomorrow. Bye-bye.